Good morning, everybody. Happy Tuesday. Happy Tuesday. Welcome back. Day 30th, guys. Very momentous. Day 30. You know, I was looking back on trial one. And those of you who were there watching that one, remember how it seemed like it just took forever and we had Lally, you know, bringing on all these additional witnesses, all these people we didn't hear from this trial, all this repetitive testimony and stuff like that. And it seemed like the whole thing took years. And I looked back at my notes and was really shocked and surprised to see, hey, back in that first trial, guess what day they had closing arguments? They had closing arguments on day 31. By the time we finish today, we will have put in as much time, as much evidence taking time in trial 2 as we did in trial 1. And with, you know, a good chunk less of the witnesses. Isn't that wild? I really hadn't noticed that. Just kind of took it for granted. Of course, that first trial took forever and this one's going much faster. At the end of the day, it looks like this one is going to take longer than trial 1, even with fewer witnesses. Isn't that fascinating? Well, guys, I had an idea, something a little different I'm going to talk to you guys about this morning. Because after a day like yesterday, it can get real easy to get real frustrated, real disillusioned with your government, real wondering, how do you fix any of this? How do you deal with whether it's incompetence, whether it's corruption, whether it's malice, whether it's anything? This is not how our government is supposed to function. How are we supposed to fix it? And I get so many questions about that. And I think the answer that I give most often is just it's very unsatisfactory, which is basically, well, you got to go through the political process because these are ultimately political problems. The governor appoints. Legislature can impeach. All those types of things. You can vote in a new prosecutor, right? But it's very unsatisfactory because, one, it's not direct. You know, it's not like a you harmed me and I get some kind of retribution for it. There's no obvious connection between, you know, messing up the Karen Reed trial and getting voted out of office. There's a lot of reasons why people get voted out of office. If someone gets voted out of office, you don't necessarily have vindication that, well, it's because of all the harm you inflicted in this particular case. It's not immediate. You got to wait till the election season. You got to convince everybody else to participate with you. So you got to wait. And then once you wait, you know, maybe it'll never happen because people lose interest. People forget about things. People move on to other stories and other things that they're concerned about. So the delay may make it not even something that you can pull off when you get the opportunity. So I understand the political remedy is it's undesirable in a lot of different ways. And I think what people really want to know is, how do you sue these people? How do you make these people pay? How do you make these people suffer some kind of consequence? Do they have skin in the game such that they foul and they can be punished for that? They can be held accountable for that. We can get recourse against the government for violating our rights. We have this big, beautiful Constitution, and we have this Bill of Rights, these amendments that the founders specifically adopted to protect us individuals against the power of the state. But there's no right without a remedy, right? This is kind of a philosophical idea that exists in the law. If you can't enforce your right, then you don't really have a right. Let's not kid ourselves. Let's not kid ourselves. So we got this paper that says we have all these rights against the government. What's the remedy? What's the remedy when the government comes and enforces these rights? What's that remedy? Well, guys, that's what I think we're going to talk about today. We're going to talk about how it is a feature and not a bug that you cannot hold your betters in the government accountable. It is made that way. It is made for our elite ruling class to have no skin in the game. So we're going to talk about 1983, guys. Good old 1983. If the number 1983 does not ring any sort of bells for you, that's okay. What you need to know is that by and large, 42 U.S. Code, Section 1983, this is your mechanism to the extent that one exists to get recourse against the state, to enforce your rights. This is your remedy. This is your remedy for being able to vindicate your rights when the government has come in and violated your rights under the Constitution, potentially your rights under statute, your due process rights, etc. 1983 is your mechanism to enforce them. So why let's just start real basic. Why do you need a statute in the first place? Why do you need something like that? Well, guys, we got this problem of sovereign immunity. Sovereign immunity. It's this doctrine that we brought over from England, where you had a king who is ostensibly imbued with the power of God. God chosen, God appointed, and because of that, can do no wrong. Whatever the king does is right. The king can do no wrong. So you have no recourse against the king. The king is immune from suit. It's so ironic to me when I think about the founding of this country and the idea that it was founded to combat tyranny, to promote individual freedom and stuff like that. And then look at things like immunity, the immunity doctrine that we just picked up and brought over wholesale. And what it shows me is that we didn't actually have a problem with tyranny at the founding of the United States. We just had a problem with that particular tyrant. It was the fact that it was him and not us that had that power that was the real problem. So instead, we came over to this country, we occupied it, we took it over, and we created new tyrants. We created new tyrants, our new government. Sovereign immunity, it could do no wrong. So it exists at common law for the federal government. For the states, it's in the 11th Amendment. The 11th Amendment of the Bill of Rights gives the states sovereign immunity. So that's why you need a statute, because you can't sue the government unless the government says so. The government gives you permission in its grace. They decide when, where, how, who, etc. you can sue them. So they decide whether you have any rights against them or not. Does that give a little shiver down the back of your spine? It does to me, because when I start thinking about, imagine having the authority to decide if you're going to apologize, if you're going to compensate somebody that you harmed, if you're going to try to make it up to them. It's completely up to you. Your incentives don't really favor a lot of grace and generosity, do they? your own incentives are to keep that limited. Keep as much of that power for yourself, as much of that protection for yourself as you can. And lo and behold, that's what you see in Section 1983. So I got something I'm going to share with you guys, because this is just a great thing. If you're curious about the law, if you're interested in the law, you want to learn more about it, this is just a great thing to know that's out there. This is the Ninth Circuit Court of Appeals, Section 1983 outline. So Federal Circuit Court, it's put together this huge guide by the staff attorneys to basically navigate all of the legal issues that come up in the 1983 context. And they do this because one of the things that 1983 covers is prisoner lawsuits. So if you're being confined in conditions that are cruel and unusual, things that constitute an Eighth Amendment violation, if you're being deprived of due process in how you're being treated in prison, very common complaints to be brought up, and those go to federal court under 1983. So they deal with a massive volume of this type of litigation. Makes it easy for them to just have this handy dandy guide that they can work through. They can all see, here's the broad overview. So if you want, this is Ninth Circuit specific. It is important to realize that, because there can be variations in a lot of these details in different circuits. So you always kind of want to check where, the jurisdiction you're in, see if it's the same as the Ninth Circuit or see if it's different. But it's just a great starting point to give you an overview. If you're interested in what it takes to sue the government, come in and read the 1983 outline. The first thing I'm going to point out to you to kind of make this point about how this is a feature, not a bug, to have no skin in the game, to make it as difficult as possible for you to hold your government betters accountable, is right over here. You probably can't see it because it's too small, but it's right here where it says this guide is 252 pages long. 252 pages long. Section 1983 itself, let's look at that. Section 1983 itself, it's just a short little paragraph here. Oops, where is it? Not sure why we lost it, but we did. Right here. Just a short little paragraph. Civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the person injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. Seems like a pretty straightforward statute, doesn't it? Any person who deprives somebody in the United States, subject to the jurisdiction of the United States, of a deprivation of right, privilege, or immunity secured by the statute of other law shall be liable to the injured person. This limited exception, injunctive relief, you also have the separate act about getting declaratory relief, the separate process. If you're looking for an injunction against a judge, you can do it through here, but only if that other mechanism is unavailable. So just kind of not duplicating grounds to be able to go get an injunction against a judge. Seems pretty straightforward, doesn't it? Real simple. Violate somebody's rights, you're going to be liable for it. But then we need 250 pages to explain to you why it's not actually that simple. And this is all, once again, guys, this is judge created. Judges have decided that statute that you just read, it doesn't actually mean that. It's not actually every person. It's not actually every wrong. You're not actually going to be liable for damages. It's got this great outline that you can go through and just see overview, specific applications, different kinds of issues that come up. So what's the first thing that we argue about? Well, who's even a person? Turns out state's not a person. You can't sue the state. You can't sue the state. You can't sue state officers. You can only sue people acting in their individual capacity, people who have personally committed a wrong. So let's say in our particular case, we have some proof. We come up with some proof that Yuri Buchanan and Michael Proctor, they've personally fabricated evidence. Okay, they've gone out, broken pieces of taillight, planted little glass bumper sprinkles on Karen Reed's car. We actually got the Sallyport video, and we can prove that. Let's hypothesize that. So framing Karen Reed. They framed Karen Reed. You'd think, obviously, Karen Reed can sue them for that. Let's walk through some of the pitfalls, shall we? So the very first thing is that when we're talking about a person, that's not the state. That means, number one, you're going after Yuri and Proctor individually. You're going after them as individuals. They are personally liable. The state is not liable on their behalf. There is no vicarious liability by virtue of being the employer. So you go and you get a judgment against Michael Proctor or Yuri Buchanan. If they don't have the money, they've spent all their stuff on whatever they spend their money on. They don't have any money. You're not getting paid. You're not getting your judgment. You cannot go to the state and get it enforced. Look at this outline, guys. Like, look at it. It just goes on and on and on. 250 some pages of how difficult it is to sue the government. All the different roadblocks in the way. So the state's not a person. It's the first thing you run into. Guys, I'm just going to get us into the substance a little bit here because, number one, I really do. I want you to be able to see this. It's a great legal resource. This is a great piece of legal material. It gives you this very comprehensive, update, breakdown of all the cases, these different, different laws and so forth. This is, I believe, the 2024 update. So it is pretty current. States are not persons. They're not people. You don't get to sue the state. Officer of the state violates your law. It's not the state's problem. Not suing the state. Territories, not persons. You're not suing the territory. Look at this, though. Local governments, municipalities, and other local governments are people. So we got a difference here when you're talking about whether we're going to sue a local entity like, I don't know, for example, the Canton Police Department versus a state official like the Massachusetts State Police. Counties are also persons. So the sheriff, the district attorney and the district attorney's office, they're a person. And so they can be subject to liability if they have policies that cause a constitutional violation. Municipality may be held liable as a person when it maintains a policy or custom that causes a deprivation of a plaintiff's federally protected rights. So even if it's not written down, if it's just your way of doing things, your everyday practice, your customs, the way it's done in your department, that results in constitutional violations, because you just got a practice of cracking some skulls, you know, when a person is a certain color. It doesn't have to be written in policy. So the local government can be sued for that kind of thing, but the state government can't. Guys, sit and chew on this for a minute. Sit and chew on this for a minute. Why do you think so much of the high-level investigative power in Massachusetts has been transferred to the Massachusetts State Police? The Canton Police Department has such limited jurisdiction that they don't even know. They don't even know how to investigate a homicide. They hadn't done it for what did we hear? 20 years, 30 years, something like that. It'd been a long time. Been a long time before John being found out there on the snow that the Canton police had ever investigated a death. Why? Because all that's been transferred up to the state. And when you start thinking about this from a skin in the game perspective, you realize it's because the state can't be held accountable for any of that. If you're the local government and you're doing a murder prosecution or you're doing a murder investigation and your investigative policies are maybe a little too pushy, a little more than the Fourth Amendment will tolerate, a little more than the Sixth Amendment will tolerate, a little more than the Eighth Amendment maybe will tolerate, a little more than the 14th Amendment due process will tolerate. You, the city, you're going to be sued and you're going to be held accountable. But the state can't be. So you just transfer all of that risk associated with the most serious investigations. Just go ahead and transfer that to the state. And now, poof, our liability is gone. This is by design, folks. It's by design. This is a feature, not a bug. This is a feature of the system. So just an interesting little lens, maybe, to help understand why things work the way that they do. This is why Massachusetts does all the death investigations. This is why the state police do all the death investigations. Because the state can't be held accountable for it. Local government, you got risk. But the state, nope. Nope. So lots of detail about when, where, how. Okay, so even with the municipality, it can't just be respondeat superior. Respondeat superior is this legal doctrine that says employers are liable for the wrongs committed by their employees who are acting in the scope of their employment. So the plumber shows up to your house and the plumber's assistant is down there in your crawl space and they accidentally cut your gas line. Any liability for that, the plumber, the plumbing company, the employer is ultimately going to be responsible for that because it's their worker doing work for them in the scope of working for them that caused this damage. So they're going to be responsible for it. Doesn't apply in 1983. They're not liable just because they're an employee. They have to be liable because they have some policy or they have a practice, a custom. So, of course, a lot of detail about what that means. Supreme Court has further required that the plaintiff demonstrate that the policy or custom of a municipality, quote, reflects deliberate indifference to the constitutional rights of its inhabitants. So not just that it happened, but it's like so persistent and widespread as to practically have the force of law. So it's got to be bad. Okay, it's got to be bad. These are ways you can come in and the court can be like, well, yeah, I feel bad for you, but they haven't really done it that many times. So it's not really a custom. So thanks for coming to court. Appreciate you playing, but you rolled snake eyes. So off you go. You're out of court. A lot of detail on this, huh? Failure to train. Municipalities can also be held liable for failure to train. Isn't that kind of ironic when we look at the Canton Police Department? situation, and you know, the way that they handled their end of the investigation, solo cups, etc. Failure to train. So if you can show that because the officers are untrained, that causes routine violations of constitutional rights, then you can go ahead and go after the municipality too. So remember, these are things that do not apply to the state. These are just what allow you to go after local government. None of this applies to the state. You are not able to go after the state for any of this. A governmental agency that is an arm of the state is not a person. So not just like the state in the sense of the governor and the legislature and those official people. Any state agency, guys. Yeah, Massachusetts police, every single employer of the Massachusetts police, the state crime lab, everybody from the state's off the hook. State's off the hook. So the only time you can go after a state official in his personal capacity. That state official personally has done something wrong. So in our example with Uri and Proctor, we can go after Uri and Proctor. We can sue them for their own wrongdoing. We can't sue Tully for allowing it and overseeing it. We can't sue Fanning for promoting a culture where this type of thing is normal and routine and overlooked. And we can't sue the Massachusetts State Police generally as an entity for being responsible for the conduct of its troopers. They have no liability. So just Uri and Proctor. That's all we can go after. An exception for that is if you're suing for an injunction. And so we see like with Mark Randazza's complaint that he filed, the First Amendment case that he's filed. His First Amendment case is a 1983 case. And you'll notice it names Judge Bev, it names the MSP, people like in charge of the security and so forth. And that's because when it's injunctive relief, you can do it. You can go, and it's like an exception to this. You can seek an order compelling them to follow the law if they're not following the law. But you can't sue them for damages. You can't force them to have any skin in the game. Are they acting in their official capacity? Well, that's another potential out. Are they furthering the interests of the state? Are they acting in their capacity as you know, having the authority that their position imbues on them? A lot of detail in this, guys. I mean, here we are 16 pages in. By the way, none of this applies to federal. When 42 USC 1983 said any person, be very clear, according to the courts, that means not federal people. Not federal people. This doesn't apply to federal agents. There's a whole separate doctrine there called Bivens, which is just a mess, that says whether or not you can sue federal officials for violating your rights. And it's extremely limited. Let me see if I can remember off the top of my head. A violation of a search and seizure. So knowingly, committing an illegal search, an illegal invasion of your privacy, that's allowed. Oh man, the wrongful treatment, like willfully depriving prisoners of medical care, that can be brought under Bivens. I think there's one other. I can't remember what it is off the top of my head, but like that's it. So if your issue with them is something different, our planting evidence issue, if we were talking about federal officers that did that, no, you don't get to sue them for that. You don't get to sue them for that. It's they're not generally subject to 1983. You have to be under Bivens, and Bivens is way more limited with what you get to sue them for. So then acting under color of state law, have they exercised power possessed by virtue of state law and made possible only because the wrongdoer is clothed with authority of state law? If Uri and Proctor did what they did, and any person could do that, you don't have to be a police officer to be able to plant the evidence. It's another out. The Sallyport door is left open, and any random person can wander in, sprinkle some stuff on the bumper. You don't need any particular authority to get access to that area or to take that action. Then you.
All right, so I received a couple of motions a little while ago. Good morning, everybody. I'm sorry.
Guess we're getting going.
And there are some things we need to talk about from yesterday. Are the jurors here? Okay, good. All right, so the order I'd like to do is, Mr. Jackson, yesterday you were going to take a look at any photographs you intend to put in with Dr. Laposata?
Yes, those have been presented to the Commonwealth.
All right, can I just, are you all in agreement, or are you just looking at them now, Mr. Brennan?
I heard specifically from Mr. Brennan, but the issues that he had, obviously we're not, at this juncture, until we're heard further, we're not going to bring in anything having to do with dog bites, claws, dog dentition, any of that information, but we are going to bring in exactly what we indicated yesterday. If there's an issue with, for instance, the ecchymosis, we've got a clean copy of the photograph without any of the narrative next to it, which is explanatory. The only one I think that does have narrative is the one with the lupus machine, which Mr. Brennan indicated yesterday was not accurate.
All right. So I need to know, just for instructions to the jury, about, I'm concerned about the photograph on page 5, figure 3.
The brainstem?
Yes.
Yeah, that's going to be, we intend to show that. That shows the...
So what I would like you to do, if you could, is just crop the center that shows what appears to be blood cells, or the red. I assume that that's the part you want to get into?
Like, does that hold?
Sure. If you can crop that, I'll let it in, and I still want to give an instruction, so I need to know what you're going to do with that. I was going to exclude it, but I understand. So if you can crop, yes, if you can do that, I think it takes away some of the sting on the gruesome photographs.
Gruesome. A picture of a cell is
all right,
gruesome.
so you'll do just the brainstem on that, Mr. Jackson? All right. And so I'm concerned more about the ones that I think may cause the jurors some concern. So the photograph, figure 5, the Wisniewski spots, I thought that was in evidence. I don't know for sure if it's in evidence.
We went back and forth yesterday, and I don't believe that it's actually in evidence. It is not.
Okay, so
it's not in evidence. That was
okay.
Yesterday, we all assumed it was.
Yes.
I'll put it in evidence as.
All right, they've already seen it, so it's less likely to have an impact on them for purposes of the gruesome photographs. But and then on page 8, figure 6, the stomach lining.
Correct, that's already in evidence.
Okay, that's what I thought, Tori, you told me yesterday the number, right? So those are in. So are you using them again?
I'm going to use them again comparatively and probably side by side.
Okay. All right, I don't have a problem with that. Does the Commonwealth?
I don't.
Okay. All right. Those are the ones I was concerned about for purposes of an instruction. If there's objections to hearsay or something, I'll give Mr. Brennan an opportunity to take a look at whatever he's got.
Understood.
Okay. All right. So with that, that's helpful. Thank you. So there is a new motion this morning suggesting that the Commonwealth open the door with their questioning of Dr. Russell to allow Dr. Laposata to talk about bite wounds. So I've read that.
Correct. I'd like to be heard on that briefly.
Okay, sure.
Thank you.
With the cross opened it up the door on cross.
I'd like to start, if I may, by marking two documents with both permission. One is Dr. Laposata's entire report, and the second is her
great.
entire CV.
Okay. Yeah, those are the ones I needed from yesterday. So, yes.
Chance to
Yes.
fix your mistake, Bev. They're being quite courteous about that, letting you backpedal and go ahead and let Laposata in and blame the Commonwealth instead of acknowledging you were wrong.
Okay. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. We are asking the court to reconsider the court's ruling yesterday concerning Dr. Laposata and her ability to opine on the issue of dog bites, dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we've brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at Sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows, foundationally, we don't have to call anybody. We don't intend to call anybody. We don't have to call anybody, but we can call whoever we feel like. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. After I brought it to the court's attention, Mr. Brennan has continued along that same line. The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape. Dr. Russell was cross-examined by Mr. Brennan on the issue specifically of Dr. Laposata and her opinions regarding dog bites. He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell, specifically on the issue of whether or not she had seen Dr. Laposata's reports, whether she was aware of Dr. Laposata's opinions, implying that Dr. Laposata had opinions about the dog bites. She was asked if she was familiar with Dr. Laposata's credentials. Dr. Russell said, yes, she was familiar with Dr. Laposata by name, that she thought she had impeccable credentials, and she very much wished she could have seen her reports as it relates to dog bites. It was an intellectual curiosity by Dr. Russell that was evoked and elicited by Mr. Brennan on cross-examination of Dr. Russell. She was then asked the seminal question: did the defense, Dr. Russell, give you any reports by Dr. Laposata related to dog bites?
What page is that on here?
And the transcript?
Yes.
Oh, my motion's back at the desk.
Oh, I see it.
Does the court have it?
Yes.
Okay. I'll just read it. Question by Mr. Brennan to Dr. Russell. And so you think of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify someone to give an opinion on a photograph about the genesis of a wound related to dog bites? Answer: well, if a forensic pathologist autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not sure that person would be a very good expert in that kind of case. Question by Mr. Brennan: have you ever heard of a doctor named Laposata?
So are you going to read all 3 pages?
No.
So I've read it, Mr. Jackson.
I'd like to read it into the record, Your Honor.
It's in the record. I will put this transcript into the record. I'm not going to let you read 3 pages here.
It's not 3 pages, Your Honor. It's about another 5 lines.
The
It just
part
goes to
that
the
you
top of the
brought
next
to
page.
my attention is on page 15, not where you're reading.
Colloquy between between Dr. Russell and Mr. Brennan was specific to dog bite wounds. It was specific to Dr. Russell's understanding of whether or not Dr. Laposata had been retained by the defense, whether she was a defense expert, whether she had written a report, and whether she opined about dog bites and dog bite wounds. And after she was asked if she had been provided any reports by the defense attorneys specifically, from Dr. Laposata related to dog bite wounds, Dr. Russell said, no, I haven't been. And to summarize her statements, which the court has in front of it, Dr. Russell went on and said, I really wanted to see what Dr. Laposata had to say about these dog bite wounds. I really wanted to read her report, but no, I was never provided her report or reports by the defense. And of course, Your Honor, as the court knows, that is standard operating procedure. I don't trade reports between and among experts because obviously I want independent analysis. I don't want to cross-contaminate any opinions, et cetera, and be accused of doing so. So of course we didn't provide a report from Dr. Laposata to Dr. Russell. But Dr. Russell's intellectual curiosity was then extracted from the witness stand, and the jurors heard all of that. So then days later, not weeks, not months, 3 days later, after eliciting testimony from Dr. Russell about Dr. Laposata having a report, being hired by the defense on the issue of dog bites, and not providing that report to Dr. Russell, the Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression. They used it tactically as a sword and a shield, and that's burden shifting. That leaves the jury with the impression that Dr. Laposata was consulted by the defense, number 1, that she wrote a report, number 2, that the report was about dog bites, number 3, that she didn't provide that report to other experts, number 4, and the reason she didn't, obviously, is because her opinion, Dr. Laposata's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts. And the Commonwealth has taken advantage of that. The Commonwealth's questioning of Dr. Russell about Dr. Laposata and her report and her opinions about dog bite wounds specifically was deliberate, and it left the jury with an open question. We know they consulted her. We know it was about dog bites. This is how the jurors are thinking about it now. We know they consulted her. We know it was about dog bites. They hid the report from Dr. Russell because they didn't want her to know about it. Ergo, must be harmful to defense. Now we've got Dr. Laposata on the stand. Her credentials are peerless, absolutely peerless. They've got possibly the most qualified medical examiner in the country, certainly on the Eastern Seaboard, right in front of them, about 6 feet away, and the defense is not going to ask a single question about her opinions concerning dog bites when she reviewed the entire autopsy. How is the jury going to conceive that? How is that going to land with them? The answer is they're going to think, they have no choice but to think, the only reasonable explanation is, if Dr. Laposata's opinion helped the defense, they would ask her. If they don't ask her, it's because whatever Dr. Laposata says about that right arm and those wounds, it's got to be harmful to the defense. They would absolutely ask the question. So the Commonwealth got to have it both ways. They got to ask Dr. Russell about Dr. Laposata and imply that Dr. Laposata had opinions about dog bite wounds, and then they have it the other way, which is, let's ask the court if she will exclude Dr. Laposata from testifying about the very issue that they brought up in front of Dr. Russell.
That's a good point.
That cannot stand. That ensures, it reasonably ensures that the jury will misrepresent or misunderstand the import of why we're not asking Dr. Laposata about her expert opinion. especially as it specifically pertains to dog bite wounds. I want to talk for just a second, and that has, by the way, that has constitutional implications. Ms. Reed is entitled to a fair trial, not a fair trial that the Commonwealth designs, not a fair trial that the Commonwealth curates, but a fair trial. Regarding Dr. Laposata's credentials, we went back through, specific to the court's questions yesterday, her resume. There are no fewer than 13 classes, 13, that she has taught specific to wound pattern recognition that have included dog bite recognition. On page 7, she was the course director for medical legal death investigation. That was in 2013. She taught about dog bite recognition in that case, or in that course. She was a thesis advisor for Master of Science Graduate Medical School, Boston University School of Medicine, taught about dog bites. Staying with page 7, forensic pathology course director in pathology, course 205, taught about dog bites. Member of Quality Assurance Committee, Training Division of Trauma and Surgical Critical Care, teaching on the issue of wound recognition, animal bites, and specific to dog bites. Pediatric Forensic Pathology, Texas Homicide Symposium. She was a presenter in 1989. She taught about the issue of dog bites as it relates to pediatrics, children, dog bites in children. Forensic aspects of physical child abuse as related to being left with dogs that can injure a child, dog bites, dog bite recognition. These are all classes taught by Dr. Laposata on the issue of dog bites to other medical professionals. The one that stands out, however, and I'm not going to go through the other 9 or 10 or 11, the one that stands out is 2015 and 2016, 2 courses. The name of the course, Emergency Room Forensics, Evidence and Patterned Injuries, New England chapter of the International Association of Forensic Nurses, taught in Norwood, Massachusetts, both times, specific to dog bites and the issue of dog bites as seen by emergency room physicians, how they should handle them, what they should do with them, how they should view them, what to look for in terms of pattern recognition.
Not an ER doc, she just teaches them.
She's eminently qualified. I will leave the court with one thought. The court indicated when qualifying Dr. Russell, one of the preeminent things that the court mentioned in qualifying Dr. Russell is that Dr. Russell utilized a methodology that the court sanctioned and quoted and said the methodology that she used of wound pattern recognition, dealing with differential diagnosis, utilizing and interpreting dog bites by the method of exactly what Dr. Russell did. Differential diagnosis is something that the court said was exactly why the court sanctioned Dr. Russell and blessed Dr. Russell as a qualified expert, and that's exactly what Dr. Laposata testified yesterday she utilized and utilizes in coming to her opinions and conclusions. Going back to the open door issue, obviously she's eminently qualified, but Your Honor, this cannot stand. The Commonwealth cannot have it both ways. They cannot walk up and say and leave the impression with the jurors that Dr. Laposata opined about the dog wounds, but we're not able to hear it. We, the jurors, are not able to hear it because obviously that is something that is her opinion, whatever it might be, is harmful to the defense. When in truth and in fact, it's exactly the opposite. Dr. Laposata's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog. Period, full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury. Ms. Reed is entitled to more. She's entitled to better. She's entitled to the evidence.
All right, thank you, Mr. Brennan.
All right, thank you. Thank you, Mr. Jackson. Good night.
The pattern of conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. And that is, the defense uses their witnesses to vouch for their own credibility. They use their witnesses to introduce information they know is not admissible, and they use their witnesses to introduce otherwise inadmissible hearsay. Dr. Russell took the stand and she was led into answers where she was vouching for her own credibility. Dr. Russell promoted herself not only as an expert, but through the defense's questions as virtually the only expert in America who has the expertise to give this type of opinion. It is the defendant's tactics that open these doors that they then want closed. The defense had Dr. Russell all but assure the jury that she uniquely was in the position to give any type of opinion regarding dog bites. Inevitably, when I asked Dr. Russell, and I began asking her about her credentials, whether she thought that she was exclusive, and I mentioned Dr. Laposata, she denied ever reading anything about Dr. Laposata. I did not specify whether she read an opinion about a dog bite. I asked if she had heard about Dr. Laposata. She denied it, and then she told us that she knew about Dr. Sheridan. Unsolicited, then added that Dr. Sheridan, involved in a previous proceeding, believed that the bites were consistent with dog bites. I don't know how she became aware of Dr. Sheridan's testimony, and since the defense doesn't speak to her about these things, she must have watched it on her own. But inevitably, she introduced inadmissible hearsay and inadmissible opinions. And so the sum zero here is that Dr. Russell has denied that she saw anything relative to Dr. Laposata, ensured that she was exclusively qualified, and introduced an improper opinion.
Already glitchy.
As it pertains to dog bites. We asked her questions about her specific experience. She did not provide a basis, and so her opinions regarding dog bites should not be permitted in this trial.
Just to clear up the record, two things stand out about that speech. Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
So
No, I'm not gonna.
I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to your
How about
argument.
if I quote his words? How about that? Question. And so you think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. Laposata? Those were his words. Then he goes on, I think he also just said that he did not elicit information about other individuals, including Dr. Sheridan or anybody else. Question by Mr. Brennan. Were you ever told what other people's opinions might be regarding those photographs? That's the question that she was answering when she said, quote, I'm aware that there was a Dr. Sheridan involved in the previous proceeding, and he believed that those were consistent with dog bites. That was in relation or in response to Mr. Brennan's specific question. She didn't just elicit that. She didn't volunteer it. She said it because he asked her. And that was all by design. The entire thing has been by design. He elicited the information suggesting that Dr. Laposata was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. Laposata to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand in this courtroom.
Go ahead.
It's helpful if you read the entire thing in context, which I won't do. We always have a right to object to an inadmissible opinion. So the suggestion that somehow an ambush here is not only misplaced, it's strategic by the defense to try to create an error. It's improper.
All right. I'll be out in 10 minutes on this, and we'll get started right away with Dr. Laposata.
All right, the court, please.
Got to go hunt down a rule of statutory construction that says, nah, you know what? Don't think I'm going to follow the rules here. No, of course she's running out to think about how are we going to hold Hank accountable for his appalling courtroom behavior, cutting off the other party, arguing with the other party, directly addressing the other party. You guys know that in the courtroom, the attorneys do not talk to each other. The attorneys only talk to the judge. The judge talks to the attorneys. This appalling courtroom behavior, interrupting. You know, there's a rule of professional conduct about, oh, how exactly is it phrased? Disruptive conduct. That's not supposed to be engaging in disruptive conduct. That is unethical. And yet we see it repeatedly. Nothing, no issue. He can get up there and argue, lie, dispute. Get in a little verbal throwdown with AJ right here in open court. That's the decorum. That's the level of decorum that she has in here. It's embarrassing. It's like a Maury Povich show in this courtroom. If you didn't know better, you might think she wants it like this. Thank you, Mr. Jackson. It's denied. We're just waiting, you know. If we didn't have to be so jaded, we wouldn't be. But there's a reason why we are, guys. There's a reason why we are. We spent, 30 minutes this morning barely scratching the surface. Because, of course, we were late again today, right? We all knew that. She tells the jury to come in 20 minutes late. We'll be ready for you. No, you won't. We already know that. I don't know how you're the only person in the room who hasn't quite figured out that you're incapable of doing things in a timely fashion. But because of that, we spent 30 minutes this morning just barely scratching the surface of how the government doesn't allow you, doesn't want to be accountable to you for harming you. And we haven't even gotten into the good stuff, guys, yet. We haven't even gotten into the good stuff. Let's just go back real quick, shall we? All these different people that are state, hey, this is all just about whether you're acting under color of state law, because that can potentially give you a way out. The types of rights that you have, sometimes the right is going to allow you to sue under 1983, but sometimes it won't. Has to be the proximate cause. Supervisor in and of itself is only liable for this deliberate indifference. So you know what your underlings are doing and you don't do anything about it. That's the only way you get after somebody like a Tully, to have some independent wrongful conduct, a fanning for supervising. Urian and Proctor in our planting evidence example, planting evidence to frame somebody. Only if they knew and were deliberately indifferent. Otherwise, they're off the hook. Here's where it gets good, guys. Here's where it gets good. Here's where it gets real good when we start talking about immunity. Everything else being equal, we've established just the claim itself is difficult enough. And now we're going to start throwing out people that you can't assert it against, no matter what they do, because their immunity is absolute. Absolute immunity has been granted to the president, judges, prosecutors, witnesses, officials performing quasi-judicial functions, and legislatures. Oh, looks like they are back in court. Yep, let me get us back.
Your rights are saved. I'm going to give an instruction regarding burden shifting. So,
Not allowing it, you get an
It's
instruction.
outrageous. I think the conduct is outrageous. And I don't think that a curative instruction can do anything except bring the point home yet.
okay.
But if the court is not willing to allow her to testify to her full opinion to a reasonable degree of scientific certainty, can she at least testify that she reviewed the arm, looked at the arm, that it's consistent with an animal? Can we at least split the baby?
I will do that. I'll allow that, yes. Over the Commonwealth's objection.
Can I look to have the cross-examiner? Because if you want to allow a consistent opinion with a dog,
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, seeing animal bites, this is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar before I display anything. That will include a representation of what an animal jaw looks like.
No. No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
That's what I said so.
No visuals, just that one sentence that's consistent with what she has seen. It's an animal bite. A brief foundation, because I'm letting that statement in as long as she has said, as long as she testifies that she has seen animal bites over the years. That's it, Mr. Brennan. That's what I'm doing. So you don't want an instruction, Mr. Jackson? Okay. All right. So there are two other quick matters, but the jury's been here, and I don't think we'll get past the break without this anyway. I may have left it in I left it in my office anyway. So let's just bring the jurors in and move forward with this.
She's red again. She's red. Absolutely hated doing that. Absolutely hated that. You get the one line. Why? Because I said so. Because I said so. Like we're a bunch of toddlers in here and she's just mommy. Like she's not bound by rules and standards. But she just has her own judgment and authority. While we were talking about the king, this old idea, the king's authority flows straight from God, so he can do no wrong. Real similar kind of attitude we see here in this court, because I said so. Nobody gives a shit what you think, Judge. Your job is to enforce the law, not to make it up from the bench. And you know perfectly well that's what Mr. Jackson is asking for. What's your legal justification for saying Karen can defend herself with this one sentence, but not the others? So the imperial court that we witness here in Massachusetts, particularly gross. Can't wait till we get more into this immunity discussion. Can't wait. Can't wait. Just wait till you see who is immune, what they're immune from, and who's not. Wait till you see. And you'll start to think to yourself, wow, almost looks like this is all by design. It almost looks like it's set up so that peons like you and me can be accused of crimes and railroaded, and we have no recourse. Can't do anything about it. Powerless against the government. Almost looks like that's on purpose. It's going to get worse, guys. We're going to look further, and it's going to get worse. Oh my God, Darlene D. I once had a judge tell me I am the law. That's like the most Louis the 14th thing I've ever heard come out of a judge's mouth. It should never come out of a judge's mouth. L'état, c'est moi. L'état, c'est moi. I am the state. I am the ruler. I am the law. Like you're the Sun King. Absolute authority. You want to order people's heads off? They'll do it. You want to order people tortured in the street? They'll do it. You have the power to do that. Anyone refuses their orders, you can do it to them too. Why? L'état, c'est moi. That is what this judge thinks about her authority in this courtroom. The rules, all those fancy books that are all dusty on the shelf behind her, if she wants to go by it, she will. But she feels completely untrained by it, doesn't she?
You are unmuted.
Yes, thank you.
Surprise to the jury. Hey. All persons have any business before the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court, before the County of Norfolk. Draw near, give your attendance, and you shall be heard. I say the Commonwealth of Massachusetts. The court is now open. You may be seated.
Good morning, jurors. Thank you for your patience this morning. I know we brought you in late. Maybe should have brought you in a little bit later, but we've been working in an effort to sort of streamline things for you. So I do have those questions I have to ask you. Is everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or should. All right, can we have Dr. Laposata back, please?
Yeah, follow me now.
And Doctor, I'll remind you, you're still under way. Thank you.
Thank you.
I will. Good morning, Doctor.
Morning, Your Honor.
This 1,000,000 times. Bubsy, you nailed it.
All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Good morning, Dr. Laposata. Nice to see you again.
Good morning. Glad to be here.
Yesterday, when we last left off, we were talking about a small injury to the upper eyelid of Mr. O'Keefe. Do you recall that?
I do.
Could we have Exhibit 165 with the court's permission, please?
Okay.
I'd like you to take a look at a specific area. I could. There we go. Right here on this exhibit. Do you see that area?
Yes, I do.
Is that, tell us what that is.
And that is a horizontal splitting of the skin, which was caused by application of force that overcame the tissue's resistance, so the tissue split. And behind that, we see the raccoon-eyed discoloration of the eyelid from the basilar skull fractures.
Can we have Exhibit 13, please? I want to draw your attention to this area of the vehicle. First of all, do you recognize this photograph?
Yes, I do.
How do you recognize that photograph?
I recognize it from looking at it in my materials reviewed, that it's the rear of Miss Reed's SUV.
Taking a look at the area that I'm highlighting, right about there.
Yes.
Could we zoom in on that area? Do you see that overhang over the window?
Yes, I do.
If I use the word spoiler, would you understand what I'm talking about?
Yes, yes, I do.
Knows what a spoiler is. That's our girl.
Is the laceration to Mr.
Explain the
O'Keefe's
physics of the
upper eyelid
spoiler.
that we just looked at, is that consistent in your opinion with a strike from that area of the vehicle if that vehicle were traveling in reverse at, say, 20 plus miles per hour?
No, that rounded, thick area would not cause that skin defect in his upper eyelid.
If, in fact, a person were hit at, say, 20 plus miles an hour in the face with that rounded edge, what kind of what kind of injury would you expect to see on that person's face?
I would expect to see a ribbon of bruise that would correspond to the height of that spoiler, and then it would go across the eyeball, it would hit the nose. So I would expect to see some horizontal ribbon of bruise.
Did you see anything consistent with that, with Mr. O'Keefe's injuries?
No, nothing.
Thank you. We can take that down. We talked yesterday about this phenomenon known as coup contra coup injury to the brain, correct?
Yes.
What happens to the brain after a coup contra coup, a significant coup contra coup injury?
Yes, this was quite a severe brain injury. Was injured on the back of the brain and also the front of the brain. The falling back and impacting the back of the head made the skull fracture radiate along the base of the brain on the right and left sides. It also radiated around on the side of the skull, and that indicates a tremendous transfer of force and energy to the skull and then to the brain, and the brain is rattled around, therefore, within the cerebral spinal fluid in the skull. So what that does is that it breaks the connections between the neurons in the brain and causes small little hemorrhages, and it causes the brain to swell. So when you get an injury, like if you get an injury on your arm, it starts to swell. The same thing happens when that injury energy is applied to the brain. The brain starts to swell. And unfortunately, the brain, when it swells, it doesn't have anywhere to go because it's encased in the skull. So what happens is that the brain and the brain stem under the brain starts to go down the opening in the base of the skull where your spinal cord goes. And that is a harbinger of death, because that means that the brain stem is getting pushed down in this hole in the skull and compressing the areas in the brain stem which control the heartbeat and breathing. And that's called brainstem herniation, and that you just die after that. So that's what happened to Mr. O'Keefe's brain.
Your Honor, I have a document that I'd like to approach with.
Okay.
Yes.
Doctor, can you take a look at that document that I just handed you and tell me if you recognize it?
Yes, I recognize this.
How do you recognize that document?
From looking at the autopsy photos of Mr. O'Keefe's brain.
And what portion of the brain are you looking at?
This shows a photograph looking up under the brain, and it shows a cross section of the brainstem that went down in the hole in the base of the skull, and we see there's hemorrhage in it, and those have a special name. They're called Duret hemorrhages.
How do you spell that?
D-U-R-E-T with there's a little accent somewhere there.
Carrot over the E?
Yes. And this shows that the brainstem is going down into the hole where the spinal cord goes. It's stretching the blood vessels and causes little hemorrhage and compresses the neurons in the brainstem, which control your heart rate and your respiration. It's called brainstem herniation, and that's a harbinger of immediate death.
Your Honor, with that, I would ask for the admission of the next, that document is next in order, subject to the appropriate redactions.
Okay, so we'll take that into evidence.
May I have a moment, Your Honor?
Yes.
Your Honor, with the court's permission, with the redaction, may I present the...
Not yet. 1 minute. Jurors, I told you before that there were photographs that have been introduced into evidence that aren't pleasant. And you may find that these photographs are graphic. And I'm instructing you again that your verdict must not in any way be influenced by the fact that these photographs, you'll see some more today, I believe, that have already been introduced into evidence. So your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant's entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by the photographs. Importantly, consider the photographs only as they may draw your attention to a clinical medical status or to the nature of Mr. O'Keefe's injuries themselves. So again, these will be presented to you in the deliberation room in an envelope. But today you'll see some on the screen, and I just wanted you to know that before you see it. So now you can display it.
Your Honor, may I approach very briefly?
Yes.
If you wouldn't mind taking a look at that document.
Oh,
Is that
yes.
a redacted version or a close-up version of just the brainstem?
Yes, this photograph shows the cross-section going this way of the brainstem with the hemorrhages caused by the brainstem going down into the foramen magnum.
With that, Your Honor, actually, with the court's permission, I would trade that as the next in order rather than the unredacted version.
All right, is there any objection to switching the exhibits like that?
No.
Okay.
Thank you.
Oh, and the arrows point to that on it.
So this is going to be the next exhibit?
That'll be it.
Exhibit 225, Mark.
Thank you. The other one will be for identification, the first one.
Thank you, Your Honor.
And that'll be FFF for ID. Number F.
Okay, you can display it now.
Thank you, Your Honor. Mr. Walt? Do you see what's displayed on the screen above your head?
Yes,
What is that?
excuse me, that's a cross-section across the brainstem of Mr. O'Keefe, and it shows where the blue arrows I've put in there show the red areas, which are areas of bleeding, which is the sign of brainstem herniation. All the background is white material, and that's part of the appearance of neurons in the brain. So that shows that the brainstem, because of the brain swelling, pushed it down into the hole in the base of the skull where the spinal cord goes, and it pulls on the blood vessels, causing the blood vessels to break and the blood vessels to bleed. And that shows you that the brainstem has been compressed and damaged, causing death.
May I approach?
Yes.
I'm holding a green laser pointer.
Oh, thank
You can
you.
use the display to your right, so the viewers can better see it. Could you point to the areas with that laser pointer of the bleeding that you indicated causes the swelling?
Okay, so, okay. Is that going on the?
It is. It's probably
thank
hard for you to see.
Oh, that's okay. So this sort of roundish thing is the brainstem, and the arrows are pointing to the red areas. So there's a blood vessel that's broken there because it's been torn and pulled, with surrounding blood going into the neuronal tissue here and over here and over here. And also some of this is also bleeding, with the blood looking brown because the brain was placed in formaldehyde. So all this brown area, the red area, should not be there.
Is this type of herniation life-threatening?
It causes death. Yes, it is life-threatening.
How quickly, we can take that down. How quickly, doctor, would you expect that this could cause, let's first talk about incapacitation.
Yes.
How quickly would someone be incapacitated after they suffer a coup contra coup injury of this magnitude with the concomitant injuries that you see in the brainstem?
Well, there would be two parts to what that injury would cause the body to do. First, there would be immediate unconsciousness because of the transfer of all the energy to the brain and the massive skull fractures. So that, excuse me, so that would disrupt the normal function of the brain and produce immediate unconsciousness. Then the brain would start to swell, and within 15, 20 minutes or so, then that brainstem starts to go down the opening in the bottom of the skull, and then the blood vessels are broken, the brainstem gets compressed, and the centers in that brainstem which control the heart and the respiration then stop. So you go unconscious, brain swells, then you die.
Turning to the actual, your review of the actual brain, in this instance, Mr. O'Keefe's injuries specifically, did you reach any conclusion or opinion to a reasonable degree of medical certainty about his incapacitation, the length of time it would take for him to become first incapacitated and ultimately to be rendered dead?
He would be immediately incapacitated with a decreased level of consciousness. Once he received that impact on the back of the head, he would not be able to make any purposeful movements. There might be some arm jerking or some seizure activity, but he would not be able to carry. He wouldn't be able to get up. He wouldn't be able to walk. He wouldn't be able to do any purposeful activity. He would be severely concussed, unconscious, not able to walk, not able to carry out purposeful activity. And then as the brain continues swelling and that brain stem gets compressed, then the heartbeat is disrupted, the breathing is disrupted, and then those heart and breathing stop. And within 15 or 20 minutes, then he could be dead.
Is that opinion to a reasonable degree of medical certainty?
Yes, it is.
Interesting. Dead
You
within 15
testified
to 20
concerning
minutes.
wound pattern recognition pretty extensively during the course of your giving your qualifications. What is a patterned injury?
A patterned injury is very basic to the training in forensic pathology and medicine because it helps us understand some change on the body, some pattern injury that corresponds to the object that made it. So we can look at an injury and say, we can figure out what made that. Sometimes you can, sometimes you can't. But a pattern injury is very important for a forensic pathologist to recognize because it's going to really help the police investigation, because I could say, oh, this looks like it's a wound from scissors. This looks like it's a wound from a screwdriver stab. So by identifying the pattern that object makes on the body, I can help the death investigation by helping the police say, look for some screwdriver, look for some hammer. So looking at that, identifying a pattern injury is really important it's basic to the forensic pathologist's knowledge base, and then also very important to the investigation of the crime or incident.
I'd like you to look at another photograph, an exhibit that's already been put into evidence. 160, please. With the court's permission.
Yes, jurors, this may be one of the photographs as well. Right. Or there'll be a series.
Dr. Laposata, I want to draw your attention to the center of this photograph.
Yes.
First of all, do you recognize what's depicted here?
Yes, I do.
How do you recognize?
I recognize it from reviewing the autopsy photographs of Mr. O'Keefe.
You reviewed it, informing your opinions and conclusions?
Yes.
Can you describe what's depicted in this photograph? What are we looking at?
Yes. So we're looking at the back of Mr. O'Keefe's head and an injury caused by the angular acceleration going down and hitting his head in the back. And then this is also a patterned injury. So what we see is the horizontal tear of the scalp, and we can see it's undermined a little bit. So that means the direction is going from bottom to top. Also, we see these sort of vertical lines in here and down below. So what that tells me is that the back of his head hit something that had a fine granular pattern to it to cause those individual little marks, and then also something that had a linear or ridged pattern that he went back on that broke the scalp there. So we have two parts really to this pattern injury. We have the horizontal tear of the scalp made by impact with some sort of ridged surface. And then we have these vertical scraping of the skin above and also below. They're obscured a little bit by the ruler there, which says that whatever he hit had some little like granularity to it, with each little sort of granule making those vertical marks, and then the ridged pattern having the major point of impact.
What is the significance of the pattern when you say ridged pattern, and there's two things we're looking at, the laceration or the abrasion versus the defect above and below that laceration?
Yeah, so what this injury tells me, or what I would tell the investigators, is that Mr. O'Keefe went back onto some object that had some sort of ridge to it to make that horizontal tear in the skin, but that ridge also it wasn't smooth. It had some little grainy grainy thing sticking up on it that would make each of them these
like a
little
concrete step.
things. And then it's the job of the police then to go back to the scene and look around for something which might fit that pattern.
We can take that down. Did you, in furtherance of your investigation, coming to your opinions and conclusions, look at the area of 34 Fairview?
The outside, yes.
Meaning photographs?
Yes.
Did you also see photographs of any significance to you related to the garage, the interior of the garage?
Sustained. Jurors, disregard that comment, that question.
What part of the area did you see? What part of the location did you see?
I saw all the scene photographs taken by the police, which showed the front yard in the area where Mr. O'Keefe was found. I also saw some photographs of the inside of the house and the inside of...
So I'm going to stop you there, Dr. Laposata. Jurors, I'm striking anything afterward. The pictures from outside, Mr. Jackson. Move on.
Let's stay with the outside of the home. Did you see the front lawn area?
Yes, I did.
How did you, what did you note about the front lawn area?
Well, I was looking at the area where Mr. O'Keefe's body was found, because we know once he came back and slammed his head, he's not going to get up and move around.
So, yes, I'm going to strike the second part of that. Just answer the question specifically.
Okay, I'll try, Your Honor. Thank you.
You already testified to that.
Why were you interested in the outside area where his body was found?
Because then I could identify an object possibly there that would have caused the injury on the back of his head.
Did you see any such object in any of the photos that you reviewed?
No, there was nothing there. It was a flat grass surface.
Would the flat grass, let's assume that the grass was very cold and very hard.
Very
the dirt was
cold.
very cold and very hard. Would falling backward onto that dirt, hard or not, would that cause the patterned injury that you see, that we just saw in Exhibit 160?
No.
Why do you say that?
Because if you fall back on a flat surface, you get many times the tear you get in the scalp can be more like a star, because you've just hit one part and then the tears go in kind of a star pattern. And also because you would not have those discrete vertical scraping of the skin. You would tend to, if you fell back on grass, you would tend to see, you might see grass in the wound, or you would tend to see an irregular kind of crisscross pattern of the flattened grass. And that's not what we have here on Mr. O'Keefe.
Do you have any training or experience in diagnosing hypothermia in individuals?
Oh, yes.
Have you conducted autopsies of individuals who have suffered from or died from hypothermia?
Yes, many.
How many?
100 or more, and then I've supervised my assistants who've also diagnosed the same death from decrease in body temperature.
Have you ever engaged in any death investigation, aside from the actual autopsies, death investigations in which the cause of death was deemed to be hypothermia?
Yes,
How many times would you say you've undertaken that type of investigation?
at least 100.
Have you ever reviewed any peer-reviewed medical literature associated with or discussing hypothermia and something known as Wisniewski spots?
Yes, that's in the medical literature and also in our forensic textbooks.
Did you review the medical examiner's file, Dr. Scortibello's file, as it related to, well, in connection with this case, you reviewed the entire file, correct?
I did.
Did you conduct a differential diagnosis as it relates to the potential for hypothermia?
Yes, I did.
Describe, before we get into your findings or your conclusions and opinions, what is inferential thinking?
Inferential thinking is another name for making a differential diagnosis. In other words, seeing a finding and then saying, how many ways can I get that finding? And then go and investigate each one of those ways and either rule them in or rule them out as being responsible to causing that finding.
Did you note whether or not the medical examiner, Dr. Scortibello, mentioned hypothermia as a potential cause of death in this case?
She did put that on the death certificate.
Along with something else?
Along with the blunt force head injury.
Do you agree with or concur with the blunt force head injury as a cause of death?
Yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment. So those are the two things you have to look at.
There we go. This has been bugging me since day one.
Take a look.
How much is because he's dead and how much is because he's in the cold?
Thank you, I apologize.
Yes.
Do you recognize what's depicted in that photograph?
Yes, I do.
What is that?
This is a photograph I took from our forensic medical literature, and it shows the lining of the stomach. So the stomach is opened up, and we look at the lining of the stomach, and it shows a characteristic pattern of small ulcerations throughout the stomach, which are called medically Wisniewski's ulcers, and that allows a forensic pathologist to diagnose death from being exposed to a cold environment or death due to hypothermia. And they're caused by, as the body gets colder and colder when it's alive, the small blood vessels in the lining of the stomach, they start to break, and then they're in the acidic environment of the stomach, and you get tiny little ulcers, which then look like small dots. And that is how at post-mortem examination or autopsy, it's one of the findings I look for to see if a person died from hypothermia.
Doctor, what is gastric mucosa as it relates to the stomach lining?
The gastric mucosa, when you open up the stomach and you look at the inside, the first cells lining that inside is called the mucosa.
Is that what we're looking at in this photograph or no?
Yes, we're looking at the mucosa with ulcerations, which are little craters that form in it due to hypothermia.
Is that exemplar of what Wisniewski spots looks like as it relates to hypothermia from a book that is, or literature that is peer reviewed?
Oh, yes.
Is it widely accepted in the medical field?
Yes, it is.
And is it referenced by forensic pathologists and used in teaching?
Yes.
Your Honor, I would move for the admission of that photograph.
Okay. Exhibit 226.
Permission to display, Your Honor?
Yes.
Textbook, but is it still
Is
too
this
graphic
a
for
fair
TV?
representation of what you were just looking at?
Yes.
Describe what we're looking at.
Okay, so this, I took this photograph from our forensic medical literature, and this was from a person who died due to exposure to a cold environment. And this is the stomach has been opened, and we're looking at the inside of the stomach. And the normal appearance is kind of pinky white. That's how it should look like. And what's abnormal here is all these black dots, which are the Wisniewski's ulcers, which are diagnostic of death due to exposure to the cold. So these areas are little tiny craters, and they fill up with blood. And we see that in over 90% of the cases of people who die from exposure to the cold.
Doctor, did you also look at Mr. O'Keefe's stomach lining?
Yes, I did.
If we could have, with the court's permission, Exhibit 164 put up as well.
Okay.
Go ahead and Google Wisniewski's ulcers if you want a visual on that. It's kind of creepy.
Do you see the photograph on the right?
Yes.
What is that of?
This is the Mr. O'Keefe's stomach, which has been opened up, and we're looking at the inside. We see that the mucosa is a little bit red, and there's a little bit of increased blood flow here, and this is the normal pattern of the inside of the stomach. It's kind of ridged, that's called rugae. That's the normal folds inside the stomach. But there's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
Did you see, or do you see, any classic Wisniewski spots in Mr. O'Keefe's stomach lining or gastric mucosa?
No, no.
Do you observe any ulcers specific to Mr. O'Keefe's stomach lining?
No, there are no ulcers. It's a normal appearance of what we would call a gross specimen. When you open the stomach at autopsy, you can see some redness of the normal lining of the stomach.
Did you, let me ask this first. Do you have an opinion as to a reasonable degree of scientific certainty based on the totality of your review and examination of the autopsy and its associated file, an opinion as to whether or not Mr. O'Keefe died of hypothermia or complications related to hypothermia?
I do have an opinion.
And what is that opinion?
He did not die of hypothermia.
And is that opinion to a reasonable degree of medical certainty?
Yes.
Taking a look at the darker red areas in the stomach lining of Mr. O'Keefe on the photograph to the right.
Yes.
That's Exhibit 164. Can you describe what those are? What are those darker areas?
Well, here we see a little bit of bleeding. The darker areas are the areas of the lining that are at the bottom of the normal rugae, because the inside surface of the stomach sort of looks like it's covered with little mountains. And so we can get the redness in between what the rugae in the stomach, and there's a little bit of increased redness here, but no ulceration.
Do you have an opinion, or were you able to form an opinion as to what the increased redness might be or is associated with?
Yes.
Did you note anything of significance in the rest of your examination of the file, the autopsy file, the medical examiner's file, that was related to what you see in the photograph 164?
Yes.
All right, see you at sidebar for just a minute here.
We can take that down.
Sidebar, because Bev doesn't want it coming in that the reason why he's got redness and a little bit of bleeding in his stomach is related to alcohol. Has nothing to do with dying in the cold. Has to do with his Pepsid prescription, and she saw that. We already know this is coming, Bev. It's already out. We already heard about it. It came out on Cross with Scorty Bello. We know it's coming. She gets to give her opinion about the medical condition, and the reason why Scorty Bello's opinion on this, on hypothermia, should be discounted, as he failed to account for what's in the medical records.
May I continue?
Yes.
Thank you. With regard to the, it's my word, not yours, doctor, so forgive me, the defects, the redder marks that you're mentioning on the rugae or in and around the rugae on the gastric mucosa. Did you note that there was a machine that was used for life-saving measures as it related to Mr. O'Keefe?
Oh, yes, it caused some damage to the body.
Okay, let's talk about that for just a quick second. What is that machine called?
It's a mechanical device to administer chest compressions, and the company that makes it is called Lucas, or one of the companies, so it's called a Lucas machine, and it can be attached to the body. Your arms go up over a ridge, and there's a plunger, and it goes around your back, and so it just plunges, and it does mechanical resuscitation and chest compression, compressing the chest right over the lower sternum, about 2 inches or so, and it's very helpful in a situation where the manual compressions, where the attendants and the ERT people, they get tired continually compressing for a long period of time. So the mechanical device was invented to prevent the EMT fatigue when administering chest compressions.
When you mention the sternum area
Yes.
of the body, are there, let me go without saying, are there organs beneath the area that's being compressed by the mechanical Lucas machine?
Oh, absolutely.
What do those organs include?
Well, ideally they include the heart because that's what's supposed to be pumping the blood out, but it's also in a circular area that's right below the sternum, which includes the heart. But what is also under there is the esophagus and the interior of the stomach. So this area is right under where the machine is compressing as well, as long as, in addition to part of the head of the pancreas, which is also right there under the lower sternum. And what can happen with the Lucas machine pushing in for 100 times a minute for a depth of about 2 or 2.5 inches, that these organs right underneath of it get compressed between the Lucas pump and the bony vertebral bodies that's along your back. So you have the Lucas machine compressing these organs, and they're compressing them against the vertebral bodies of your bony vertebral column in the back. So you can get other injuries, organ injuries, that is a complication of the automated mechanical resuscitation. You can get cardiac ruptures, you can get ruptures of the liver, because all those organs are clustered right there, and that machine is pushing those organs in between the pump and the back of the bony spinal column.
Doctor, in your review of the medical records, was there any indication that an automated chest compression machine, a Lucas machine, was used on Mr. O'Keefe?
Yes.
May we can take this down?
Yes.
There's two documents that I'd like to show you. First,
Yes.
that document, and then after you're finished, familiarize yourself. First one and then the second one.
Yes.
Taking the first document that addresses the Lucas machine,
Yes.
how do you recognize that photo or those series of photos and graphs?
These are illustrations I put in my report, and one shows a generic patient with the Lucas machine in place around him to do the chest compressions. Then I have a photograph of the actual apparatus of the Lucas machine itself. Then I show what's recognized as medical complications and injury from that machine. It shows, I have an example of a CAT scan of a section through the body horizontally, right where the plunger goes into the chest. And it shows in another patient hemorrhage around the pancreas and around the top of the stomach. Then I have a diagram also taken from our medical literature that shows the direction of force that compresses those organs between the resuscitation paddle and the vertebral body and the backbone.
Doctor, are those photographs and graphs taken from peer-reviewed literature in the medical field that's normally relied on by other medical professionals?
Yes.
Your Honor, I'd move for the admission of that first document.
Right, subject to redaction?
I don't think so. I think that that one is not objected to.
Okay. So would you hand that to...
Oh, sure, thank you.
Exhibit 227.
The reason this machine is so damaging is because it's the trade-off. You're going to die without it. You're probably going to die even with it, honestly. Resuscitation does not have a great success rate. So they just don't worry about that. Lower concern.
Doctor, I know that's a little bit small and far away. We'll enlarge it as you need. It's not an eye test. Can you tell me what we're looking at? Yeah, let's take the top half of the document. what is that to the left, and then what's the machine in the
Okay,
middle?
so what you see on the left is a anonymous patient showing how the Lucas machine is placed onto the patient, where the arms are pulled up and clasped against these rigid mechanical bridges, and then here is the engine which puts the pump, and that's the pump which just goes up and down to do the chest compressions. And so that's how it's affixed to a patient.
To be clear, doctor, that is not Mr. O'Keefe. That is
No, this is
Could be a model.
an unknown person.
Okay. And then what are we looking at in terms of the actual machine to the
Yeah,
right?
this shows the actual machine before it's put on a patient. You can see how it encircles the patient, and then there is this circular pump, which is the compressor pump.
If we can look at what is that a picture of, the highlighted portion?
That's the circular part that actually is projected down onto the body.
That makes contact with the chest?
Correct, and it has a spring in there that the engine above it gives a certain number of compressions per minute.
And you said on average the compressions per minute would be about what?
They should be around 100.
Okay. If we could go to the bottom half of the page of the graphics on the bottom. What are we looking at in this photograph?
And we're looking at, on the left side, we're looking at a CAT scan, which scans a person who's had some injury from the Lucas compression machine, and it's a cross section. So the arrow here is pointing to the head of the pancreas and the area of the esophagus, and then the machine would compress down onto that. And the important part is that I don't know if that's working on there. The little thing that looks like at the very bottom, that's circular and then has a little, looks like a little steer head, that's the vertebral column, and that's bone. And so the pump is pushing in that area where the arrow is pushing those organs against the bony vertebral column. Excuse me. And that's an actual patient that had that. Then on the right, it shows the schematic of the blue arrows indicating the force coming down. Then we see the organs, and the red arrows show how the pancreas can get hemorrhage, and also some of the esophagus that goes into the top part of the stomach. And we see that's, I can't really see where that, I think it stopped.
Oh. May I approach you?
Yes.
Oh, no, you've got it. Okay.
Could be a pattern issue.
Okay. And then we see at the bottom with those three little things projecting from it, that is the vertebral body, which is made up of bone. So you can see how the chest compressions, not only hoping to save the life by keeping the heart blood functioning, can also cause some injuries and damage, not life-threatening usually, to the other organs there.
We can take that down. Doctor, taking a look at the second document that's in front of you, do you recognize what's depicted in that document?
Yes.
What is that?
This is a picture of Mr. O'Keefe's chest while he's at the hospital, which shows a lot of the resuscitation equipment.
Is that a true and accurate depiction of the of Mr. O'Keefe at the hospital based on your review of the medical file?
Yes.
I'll move for the admission of that.
Okay. Oh.
Exhibit 228.
Permission to display briefly.
Okay.
Taking a look at the photographs to the left and to the right, do you see any indication on Mr. O'Keefe's body that is suggestive that the Lucas machine, where the Lucas machine was situated?
Yes, as I pointed out here with the blue arrows, that big circular mark there is the mark on the skin where the compression pump compressed the chest of Mr. O'Keefe, and it caused some rib fractures, and it also caused those reddening of the stomach and some hemorrhage in the pancreas.
We can take that down. Doctor, based on your review of the medical records, did you calculate the approximate number of compressions that Mr. O'Keefe would have been subject to based on that Lucas machine?
Yes.
What is that calculation?
His body was found around 6 in the morning, and he got to the hospital around 6:37, I think. So if they put the Lucas machine on him when they got him into the ambulance, and it's compressing at 100 times a minute, and that is from the time of the body being discovered to the time at the hospital, that's around 37 minutes. So if you multiply 37 minutes times 100 compressions a minute, that's around, over 30,000 compressions that would have been done to Mr. O'Keefe's body in the course of his resuscitation efforts.
Doctor, do you have an opinion as to what caused the hemorrhaging that we saw on Mr. O'Keefe's stomach lining?
Yes.
What is that opinion?
It was from the blunt compression of the Lucas machine.
Is that opinion to a reasonable degree of scientific certainty?
Yes.
You indicated earlier that there is a difference between someone dying of hypothermia or complications associated with hypothermia and a body that's already passed away just cooling, correct?
Correct.
Do you have an opinion as to a reasonable degree of medical certainty as to whether Mr. O'Keefe suffered from hypothermia?
I do have an opinion.
What is that opinion?
He did not experience hypothermia.
Did you observe any signs of frostbite?
No.
Did that have any weight concerning your opinion, overall opinion, as to whether or not Mr. O'Keefe died with complications associated with hypothermia?
Well, if someone dies due to exposure to low temperatures, you expect to see not only the Wisniewski's ulcers, but you expect to see some frostbite changes in the extremities.
Based on your overall review of the medical records associated with Mr. O'Keefe, were you able to reach an opinion and conclusion as to the cause of death of Mr. O'Keefe?
Yes.
What is that opinion?
He died of brain injuries and skull fractures due to blunt force trauma of the head.
Do you hold that opinion for Mr. O'Keefe's cause of death to a reasonable degree of medical certainty?
Yes.
I want to shift gears for a minute, Dr. Laposata, and talk about patterned injuries elsewhere on Mr. O'Keefe's body.
Here we go.
You've obviously talked about your training and experience as it relates to recognition of patterned wounds, correct?
Correct.
That's something that you were trained in when you were training, correct?
Yes, it's very basic to the discipline of forensic pathology.
And have you also trained others during the course of your 40-year career on the issue of wound pattern recognition?
Yes.
You've taught courses and given lectures, is that right?
Yes, I have.
I'd like to show you Exhibit 167 with the court's permission.
Okay.
Do you recognize what's depicted in this photograph?
Yes.
How do you recognize it?
Is a photograph of the right arm of Mr. O'Keefe.
Did you review and consider this photograph and others in coming or forming your opinions, coming to your conclusions and opinions in this case?
Yes.
In order to come to your ultimate opinion and conclusion, or opinions and conclusions in this case, is it important to take all of the injuries that a decedent may have suffered into account rather than one or two piecemeal?
Now you have to look at the whole picture to understand what happened to the body.
Why is that? What's the importance of that? It may be obvious, but explain that for the jurors, please.
Well, when you're looking at changes and injuries to the body and trying to understand what happened to the body, there are different patterns of injuries on different parts of the body. And by trying to separate those and understand what patterns were caused by certain things, then you're able to put together a sequence of events that happened to the body prior to death.
What role do photographs play in a forensic medical examiner reviewing the medical evidence and coming to opinions and conclusions? How important are photographs?
Oh, those are huge. It's standard practice to always document at the postmortem examination important findings with photography.
Were the photos in Mr. O'Keefe's case useful in coming to opinions and conclusions concerning his injuries altogether?
Yes.
What about the injuries to his right arm?
Yes, those photographs are very important to understand those injuries.
Do you believe that there is a patterned injury on Mr. O'Keefe's right arm?
Yes, there is a pattern injury there.
Have you ever seen, in your experience, either being taught or teaching, patterned injuries as they relate to animal wounds, generally?
Oh, absolutely. Very common.
Do animal wounds include both claws and teeth, dentin?
Yes.
So bite marks and claw marks might be two different types of patterned wounds that you may see in your evaluation, just in general?
Correct, because when an animal approaches the body, there may be damage from the claws and also from the mouth.
Do you expect to see punctate wounds as well as linear abrasions?
Yes.
Do you expect to see certain bite patterns as well?
Yes.
You see those on Tom's arm?
What types of injuries, let's talk about animals in general, what types of injuries do animals produce on the skin of human beings?
Well, animals can produce, if you're talking about, mammals, they can produce injuries from their claws, where you get parallel scrapes of the skin from the claws applied to the skin, or you can see a pattern from the jaw configuration of the animal. And most animals that attack or get in contact with a body have canines, so there's two canines on either side that make paired marks, and that would be called a pattern injury. So it makes parallel sort of gouges, and as the canines move in a horizontal pattern or a vertical pattern, the space between them can change. The other thing you see in an animal bite is you see not only the canines that come out, but depending on how the jaw is applied to the body, you can have little dot-like imprints in sort of a U-shaped pattern, which are from the incisors, the little incisors of the animal. So you look for punctures, you look for paired gouges, which would be the canines, and then you look for arced patterns of little dots, which can be the application of the incisors of an animal bite.
What is an incised wound?
An incised wound is a wound due to cutting from a sharp object.
Would you expect to see incised wounds from an animal bite or claw marks?
No, they don't cause, they're not like knife wounds. They cause more of a scraping injury.
Do you see the injuries that you're looking at in Exhibit 167, are these more consistent with incised wounds or the scraping abrasions that you just talked about?
Sustained.
Were you able to determine from your review of the medical records whether the injuries that you see on Mr. O'Keefe's right arm were pre-mortem or post-mortem?
They were, oh yes, I can determine that. They were inflicted prior to death.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm is consistent with an animal bite or claw marks?
Yes, it is, very much.
Thank you. You can take that down. May I have just a moment, Your Honor? Actually, Your Honor, may we approach very briefly?
Okay.
Imagine a forensic pathologist doesn't get to say this photograph, the difference between an incised wound or a scrape, a very fundamental category of injury type. And the forensic pathologist doesn't get to look at the photo and give us this very basic information about, is this a scrape or a cut? Why would that matter here? Well, because a taillight's going to cut, isn't it? That's the whole theory, the sharp pieces of taillight cut him. So it's sort of important that these are not cutting wounds, isn't it? Also extremely basic. Imagine a forensic pathologist can't testify to that. It's certainly not beyond the scope of her expertise, so why is she not being allowed to testify to it? Must be highly damaging to the Commonwealth. It's the only reason. There's no legal reason. There's no reason based on her experience or qualifications. Imagine that fundamental. Is this a cut or an abrasion? Doesn't get to say.
May I inquire?
Yes.
You indicated that, in your opinion, the wounds to Mr. O'Keefe's arms were pre-mortem, not post-mortem. His right arm, I should say, were pre-mortem, not post-mortem, correct?
Correct.
What's the basis for that opinion?
Well, a forensic pathologist has to be able to differentiate changes that happen to the body while the person is alive versus things that happen after the person is dead. For instance, there is something called post-mortem predation, where if the body is out in the woods and dead, then wolves and such can come and make, quote, injuries to the body. But we're able to tell from our training and experience that those were made after death. The usual way we tell is that when it's made during life, the blood vessels that are damaged, the heart's pumping blood through, so you can see a reddish color and maybe some blood around it. Whereas if the body is damaged after death, the changes to that body and those, quote, injuries look more yellowish and kind of brown because the blood is not flowing. So that's how you can tell if something done to the body is while the body was alive or whether it was done after death.
Do you have an opinion to a reasonable degree of medical certainty that the wounds on Mr. O'Keefe's right arm were pre-mortem?
Yes, they were done while he was alive and bleeding.
You talked about death investigations. As a matter of fact, you mentioned something about what a forensic pathologist's role is in a death investigation to potentially send investigators back out to answer certain questions, correct?
Yes.
Did you see any evidence in the medical records or the medical examiner's complete records that any effort was made to send investigators to the location to see if there were any animals at the location at or around the time of John O'Keefe's death?
Sustained.
Do you believe it's important? Well, let me ask it a different way. Would following up with investigators be an important part of any forensic pathology investigation?
No, absolutely. You're working as a team to figure out what happened to the body.
Thank you. We talked about the theme and theory of differential diagnosis, correct?
Yes.
How does engaging in the process of differential diagnoses avoid bias in an investigation?
By after you have your findings and you sit back and think, well, how many ways could I get this finding? And so bias sometimes means, oh, I think it's this, and then you just stop. So that's a sort of a bias where you make a decision too quickly and you don't then stop to consider what other things could cause this same finding. So you have to consider not only what immediately comes to mind, but then you think, how else could we get this pattern of injuries?
Did you engage in a differential diagnosis as it relates to this case?
Yes.
Did you consider whether the injuries could have been caused by a motor vehicle accident?
I did consider that.
Did you consider whether Mr. O'Keefe's right arm injuries specifically could have been caused by being hit by a motor vehicle?
Yes, I did think about that.
Were you able to rule that out?
Absolutely. Not.
So the objection sustained, jurors strike that answer.
Tell me about, well, let me ask it this way. Did you come to an opinion or conclusion as to whether or not Mr. O'Keefe's injuries as a whole were produced by a motor vehicle pedestrian incident?
Sustained.
We already knew.
You indicated that you've done thousands of autopsies yourself, correct?
Yes,
You've supervised many times more than that.
correct.
How many of those autopsies that you've performed or supervised have involved motor vehicle incidents?
Now, hundreds.
How many of those hundreds have involved motor vehicle pedestrian incidents?
Almost as many.
Have you performed autopsies specifically on individuals known to be hit by vehicles?
Yes,
Have you performed autopsies on individuals believed to be hit by vehicles?
yes,
Have you engaged in differential diagnosis and inferential thinking in terms of developing an opinion or conclusion to a medical certainty about whether or not the injuries that you see on a decedent are consistent or inconsistent with a motor vehicle pedestrian incident?
yes, that's part of what we figure out as a forensic pathologist.
Did you do that in this case?
Yes, I.
Sustained.
Let the jury see it, Alan. You already know she's
What are
not
some
going
of
to
the
let you go
injuries
there.
that you
Let
would
the jury
expect
see.
generally to exist if a pedestrian is hit by a motor vehicle at speed, not 1-2 miles an hour, let's say 20 plus miles an hour?
Yes, one of the things you see is a pedestrian is, standing upright and is impacted by this blunt object of a automobile or a van or a SUV. And what you see first most is the tissue is crushed where the projections of the vehicle impact the tissue. And when you crush the tissue, that gives you a bruise. So that's the first part of the pattern of impact. It crushes the tissue, it gives you a bruise because it breaks the blood vessels underneath the skin. And then depending on how much more force is applied, the skin can break.
So I'm going to strike that. Next question, Mr. Jackson.
In addition to bruising, what else might you expect to find in an individual who's been struck by a vehicle at speed?
So let's come over to Sidebar.
She's not going to allow any more of this. She's not going to allow. Hank's figured out because she already ruled on this with the qualifications, right? She said she's not qualified to get to testify about any of this. So that's why Mr. Jackson is going through now her qualifications. Let the jury freaking see exactly how qualified this lady is to talk about these things that other witnesses have already talked about. Squirty Bello has already talked about this. Okay, she already talked about the expected injuries that you would see from a pedestrian motor vehicle collision. So let the jury see. If you're going to cut me off anyway, I'm going to make sure they see how freaking unsubstantiated that is, how unwarranted it is, and how it doesn't make any sense, and how there's no reason that her opinion should be kept from them. Go ahead and let them see. She's eminently qualified to testify about what happens during a motor vehicle pedestrian incident, because she's seen it and autopsied it hundreds of times. Let the jury see you're not being allowed to put forward information that they're probably going to find helpful and useful. Pretty important to know if John O'Keefe was hit by a car. Remember the previously we had a whole argument about how Welcher couldn't say that because it goes to the ultimate issue. That was Mr. Alessi's argument, and Bev's like, nah, no, it doesn't. It doesn't. That's not the problem. And now here's the Commonwealth turning right around and arguing like they did in their motion. Turning right around and arguing. They can't say it's inconsistent with an accident. That's an opinion on the ultimate issue. She already said it's not, but they don't care because now we're talking about a different issue, and now we're talking about the Commonwealth wanting it to be a certain way. So we certainly expect the Commonwealth's standards to be flexible to the extent they have any at all, right? They want to do it when they want to do it, and they want the defense to not be able to do it, and they don't really care what the reason why is. Now, of course, the judge is supposed to care about the reason why. Literally why she's here. She's here to know the rules and enforce the rules and evaluate if this is consistent with the rules or not. But why do I have a suspicion? Rules don't matter. Suddenly it's going to be a ultimate issue. Suddenly it's going to be an ultimate issue problem, because that's how the Commonwealth wants it right now. The same issue with Judd Welcher, they didn't think it was a problem then, but they're going to have a problem with it now. And why do I suspect? She's just going to go right along with it. This isn't even a double standard. This is just no standard. This is just no standard. It's not a standard at all if you don't apply it full size. Back to l'état, c'est moi. I say you can't do it. Why? Because I said so.
May I inquire?
Yes.
I forgot where I left off, so I'm just going to pick up.
Okay.
As best my memory can serve me. It has been suggested that Mr. O'Keefe's right arm, Doctor, was injured by contact with the right rear taillight of Miss Reed's 2021 Lexus LX570.
Objection.
No, I'm allowing that in.
Thank you. As Mr. O'Keefe, it was struck as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think about.
So,
Oh, I'm sorry.
yes, I'm going to strike that question and answer.
Let me ask it a different way. Let me ask you a different question. Do Mr. O'Keefe's pattern injuries on his right arm, do they correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that, and let's see you at sidebar.
She already said that. What's the problem? Now she only gets to say it one time. She doesn't get to emphasize. Obviously, they weren't caused by a taillight because they were caused by a dog. This is just nuts. This is just nuts. This is like You know what I'm getting, like the visual of this defense case, the visual that I have associated with all of it. Have you guys seen those pictures of the climbers up on Mount Everest, and they reach what's called the Hillary Step, and it's like the last big climb. You have to go like almost straight up this cliff and get over the top, and then it's just a free, climb up to get to the summit. So it's like the last big climb. And because of that, it's where people get really backed up. Like, you're really tired by now. You can only go one at a time. You can't go side by side. You maybe have been using, supplemental oxygen, and that's getting low. You've been in the death zone for probably like a couple days now. So all of your energy is low. You just get backed up. And it's just this major obstruction to try to get to the top of Mount Everest, right there at the Hillary Step. That's, for some reason, the visual I have associated with the defense trying to put their case on. Just trying to put their case on. Not really that complicated. Not real clear why there should be this massive cliff that they have to climb right at the very end. Not real clear why they should have to keep getting booted to the back of the line and not be able to make any progress up that cliff. Really no idea why. She already said pattern injuries from an animal. So why are we striking that? Because she said it a second time, and your ruling was she gets to say that and only that. And now apparently, I guess she only gets to say it one time. How many times did Welcher say this is from the plastic? And let's talk about all the ways in which this is from the plastic. She gets to say it's not plastic. Why? Well, number one, because it's from a dog. She doesn't get to say that. This is just bizarro world that we're in right now. I got to tell you, I don't usually have an awful lot of faith that the jury can see behind the curtain to what's going on and kind of have that meta level perspective on what they're allowed to hear and not. The jurors tend to look up to the judge, tend to defer to the judge, tend to assume the judge is the referee, just there to call the balls and strikes. So you just start from the default assumption that the judge is right and everybody else is wrong. It's very, very hard to overcome that because jurors just don't have the experience. They don't have the knowledge to be able to look at a situation and get a sense that these judges' rulings are not right. The reason why they don't put lawyers on a jury most of the time, because that's why you would have that knowledge. You can sit there and know if this is a bad ruling or not. That's not something the parties want to have on the jury. But I do have to wonder, so obvious. This is helpful. He's already said it. Why do they have to fight tooth and nail to talk about what caused John's injuries with the forensic pathologist?
May I, Your Honor?
Yes.
In your report, Doctor, you indicated that Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. Do you recall putting that in your report?
Yes, I wrote that.
Do you stand by that?
Yes, that's my conclusion.
And you also wrote his arm had no tissue bruising from impact injury. Do you remember writing that?
Yes,
Do you stand by that?
I do.
You also wrote, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. Do you remember writing that?
I did.
And do you stand by that?
I do.
You also wrote that you noted Mr. O'Keefe had no bruising on his arms or torso. Is that right?
Correct.
And you also wrote, in particular, Mr. O'Keefe did not have bruises on his legs, correct?
Yes, correct.
And you indicated that that was shown by dissection of the leg tissue and muscle at autopsy. Is that right?
Yes, there was a special leg dissection done to look for bumper impacts.
Okay. You reviewed the entirety of the medical records associated with the autopsy,
Yes,
including photographs?
taken to the hospital, yes.
Okay. And autopsy photographs?
Yes,
And other data and documentation, correct?
yes.
Are x-rays an important part of an autopsy generally?
Oh, yes, usually there are x-rays taken of the body prior to the examination.
What do x-rays show? Why are those important?
They're important because they show foreign material in the body, like a bullet. They also image the skeleton, so we can look for fractures of the bones.
This is an aside, but I thought they didn't usually x-ray gunshot victims because of the presence of the foreign body. Vaguely remember reading that in a case once.
I may have just one.
Okay.
Oh, am I thinking of an MRI? You don't do an MRI because of the foreign. I just had that mixed up, you guys. I trust the chat with the specialized information. Thanks, guys, for setting me straight.
Yes.
We're going to approach because we've got a large looking exhibit. Oh, wonder how the jury is doing. Is somebody in the courtroom today? Sue has been in the courtroom all week. I've been watching her when I can for reports on what the jury is doing. Mentioned before, I like how she does it because she's not purporting to be a mind reader or, you know, what they're thinking or what they're feeling or anything like that. She doesn't do anything like that. She just notices, are we paying attention? Are we taking notes? What are we looking at? Physical behavior that can be observed. Lots of notes about the injury details. All jurors seem attentive. All jurors have some sort of reaction when Laposata says the injury was caused by a ridge. Jurors look back and forth at each other when the judge strikes testimony. All react when Laposata says she observed no area at the lawn that could have caused the injury, including grass. All jurors have heightened attention. Jurors react by writing and or looking up when Laposata testifies that John O'Keefe did not have hypothermia. Looking at the photos, jurors are attentive, many taking notes. Many jurors sip water during a sidebar. One takes a mint or a candy.
Recess.
Taking morning recess. So I've been reading from Sue O'Connell. Sue NBC Boston is her handle over on X. You're going to come back without the jury to chit chat about that large exhibit they just walked up with?
may be seated.
Dr. Laposata, you can step out, okay? All right, I did receive another motion this morning for a curative instruction. I'm not going to even consider this today. We can consider this at the charge conference. So that's where we're at with that. All right, work it out. If you can't work it out, let me know. I'll come out before the jury.
All rise to the court,
Work
please.
it out. We don't have time for this. We don't have time for this. That prejudice to the jury that Mr. Brennan caused, we don't have time for this. We're not even going to think about this right now. We'll just wait till we're looking for looking at all the jury instructions. That could be several days. That could be long after the prejudice caused by that stunt that Mr. Brennan pulled has had time to become cemented, become fixed. It's gone uncorrected all this time. Your problem with the exhibit, work it out. Don't make it my problem. Oh, this right there. Such a common attitude from judges. You guys work it out. Don't bother me with it. And then you get a pattern of rulings going a particular way. Kind of tells you who the judge thinks is at fault for making her have to decide all of these things. Who's at fault for not working it out. Kind of get a sense that maybe someone's got a little attitude about who should be bending the knee to the state, to the prosecutor. Because remember, guys, they're untouchable. They are your betters. You have no recourse against them. They have the immunity God-given, same as the king has. Absolute immunity. You can't be harmed by the king. If the king harms you, it's a right thing. It's because you deserved it. You don't have any recourse against the king. And the king is the state. I just want to talk a little bit more about that. We were just starting to get into the good stuff with the immunity. And here we go. We have a recess. Why don't we just go ahead and take a look at that again? Here we are. We're back. We're back. Is this big enough? I'm not sure I can make it any bigger. Oh yeah, a little bit bigger. We were just finishing with who has absolute immunity, can't be prosecuted for anything, or can't be civilly sued. Pardon me. Can't be civilly sued by you because of harm that they perpetrate on you, depriving you of their rights. The president, judges, prosecutors, witnesses, officials performing quasi-judicial functions, and legislatures, all of them. You don't get to sue them. Why? Because they're your betters in the government. You don't get to sue them because they are your betters in the government. Oh, believe me, they've got all kinds of great judicially created reasons for why it's a great idea that you can't sue judges. Judges have thought up some really good reasons for why you shouldn't be able to sue judges and their buddies, of course. They're fellow folks in government. They look at the function. They look at what are you doing, not necessarily what your title is. They look at, are you carrying out something that's a traditional function that a judge does, in which case it doesn't matter if you're the judge or if you're some inferior employee of the judge. If you're performing the judicial task, you're going to be absolutely immune. So guess what that means in terms of who it applies to? Judicial immunity. It applies to judicial acts, not to administrative, legislative, or executive functions that judges may on occasion be assigned by law to perform. What this means is that, for example, if the judge as an employer violates employee rights laws, anti-discrimination laws, labor laws, things like that, that's outside of the judicial function. That's not the judge being a judge. That's the judge being a boss. And so in those types of circumstances, the judge can potentially be sued. They're not necessarily immune, but anything they're doing as a judge, absolute immunity. So who gets that? Well, obviously the judge gets that immunity. It insulates judges from charges of erroneous acts or irregular action. They're not liable for getting it wrong. They can get it wrong. They can get it wrong consistently, universally. They can never be right. And you're never going to have a civil cause of action to go and get your recourse for your rights having been violated, because the judge has absolute immunity. Guess what? Even if the judge is erroneously, even if the judge is looking at a statute about, whether I have jurisdiction in this case, this is very broad, by the way. It just means, does a court generally have authority to hear this type of issue? Does the court generally have authority to hear murder cases? If so, anything the judge does in your murder case, they're absolutely immune. They're absolutely immune. And even if they don't understand if they have jurisdiction over your murder case and they're actually wrong because maybe another state has jurisdiction over your murder case, well, that's going to count too, because it's a judicial function to interpret the law. So even if they don't actually have jurisdiction, but they think they do, that's enough. That's enough. So here we have examples of the administrative decisions, things like unconstitutional conduct regarding the discharge, demotion, and treatment of employees. One of the only things they can be sued for, which is great when we have, for example, a judge over in Asotin County, Washington, in the last few years, assaulting the clerks in a gender-based way. If you get my drift, it's good to know you can actually have some recourse against that judge. That's about what it takes. About what it takes. Magistrate judges, administrative hearing officers. Guess who else gets all of this protection as the result of performing judicial functions? We're going to go through the list now. Administrative agency hearing officers, court mediators, court-appointed psychiatrists. If a psychiatrist comes in to do an independent medical examination for the court, guess what? They're the judge now. Oh, hey, court employees and courtroom officials, court employees involved in the jury selection process may be entitled to absolute immunity. Court clerks. Court clerks have absolute quasi-judicial immunity from damages for civil rights violations when they are performing tasks that are an integral part of the judicial process. Court clerks are immune. Parole board officials when they're being discretionary. Probation officers when they're being discretionary. They all get absolute immunity. They all get absolute immunity. Prosecutors. Prosecutors who are being prosecutors get absolute immunity. Michael Morrissey, Hank Brennan want to make this as clear and explicit as possible. They can violate the law here in the courtroom as prosecutors, and they are immune from liability. So think about that when you reflect on the fact that Hank Brennan is the hand-picked choice of special prosecutor by Michael Morrissey. Michael Morrissey deliberately picked this guy, and he is deliberately keeping this guy in this position. This guy's performance is exactly what Michael Morrissey wanted. They're all immune for it. They're all immune. Guess what? Appointing a special prosecutor is something that prosecutors are immune from. It's an act they're immune to. So if it's advocacy, if it's part of your job as an advocate in the court, it's prosecutorial, you're absolutely immune. If you step out of that shoe a little bit and you start getting involved in the investigation, investigative acts, now you're more like a cop. Now you only get qualified immunity. Okay, you get qualified immunity, meaning there are some circumstances where you might be able to be sued as a result of investigative activity. But here's some activities that you're immune from: seeking a grand jury indictment, deciding when to prosecute, what witnesses to call. Oh, hey, guess what? Making statements that are alleged misrepresentations and mischaracterizations during hearings, during discovery, and in court papers, and conferring with witnesses and allegedly inducing them to testify falsely. You got that? Could that be clearer? Cases, precedent, court saying prosecutors lying, prosecutors deliberately creating false testimony, false evidence, presenting it to a jury. It's intimately connected with the judicial phase of the criminal process. They're not liable for it. Therefore, no skin in the game. Absolutely no skin in the game of maintaining an honest court system. They can lie in court, guys. They can lie in court. They can present false testimony, and they can't be sued for it. They're absolutely immune. Preparing for trial, appearing at a search warrant proceeding, declining, stealing your property. Okay? They came in and seized your property under a warrant and they won't give it back. Can't sue them. Can't sue them. Too bad, so sad. Don't you know that's the king over there? That's the king over there. Brady violations. Oh, here it is. Selecting a special prosecutor. No liability for that. Doesn't matter who you pick and how bad they are. Can't be sued for it. Submitting motion for a bench warrant, parole recommendations, preparing warrants, issuing subpoenas, writing appellate briefs, and any comments they make during litigation. Can't be sued for that. So it's only things that are like investigative, that are not prosecutorial. It's more like cop stuff. Then they have qualified immunity. So some of those things, if you're advising the police officers, if you're doing investigative types of activities, sometimes pretrial comments, making statements to the public. Now that's an interesting little sideline. That's not your conventional advocacy, so that's more like what a cop does. Directing them to get a search warrant, not necessarily writing it. If the cops come to you and they want it and your job is just to present what they have to the court, that's probably going to be prosecutorial. But if you're telling them you should go get a search warrant, much more likely to be law enforcement. Acquiring false statements from witnesses for use in prosecution. Qualified immunity for that. Oh, by the way, yeah, all the supervisors also immune. So that guy commits a crime, you're his supervisor, don't matter, you're both immune. No skin in the game. No skin in the game, guys. So this, I think, is really important to understand. We've gone through the long laundry list of who is entitled to these types of protections. Guess what? CPS workers who come and take your kids, you can't sue them for that. CPS workers who recommend that your rights to your children be terminated, be taken away on the basis of you being a bad parent. They can be malicious. They can lie. They can make up stuff. And guess what? They can't be sued for it. They have absolute immunity when they make discretionary, quasi-prosecutorial decisions to institute court dependency proceedings to take custody away from children. CPS has immunity. Of course, the president has immunity. The legislature has immunity. Witnesses Witnesses who testify in court, immune from civil suit. Can't sue them for coming in and lying, perjuring themselves. They can commit a crime. Can't sue them for it. Absolute immunity. But guess who doesn't get it? Guess who doesn't get it, guys? Your public defender. Your public defender. No immunity whatsoever. Almost like it's by design, isn't it? That the people who want to railroad you have no skin in the game, no incentive to do anything different, and the people who might stand in their way, they can be sued. They can be sued civilly. Starting to look like this is by design, guys. This is not an accident. It didn't just happen to be the case. The prosecutors, courts, judges, the system as a whole has a massive systemic advantage over poor little peon you and your lawyer sitting there at your defense table. It's purposeful. It's purposeful. They can abuse the hell out of you, and you have no right to do anything about it. So I just wanted to give you guys that little bit of context in light of what we've been seeing in this court to help put it in perspective. When I say, people ask me, Andrea, what's my recourse? What are the options? I wanted you to see how this is baked in. It is baked in for it to work like this, for these people to be able to behave like this. And so it's not an accident. Guys, it's not an accident. It is l'état c'est moi. It is writ large. We have simply taken the tyranny that we protested against from England, that the king had that absolute power. And instead, we just went and gave it to a few tens of thousands of other people in our government. Instead of just having that one guy, that one king, we went ahead and just gave all that authority to the entire apparatus of the state. And we're the land of the free and the home of the brave. We just created a massive bureaucracy of tyrants to replace the one guy over in England that we fled from. Guys, it's by design. It's by design. I'm going to take a minute to go through some of your guys' comments. See how y'all have been feeling this morning. Let's take a look. Carolyn Smith, evidence prof has links to citations from Massachusetts that absolutely say Laposata should be able to talk about dog bites. I did see that. Somebody mentioned that yesterday. Evidence prof is the handle on X. But his name is Colin Miller, and he's a professor at oh gosh, was it USC? No, I can't remember. He's a professor in a law school somewhere. And so he did a long thread. In fact, maybe I can find it. I don't know. It's going to take me a minute, so I don't want to spend too much time on it, but maybe I'll come back to it if I find it while court's in session today. But he's got some Massachusetts sites about, the forensic pathologist being the person who opines about these kinds of things. His view that it was a pretty obvious error. To me, that seems like a given. The issue is always just whether it's going to be harmful or harmless. That's where the battles on appeal are really fought. You can have the best, easiest slam dunk of an error argument. Of course they got it wrong, but if you can't point to a negative consequence as the result from it, you're not going to win the appeal. You're not going to win the appeal. So he's got very good arguments on the legal side of that and how that's clearly legal error. Doesn't mean it's going to get reversed on appeal, which is unfortunate, but That's the system we have, guys. Almost like it's on purpose. Almost like it's on purpose for us to have little to no power against these tyrants that we've put in bureaucratic positions and given power and just taken away any kind of skin in the game that they might have to do things fairly. Only thing that's out there besides political recourse, you and me being able to sue, is criminal prosecution. That's the only other option there is. Well, where does that get us? How long did the FBI spend over here in Norfolk County? How many charges have we seen? Yeah, exactly. Exactly. How far does that get us? Jason McClellan, what would you emphasize in your closing as defense counsel? What should the Commonwealth focus on, and are you prepared to predict a verdict? So I think that the main emphasis here has really got to be the burden of proof and, laying that squarely at the feet of the Commonwealth. Tie it to the instructions is a very good way to do that. But that's ultimately what this case is about. The Commonwealth has a burden, has an obligation to prove that Karen Read hit John O'Keefe with a car. And their own expert says, we just don't have the data to know what happened. We just don't have the data to know what happened. Oh, for all these other reasons, these non-scientific reasons, we're gonna say it is. Why? Because we've put ourselves in the shoes of the jury to decide, well, there's DNA on the taillight and there's things that were said and so on and so forth. But you, the jury, get to independently make that decision for yourself, and you get to consider things like the testimony of the forensic pathologists who have emphasized universally, by the way, in complete agreement. Not a single medical practitioner has gotten up here on the stand and said, these are consistent with a motor vehicle collision. Even the Commonwealth's own medical examiner has said, didn't see any of the injuries that you look for. That's what I'm going to focus on, is burden of proof. The fact that the Commonwealth hasn't met it. What should the Commonwealth focus on? They're going to focus on I hit him, because that's all they have. This is I hit him 2.0. It's the same trial. It's the same trial that Lally put on. We just gave it a bow tie instead of a Windsor knot, we just painted it up a little bit differently. But it's the same case. That's what they're going to focus on, because that's all they have. They're going to have to try to focus on like Jen McCabe being credible. That's all they have. The tail light, they'll focus on the tail light. You're going to have to, I don't really get to say, prosecutors got to be very careful in closing. They don't get to say things like, you have to find that the taillight would be planted in order to, find Karen not guilty. Oh, no. No. You don't get to say stuff like that, because the jury does not have to find that. All the jury has to conclude is that we have a reasonable doubt as to your version of events. They don't have to find anything to the contrary of the Commonwealth's assertions. They just have to doubt the Commonwealth's assertions. That's it. So I'm going to be watching very, very closely during closing argument, because I just suspect the Commonwealth isn't going to respect that. They're going to make arguments that are objectionable, that are burden shifting, that are incorrect statements of the law, and that are misconduct. It's the pattern that we've seen repeatedly already. So why would that suddenly stop because we're in closing? It's going to ratchet up, if anything, because it's your last chance. You have nothing else to lose. The judge isn't holding you accountable anyway. So I think they're going to focus on I hit him, and the tail light. Am I prepared to predict a verdict? If we get a verdict, I predict not guilty, but I'm still leaning in. I think it's more probable that we won't. I think it's more probable that we get another hung jury. There's just been too much hamstringing of the defense, inability to be able to present what they need to. There's too much polarization in this community already, and too much of a risk that somebody can end up on the jury. It's already got, you know, I hate Turtle Boy. I hate Karen. She's awful. I don't like her face. And we'll take any justification to convict. It's kind of common to get jurors like that anyway. I think we talked about that at the beginning. It's sometimes you get a whole panel for full of jurors that are just all the kind of people that love to judge. They just love to judge other people and look down on them. And that's a terrible pool for me as a defense lawyer. I want people that are open, people that are forgiving, people that are flexible, people that are willing to consider perspectives outside of their own. I don't want a room full of people that like to look down on others and judge others. Those aren't good jurors for me, but sometimes that's what you get on your panel. So pretty good chance in my mind out of 18 people selected, you know, 1 or 2 of them are real super judgy types. They love it. They love to condemn others. You know, we all know people like that. You know, it's like it makes you feel better about yourself to put the other people down kind of thing. We all know people like that. So they love to cast judgment on others. Risk of those people being on the jury. And if those people are on the jury, then I think there's a big risk that it's going to hang. CNO, if somehow convicted, immediate appeal. Yes. Once, if she is convicted, once she is, that's when your right to appeal starts. It actually is technically after you're sentenced. That's when the whole conviction is like final. And you have consequences as the result of it. So it's once she's sentenced, she has the right to appeal at that point. So yes, that would definitely happen. No question about it. Mara W, missed opportunity to call it the Big Beautiful Bill of Rights. I did call it the Big Beautiful Constitution, not just the Big Beautiful Bill of Rights, the whole Constitution, a very big, beautiful document that we have, establishes this tyranny by bureaucrat that we live under. Almost like it's by design. Mispronounced name. The state tells you you have the right to remain silent, not you have the right to be heard. In my opinion, that sums up a lot of the problems. That's a good observation, and we really see it in this court, don't we? I'll hear you if I feel like it, but I don't have to. It's like it's a favor that she's doing you to entertain your argument. Technically, there is a right to be heard. It's just it's not explicit in the Constitution. It adheres in the due process clauses of the 5th and the 14th Amendments. A meaningful opportunity to be heard is fundamental to due process. And so that means at a meaningful time and in a meaningful way. You do actually have the right to be heard. But they don't put that front and center. They don't put that front and center. And then also, should point this out, because it's due process protection, that means it's flexible. It depends on what the government is trying to do to you. So the worse damage the government is trying to inflict on you, the greater your rights, the more your right to be heard is going to count. But if it's more minimal, well, then you might not have that right, or you might not have that right away. You might just have that right later on. That's why you can have things like, temporary ex parte restraining orders, where somebody comes into the court and makes a bunch of wild accusations that aren't true at all, but they can get an order based on that because you haven't had an opportunity to be heard yet. And then that order can be in place that can limit your rights, sometimes quite significantly. That hearing can be pushed down the road. Don't necessarily have a meaningful opportunity to be heard before your rights can be taken away with something like that. Yeah, I think this sense that whether and how we, your government betters, will hear you is very much part of the problem here, because it is a very arrogant and entitled position, isn't it? It makes you sound, I don't know, rather like you're putting on the airs of some kind of monarch. Some kind of absolute monarch who may or may not deign to hear from we the people. Dana Kimball, go to 7:16:37 from yesterday's live and watch for 1 minute. Is Brennan communicating with Bev through finger taps? We can go look. If this is about the clip where Bev, had her little hand over the mouth and was like saying something and covering it up, I did see that. Looks like she's calling counsel over to Sidebar, so not having anything yet, but we're getting close to court coming back. I did see the clip of her, talking and covering her mouth. To me, it looked like she was just like communicating with one of the people that's sitting right near her, the clerk, the court reporter, somebody like that. I didn't see anything that made it look loud and clear like, oh, we're having communication with the prosecutor at this point. A lot of that is just an issue with the perspective that we have with the courtroom. We have limited perspective. We're only seeing one people at a time. We don't see what they're seeing. So, Jason McClellan, Judge Bev's bias against the defense out of 10. I thought she was tapping Morse code messages to Brennan. I don't think she probably was, but we shouldn't be in a position where we have to be like, can I rule that out? It shouldn't even be like ruled in as it's possible. It shouldn't even be like that. But that's where we're at because of her behavior here. They've just completely lost the trust of those of us who are trying to watch and trying to rely on this process. Bias against the defense out of 10. I give it a 9. The only reason I'm not giving her a Judge Goal 10 is because she hasn't actually thrown off the lawyers in the case. Sure, she'd like to, but even Judge Goal got put in her place over that one by the Indiana Supreme Court. No, you don't get to do that. No, you don't have a basis for it. But then, went ahead and let the prosecutor go after their livelihoods while she's at it. Doesn't pay them for their work. Yeah. No, I give Judge Bev a 9. She's bad. Her bias is bad. But it could be worse. It's hard to imagine. But I do think it could be worse. Aaron Kerr, do you think Bev knows she's lost control of her courtroom? On some level, she absolutely knows. The issue is she doesn't care. If she cared, she would do something about it. She doesn't care. So really, whether she knows or not is kind of immaterial. If she knew, would she even do anything about it? It's obvious she's lost control of the courtroom. Look how they're behaving. Look how Brennan is behaving right in front of her. No consequences. He's interrupting the other side, addressing him directly, not allowed to or supposed to do that. It doesn't matter. But definitely she knows, at least on some level.
Gentlemen, may I approach?
Yes.
On the court's bench, there's an item that I'd like to shoot back.
Miss, we need that marked for identification.
I need all three of them marked for identification.
Okay, and we'll do that afterwards. Just please go ahead.
You see any x-rays?
I did.
What were the x-rays of?
The x-rays were taken of Mr. O'Keefe at the medical examiner's office, and they were x-rays of his chest, his arms, and his legs.
So they did x-ray all of it and dissect it.
Hand, forearm, arm.
Yes, they were included in the x-rays.
Have you seen x-rays before?
Oh, many times.
How many times?
Thousands, probably.
Is part of your job to review x-rays to make
absolutely.
a determination of whether or not they indicate broken bones, fractures, hairline fractures, things of that nature?
Yes, it's part of the medical legal autopsy to study the x-rays of the deceased.
That's done in the ordinary course of being a forensic pathologist, is that right?
Yes.
Are you trained
on how to read x-rays?
Yes.
You have to be a radiologist to read an x-ray as a medical doctor?
No.
Medical doctors do that all the time, correct?
Yes, it's part of general medical training.
And is it also part of specialized training for forensic pathologists?
It falls under the rubric of general radiology that a doctor knows. There are some specialized areas in forensic where you have to understand like decompositional changes that you can see on an x-ray that aren't something that you would see in a clinical setting.
Taking the appendage one item at a time, did you look at Mr. O'Keefe's x-rays of Mr. O'Keefe's right hand?
Yes.
Did you see any defect in the bones of the right hand?
No bony defects, and the tissue was normal.
Did you take a look at the x-ray of Mr. O'Keefe's right arm?
Yes.
Did you notice any defects at all in the bones in the right arm?
No, the bones in the right arm were intact.
No breaks?
Correct, no breaks.
Fractures, hairline fractures?
No.
Did you look at the upper arm x-ray of Mr. O'Keefe?
Yes.
Did you note any defects in the bone structure of Mr. O'Keefe's upper arm?
No, the bones were 100% intact.
No breaks, fractures, hairline fractures?
Correct, none of those.
Was there any indication in your mind, based on your review of those three x-rays, the hand, forearm, the arm, that arm had suffered any kind of bone trauma at all?
Sustained.
Was there any indication, based on your review and your expert opinion, that his arm had been broken, fractured?
No, the bones were intact. No breakage, no fractures.
Thank you.
Okay, thank you.
Whoa.
Examination.
What are we going to abuse her about?
Good afternoon, Dr. Laposata.
6 minutes till the afternoon. Good afternoon.
That's okay. You wrote a report in this case, doctor?
Yes, I did.
Do you think that based on your analysis, was Mr. O'Keefe thrust backwards? Is that what you determined looking at his head injury?
That he was, I didn't understand. You had your hand in front of your
Sure,
mouth.
I'm sorry.
Yeah.
You talked about a head injury that Mr. O'Keefe had, that
Yes.
he suffered from,
Yes.
that caused his death.
Yes.
Was that caused by being thrust backwards?
Yeah, the motion was upwards, down.
Okay. And the way you just showed it could be a fall.
Correct.
Did you have an opinion looking at his wound that he was thrust backwards?
Thrust.
What do you mean thrust?
Yes,
His
thank
body went backwards. There may have been some applied force to it.
I don't know about thrust. I'm asking if you have an opinion. Your words.
We know you don't know about thrust,
about
Hank.
thrust?
We wish your fucking mom didn't know about thrust.
What do you mean thrust?
Did the forensic pathology diagnosis mean Mr. O'Keefe's body was thrust backward?
If you want to say thrust as indicating movement, that it went backwards, then you could say it was thrust.
Okay, may I approach?
Yes.
I'm showing you page 2 of your report, Dr. Laposata.
Yes.
I'm just going to ask you to read it, not out loud, and then I can ask you the question after we take it, but I want to
Yes.
take a look.
Yes.
Are you familiar with that?
Yeah, absolutely.
So, Dr. Laposata, what did you mean when you described that Mr. O'Keefe's body was thrust backward from a standing position?
I mean that he was standing upright and his body had momentum and went down and hit at the back of his head. So when it was thrust backwards.
You cannot tell forensically how much momentum he had, can you?
No, we don't do those analysis.
You can't tell if anything caused that momentum based on the head injury, can you?
What do you mean cause it? It was caused by his body went backwards.
Yes. And so the amount of force causing him to go backwards, that's not something you can determine from the head wound, is it?
No, I can't tell you the amount of force. It was significant because he had the massive skull fractures.
Did you say it would be significant?
Yes, significant force.
In modern medicine, there are a number of different machines that can help us see the brain, like a CAT scan, perhaps?
Sure.
MRIs?
Yes.
Would you agree with modern medicine that the use of MRIs and CAT scans and other tools give a clinician equal, if not better, opportunity to examine the brain as actually cutting it and holding it in your hand?
No, the actual gold standard is the pathology, to be able to have the brain in your hand, look at it with your naked eye. And we have conferences in the hospital where we meet with radiologists and say what we find at autopsy and see if their radiology was correct.
Can CAT scans and MRIs show contusions on the brain?
Well, they might.
Subdermal hemorrhages?
Subdural hemorrhages. Yes, they
Herniations?
can. They can.
I like her correcting him.
Do you have any doubt about the modern medicine and the use of MRIs and CAT scans? Do you think they're inadequate in any way?
Well, I'm not a clinician, so I don't use those to diagnose diseases in living patients.
Dr. Laposata, have you ever had any experience studying the brain in real time, clinically, going and opening somebody's skull and treating the injury before the person dies?
No, I'm not a neurosurgeon.
You don't have any neurological expertise, do you?
I'm not a neurologist. I'm not a neurosurgeon. I'm a forensic pathologist.
Do you have any clinical experience
I love this
at all
woman.
where
No.
there's an acute head injury and you're making an effort to observe it and analyze the injury as it progresses in an attempt to save the person's life?
I don't treat or diagnose living patients.
Never put
I
your finger
understand,
through
but
someone's brain.
As far as your background, have you ever had any experience, clinical experience, showing the progress of an actual brain injury and trying to treat it?
I understand the physiology of what happens to the brain when it is impacted by something, whether it be a bullet, a boulder, a fall. So I know what happens to the body to cause the changes from that trauma. I don't treat people for those injuries.
In observing a brain that's in trauma and making determinations of how long it's viable or whether the person will expire, do you know the process that a neurosurgeon would go through in order to fight to preserve the person or save the person? Do you know the step-by-step process that they would undertake?
To do what?
To try to operate or save somebody from a head injury, from a brain injury.
I'm going to allow it because of
You're going to allow it? It's beyond the
Well,
scope.
it depends on what the brain injury is. If you have head injury and you have bleeding on the brain that's pushing the brain one way or the other, it would be a subdural. Then a neurosurgeon would come in and try to take that blood away so it doesn't compress the brain. So that's something that neurosurgeons do to treat head trauma. They can also put in drains into the ventricle of the brain, and that can relieve pressure in the brain because that brain swelling is a bad thing. So those are some of the things neurosurgeons do to treat brain injuries.
And can they remove part of the skull to relieve pressure?
Oh, yes, they can do that. It's called a craniotomy. They can take out part of the skull if they need to.
So there are a number of different steps that a neurosurgeon can take when someone suffers acute brain trauma to try to save the person, isn't there?
Well, the job of any doctor is to try to save a human life if you treat living patients. So certainly a neurosurgeon would evaluate the patient and decide if there's any treatment needed that could improve the patient.
When you've had cases in the past as a medical examiner where there have been issues regarding brain injury, wouldn't you agree that you have sought outside consultation with people who have a higher degree of specialty in brain injury than you?
Sometimes what we do is when we're examining the brain, we can call in for a conference and have a neuropathologist come in and review the brain with us.
And back when you were a medical examiner, you did that on a number of occasions, didn't you?
Yes, that's routine.
The reason why is because there are different specialties in medicine, and some are different and separate than your specialty, correct?
Of course.
And a neurosurgeon or a brain surgeon, it would be a different specialty than yours.
Yes.
And they're focused on the brain, yes?
A neurosurgeon does brain surgery.
And so, how many times in your career do you think that you've assisted the help of neurosurgeons to take a look at brain study to help you?
I've never needed to speak with a neurosurgeon to look at a brain. Sometimes we call in neuropathologists and we have a forensic neuropathology conference where we look at brains with the interns and residents.
How often would you call a neuropathologist?
Maybe once a month we would have a routine conference.
And again, the neuropathologist, that's dealing with a person's brain after they're already died.
Correct.
So it's not a clinical setting or a clinical experience of actually watching the brain at work and seeing the injury as it progresses.
We don't do neuropathology like that on living people. The person is deceased.
You had an opinion to the jury today, and you said that you believe that Mr. O'Keefe died within 15 minutes?
Yes, I think that process would start within 15 or 20 minutes.
Is that to a reasonable degree of medical certainty, that opinion?
Yes, based on the severity of the injury and the brain swelling.
You're aware that there are numerous level 1 trauma centers around the country that deal with brain injury, right?
Sure.
And the idea is that people suffer all types of brain injury, and if they are given medical attention in a reasonable amount of time, there's a chance they can be saved, yes?
It's possible, but many are so severe that they cause death no matter how fast they can get medical attention.
In fact, every day when people get the right attention or proper attention, they're brought to level 1 trauma centers around this country to try to help them or save them. Isn't that fair to say?
I would hope so.
Do you think?
Sure.
When you looked at Mr. O'Keefe's brain, obviously it's after he already expired, correct?
Obviously, yes.
And so you didn't have any clinical observation of
I
the
love her.
progress of his injury that night, did you?
I was not observing him. I did not observe how he got his injury.
When you gave an estimate or you give an opinion about how long he was alive for, are you aware that there's certain tests that are done by neurosurgeons when people are suffering brain injuries but there's an attempt to save them?
Sure.
Have you ever heard of a Guzman coma score?
Glasgow, you mean?
No, but there's Glasgow, but you've heard of Guzman?
It's called Glasgow coma score.
Have you ever seen the assessment that a level 1 trauma center goes through when they're trying to save somebody with a brain injury?
I'm generally familiar with the emergency procedures to save somebody's life.
Have you ever read any statistical studies attempting to correlate the brain injury with the time somebody would live for?
I'm aware of that, and I see that in my practice of people who have survived brain injuries and die of something else. Then I can look at the brain and understand how the brain can heal or react to injuries.
And many people who suffer coup contre coup will go into a brain surgeon center, and many of them pass after time, don't they?
Now, in every case is
I think he said
different.
60%.
Some might live for an hour,
66%.
hours, weeks, months, or
Most
survive
of them
the
die.
injury.
It
Isn't that fair to say?
it depends on the case.
In this case, you don't have any objective criteria to identify the amount of time Mr. O'Keefe would have lived if he had the appropriate help. Isn't that fair to say?
I don't think it would have been effective because there were massive skull fractures to the base of the skull, and there are cases where the amount of force and energy applied to the head, causing skull fractures, breaking the neurons, causing the brain swelling, despite rapid medical treatment, those people cannot be saved. They can't effectively stop the brain swelling.
Many people can't be saved. Did you know that about 1/3 of them do get saved?
I don't know what you're talking about. 1/3 of everybody has different sorts of injuries. 1/3 of what?
With a clivus fracture, coup contre coup. Are you aware that 1/3 of those patients survive if they get the proper treatment?
It depends on the amount of force.
Okay. Are you aware that a study would show, have you ever read a study by Isaac Wolf on clivus fractures?
No.
Have you read any studies on clivus fractures?
Clivus fractures? Yes, I understand what clivus fractures are. It's a part of the base of the skull.
Okay.
And
And
it
have you,
Oops. Okay, go ahead.
please. Did you want to
No,
say?
you go ahead.
Oh, I'm sorry. Have you read any studies that tell you with the proper treatment, despite these potentially catastrophic injuries, that 1/3 of patients can survive?
No, but that's not the case we have here.
And so in this case, I asked if you had any objective criteria. You don't have any objective criteria about the progress of Mr. O'Keefe's wound that can be a basis for you to conclude that he would have died in 15 minutes. Isn't that fair to say?
No, I understand what happens to the brain when it gets that sort of injury. I understand the time course and the physiology. I've seen hundreds of individuals who've had brain injuries. Some survive for a longer period, some die earlier, and it depends on the amount of force and the amount of brain swelling. And in Mr. O'Keefe's case, we had the massive skull fractures of the base of the brain and immediate swelling and subarachnoid and subdural. So he had a large force applied to his head, which caused the brain swelling and the herniate and the progression of the brain stem down through the foramen magnum that stopped the brain. It was a very forceful impact.
You examined his brain after you looked at photographs. You can't tell us objectively when his brain swell started.
It started immediately after impact.
And you can tell us what the progress of that brain swell was by looking at his post-mortem photos.
By looking at the post-mortem photos and the post-mortem examination, I can tell the degree of force from the extensive skull fractures that were present.
What was the degree of force?
It was medium to large.
Well, that's a wide range. What do you mean? Quantify medium
I'll
to
strike
large,
the comment.
please.
Ask the question, Mr. Brennan.
What does medium to large mean?
Enough to cause a lot of fractures to the skull. He didn't just sit down and lie down.
If he sat down and lied down, he probably wouldn't have fractured his skull, correct?
That's obvious, yes.
Right. And so when you're
I love
telling us
her
you can
attitude
identify
towards
that he
him.
immediately died or died within 15 minutes, I'm asking you for objective criteria. For you to give that opinion, I'm asking you what objective information you have. And so you said that there was a large amount of
Condition,
force,
Hank.
correct?
Sure, but because there were massive skull fractures and there's a lot of energy transmitted to the brain, starts swelling immediately
How do you know this wasn't medium force and not large force?
because of the extensive number of skull fractures.
So are you saying it was medium or large force?
Medium to large.
Okay. How much force is that? Can you quantify it?
No.
What other objective
love her
criteria
attitude.
do you have
She might be my favorite
to
witness ever.
support your opinion that Mr. O'Keefe died within 15 minutes?
My training and experience of seeing thousands of deceased people from head injuries and knowing some of their clinical course when they get immediate medical treatment, they don't survive.
But you would agree many do.
Depends on the case.
And in this case, you didn't have any opportunity to observe the progress of Mr. O'Keefe's injury that night,
You
correct?
didn't have to.
Objection, Your Honor.
I'm going to allow that.
I wasn't there.
You
The body told me what happened to it.
You have no
told
assessment of
her.
the development of his brain injury and how much time it took that night, do you?
I do, from understanding the significant skull fractures and the swelling of the brain and the compression of the brainstem that all happened very rapidly because of the amount of force that caused all those skull fractures on the base of the skull that actually then hemorrhaged into his upper eyelids. That's a large amount of force.
Was gross edema found on his brain?
I think it was swollen, yes.
But was that a finding?
Yes.
Where did you see that finding?
Well, in order to have the herniation of the brainstem, the brain swells.
Where did you see that finding?
I can't answer that. I just know it from understanding, looking at the pathology.
So at the end result, at some point, Mr. O'Keefe had gross edema.
In order to get the brain stem hemorrhages, the only way you get that is because the brain has swelled, and there's no, after injury, tissue swells, and there's no place for the brain to go when it swells except down into the natural hole in the bottom of the skull where the spinal cord goes down. So that's where the pressure goes. So that seeing the brainstem herniation tells you that the brain has swollen a lot.
Undoubtedly, but it doesn't tell you when it began to swell or the progress of that swell, does it?
I don't know what you mean.
You see inevitably because of the swelling, there's the suffocation, but when you see that, you don't know when the swelling began or how quickly it progressed. You can't tell that from an autopsy.
Yes, you can, because of the severity of the skull fractures. I know there was a lot of force, and that force applied causes you to go unconscious, then your brain swells. If there was just like one skull fracture, then that's a little bit different. But this was massive skull fractures on the base of the skull. So there's a lot of force applied. So I know because there's a lot of force applied to cause the skull fractures, that the brain would swell rapidly.
You would be unable to identify the rapidity of the swelling if you don't know the amount of force. Isn't that fair to say?
Well, I do know the amount of force because of the amount of skull fractures.
In what you know is, in your words, medium to large force.
Yes.
You've heard of periorbital ecchymosis,
Yes.
and that's sometimes called raccoon eyes.
Well, periorbital ecchymosis just means bleeding and bruising around the eyes.
And you saw the bruising around Mr. O'Keefe's eyes, didn't you, in the photographs?
Well, it wasn't bruising caused by blunt force trauma to the eye. It was bleeding in the upper eyelid because the plates above the eye and the base of the skull were fractured by the brain hitting it. So then that's a result of basilar skull fractures and not the application of force directly to the eye.
Would you agree it takes a few hours for the bleeding to accumulate in the person's eyes?
No, as soon as you break the skull bones and the heart's pumping, the blood comes out of those injuries. It starts to accumulate right away. It starts within minutes, you can see it.
So you would disagree with the suggestion that it takes at least 1 to 2 hours for that bleeding to occur in the eyes. You disagree with that?
I do disagree with that. It starts immediately.
Do you have any studies that you've relied on or literature or support for that?
I understand the physiology of what happens when you get those skull fractures and the density of the blood vessels. And if your heart is pumping, you pump the blood out those broken blood vessels into this small area above the eye. die. And
you
it
have-
it can happen within minutes.
Do you have any studies or literature to support that?
That's my training experience. I can't cite you a particular article at this time. I could certainly go look it up and bring it to you.
Okay. Let me ask you questions about the wounds to the back of Mr. O'Keefe's head.
Yes,
You see a linear abrasion?
yes, vertical lines, yes.
Now, would you characterize this as a classic wound caused by falling backwards and landing on your head?
What do you mean every wound is different?
Every wound is different?
Sure, every person's different. Every way you get injured is different.
And so if somebody falls backward on their head and suffers the basal fracture, the wound from your perspective can look different.
It depends on the impacting surface.
Wounds on the same surface, say two people fell on the same surface, could they have different wounds on the back of the head if they suffered the same injury?
In theory, if they fell, if they rotated their body, if you could reproduce something exactly, then you would see the same wound patterns.
This wound pattern is typical of falling backwards on a hard surface, isn't it?
We know it's from falling backwards and striking something hard.
Can the frozen ground be hard?
A frozen ground can be hard, but it doesn't fit the pattern in this injury.
We'll get to that, but is it
Oh, okay.
hard enough to cause a basal fracture?
It can cause a skull fracture.
The frozen ground is different than a sheet of ice, right? It's not smooth and flat like a sheet of ice, is it?
It could be, I guess.
Okay. You mentioned there's some granular patterns in this wound.
Yes.
Didn't you?
Yes.
The area in front of 34 Fairview, the frozen ground, do you know if there was any impediments in the lawn that was frozen?
In the what? Oh, the lawn?
Yeah. Yeah, sorry.
Yes, I saw the scene photographs when the snow was removed, and it was like winter lawn grass. So it was some green, some brown that was pushed down, and like straw that was going different directions, which wouldn't give you that pattern.
Did you see the exact area where Mr. O'Keefe last moved?
I saw that general area, and there were a lot of photographs,
Well,
yes.
You say general area. Can you tell us that you saw photographs?
It was good
of
enough for
the
Yuri,
spot
Hank.
Where Mr. O'Keefe was lying when he was found.
Yes, that general area.
Could you see the ground where his head was? Can you identify that?
Yes, with the scene investigation, they shoveled the snow off of that area.
And you had never had a chance to go out to that scene yourself, did you?
No, I just looked at all the photographs.
You cannot see what's under the grass and the dirt, can you?
Well, dirt's under the grass.
Well, do you know if there's any rocks or impediments or bumps?
It was a smooth surface covered with grass.
It was a smooth surface? The front lawn was a
It
smooth
was
surface?
a flat surface
Flat.
covered with grass.
Okay, and do you know what was under the grass, whether there was any pebbles, rocks, debris
I didn't see any.
from the photo?
Correct.
But you don't have any firsthand knowledge that exact area where he ended, what the turf was like, do you?
I saw photographs of that lawn where they removed his body
So
from.
you're relying solely on the photographs, is that fair to say?
Correct.
Do you know if Mr. O'Keefe was wearing anything that could cause abrasions when he landed to cause that scraping pattern in addition to the linear abrasion?
He did have a baseball hat on, but that would not cause the pattern.
The area of the abrasions, is that in the area of the level of where a baseball hat would be on the back of somebody's head?
It could be.
Could be. If somebody hits the ground and falls backwards, can they slide?
And if they're on an incline,
What if they're thrust?
well, if you fall backwards and you fall backwards on an incline, your body might move.
Well, what if you fall backwards on flat ground? Does the body, can it move after it falls?
Not really, maybe a little. If from the momentum of the impact, it might move slightly, but not really.
So when a person falls backwards and lands, you don't think their head has any room for movement?
Not significant.
Well, not significantly, maybe just a quarter inch, half inch.
No, it's possible.
Okay. And did you see the scrapes around the wound of Mr. O'Keefe's head?
Of course I saw them, yes.
Okay. And they're all within, what, about an inch?
What are you describing? What part? Are you describing the tearing, the laceration of the scalp, or the vertical abrasions?
The vertical abrasions.
There were maybe an inch and a half.
Inch and a half? Do you think that if someone fell backwards and landed on the head, they could move an inch and a half?
Well, he landed on something that had a ridge on it to cause the laceration in the scalp, and then with a little bit of movement, those vertical scratches were caused by some kind of like pebbly-like surface.
You mentioned that the
Pebbly-like.
orbital bones were broken, and you had opined that it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh, gross. What do you mean? It is soft.
Is it that soft? Is that the texture of it?
Well, it depends on what kind of tofu you have.
Okay.
Yes, it is. My tofu queen
Do you
here.
think that the orbital could have broken when the break on the back of the head split the skull and then would cause the orbital break instead of the brain?
The orbital plate fractures, if you look at the base of the skull after you take the brain out, you can see the fractures go up from the back to the front into the orbital plate. Sometimes when you fall backwards, the brain can also slap those orbital plates and cause some damage, but I could trace the fractures from the point of impact along the base of the skull to the part of the skull over the eyes.
Do you think the base of the skull break, when it separates, could have caused those orbital fractures?
I don't understand your question.
Okay. When Mr. O'Keefe incurred that head injury,
Yes.
the basal fracture, do you think that the pressure, the damage from that basal fracture, the separation, could have caused the orbital breaks in his eyes?
Well, the fracture of the plates above the eye, when the blood is still pumping, there's a space there where the blood can come down into the upper eyelid.
So you described the brain as causing that break. I'm asking you, could it have been from the basal fracture, from the skull fracture?
Yes, the fracture that was caused by the impact to the back of the head, radiating to the front of the base of the skull.
So when you told us on direct it was from the brain that caused those fractures, was that just a summary, or is that to a reasonable degree of medical certainty?
Well, sometimes the brain can also, in a fall, flap and hit those, but in this case, I could also see that the skull fracture started at the back and came to the front, but it could also be contributed to by the brain hitting those delicate bones.
I guess my question is, when you've provided the opinions generally of what you believe and what you've seen, are these general opinions, or are they actually specific opinions based on the facts of this case?
They are opinions based on my examination of this case, but all that's based on my 40 years of training and experience.
Well, when you told us about the brain causing those orbital fractures, you would agree with me, at least now anyways, that it very likely could have been the basal fracture that caused those breaks.
Yeah, both.
It could have been both?
Sure,
Okay, could have it been just the basal fracture?
that's possible.
When you offered the opinion to a reasonable degree of medical certainty, had you considered the basal fracture as the source of those breaks?
Of course.
Is there a reason you didn't share that with us and you just said it was the brain?
I had no reason not to share it.
Okay. Was there any depressed fracture to Mr. O'Keefe's skull?
No.
Can you tell us a little bit about a depressed fracture? Depressed fracture is different than what we saw with Mr. O'Keefe, isn't it?
A depressed fracture is when something fractures the skull and then pushes the skull and moves the skull inward. This just had a fracture, but it didn't move the skull inward.
And you've seen depressed fractures in your practice over 40 years, did you say?
Of course.
In those 40 years, depressed fractures can happen from sharp objects,
Sure.
pointed objects.
Sure.
If someone hit a person in the back of the head with enough force, with like a hammer, for example, that could leave a depressed skull fracture, couldn't it?
Certainly. You can hit somebody on the head with a hammer and cause the fracture, and then the continued force will move that fracture into the brain.
There was no depressed skull fracture in this case, was there?
Correct.
You gave some opinions today about you gave some opinions about wounds on Mr. O'Keefe's arm. I'd like to talk to you a little bit about that.
Sure.
Could we have that photo brought up, please? Do you see all of those superficial abrasions?
Yes, I see patterned injuries.
Right. Would you agree that they're superficial abrasions?
Yes, they go along the skin surface.
How many punctures would you identify in that photograph?
Let's see, there may be some punctures like around the elbow, consistent with the teeth puncturing. Most of them are the teeth scraping along the skin.
I'm not going to ask you what you believe the cause was. I'm going to ask you just about the wound. How many punctures do you see?
Well, this doesn't show. There are other photographs which show more of them, but there's the little dot-like areas. You could call an area of skin puncture.
Can you tell us from this photograph how many punctures you would say are in that photo?
I didn't count them.
Well, did you suggest that there was more than one puncture on that wound?
I think I see more than one, yes.
Pardon me?
I see more than one on there.
Okay, could you give us a count of how many punctures you see?
Well, without looking at all the photos, I couldn't give you a correct number.
Okay. You've written a report, haven't you?
I what?
You wrote a report?
I did.
And in your report, you describe many of those abrasions as punctures, don't you?
Yes.
And a puncture isn't just a scratch. A puncture is a penetration of the skin, isn't it?
Yeah, a point-like penetration.
A puncture has a very specific medical meaning, doesn't it?
Yes, it's a point-like penetration of the skin.
And according to you, there are many punctures in that wound.
Yes, I can see 1, 2, 3, 4, 6 or 7.
Can medical professionals disagree on opinions about wounds and causes?
I suppose they can.
You also gave some opinions that you did not believe that Mr. O'Keefe's scratches were caused by having some impact with broken pieces of plastic or glass, correct?
Correct. They weren't caused by that.
Broken plastic or glass can cause a number of different angled wounds, can it?
It causes an array of irregular, random injuries.
It can have infinite different patterns, couldn't it?
Could.
There's nothing to hold a wound from a broken shard to be north or south or east and west. It all depends on how the force is impacted on the body, true?
I'm not quite clear on your question.
I'll try to do better. When you're
Good luck
talking
with that.
about shards of broken glass or broken plastic, there is no set direction that they may cut somebody, is there?
Well, it would depend on the case and how those occurred.
They can happen in many different forms as far as depth, yes?
Well, anything's possible.
Okay. How about length?
What about length?
Wouldn't that change? Couldn't that change depending on how the injury occurred, the length of the wound?
Sure.
And in this case, you talked about your opinions of injury relative to a motor vehicle, didn't you?
That was
No, because
something
you
I considered.
objected.
That's something you considered. Did you know much about the details of the motor vehicle in this case?
Yes.
Okay. When you considered your differential diagnosis, did you consider whether there was any DNA on the vehicle?
I didn't look at any of that.
I'm sorry?
I did not look at any DNA.
Did you know if there was any hair on the vehicle?
I don't know.
Did you consider the scene itself where there may have been a debris field? Did you take a look at the debris field in this case?
I know there were photographs of various pieces of plastic around the area where the body was found.
And do you remember where those pieces were found?
Somewhat, yes.
Did you have an opportunity to consider other evidence like a shoe in the area near where Mr. O'Keefe was found?
I know one shoe was on his foot at the hospital, the other was at the scene.
Do you know if his hat stayed with him after he landed on the ground?
The hat was in the area where his body was found.
Did you take a look at his pants, the back of his pants?
I looked at that, yes.
Okay, what did you see when you saw the back of his pants?
Well, because he had bled from the back of his injury and he was on a hospital gurney, some of that blood came down, so some of the blood was on the back of his pants.
Did you see anything else other than blood on the back of his pants?
I don't remember.
I'm sorry?
I don't remember if I saw
Objection
anything
to
else.
this.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
Like data you would find on a cell phone?
No.
Did you look at any of the data evidence from the defendant's Lexus?
No, other than looking at the contours of the back to see if it had impacted Mr. O'Keefe.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
So you didn't care to know anything about the car or the data in the car because you had already formed your opinion?
It did not hit him, so it was not relevant to my opinion.
Oh my God.
Is that a different way?
By looking at the body, I could tell that there was no evidence of impact with a vehicle.
Is that
So whether the vehicle was going slow or fast is not relevant.
And so you didn't try to get any information about the speed of the vehicle? It was totally irrelevant to you?
Correct.
And did you also disregard?
See that wall you just walked
Well,
into?
let me ask you, do you ever look at statements?
I look at witness statements if they're available to me.
Were any of the defendants' statements made available to you?
I did hear some of them.
Did you consider the ones that you heard?
Of course.
Which ones did you hear?
I really can't answer that. I don't know what you'd have to give me an example.
You said that when Mr. O'Keefe was first incurred his injury, you think that he was unconscious?
Yes, I think that the severity of the impact made him immediately unconscious.
So if hypothetically Mr. O'Keefe incurred his injury sometime around 12:32, is it your opinion that he never moved again until he was moved physically by somebody else?
Well, I don't know the exact time that he got the injury on the back of the head, but after that time, he could not carry out any purposeful activity.
May I approach sidebar, Your Honor?
Okay.
Oh, no problem with, no problem. It's not an issue of delaying the jury. Hank wants a sidebar now. Why, Hank? You struggling a little bit? You find in this professional witness a little hard for you to crack? I love this woman. Okay, this woman is now my new favorite witness. She's up there with Isaac. Okay, Isaac is still the king. He's still the pinnacle of like the best witness ever. But this one is great because it's such a role reversal, isn't it? All this contempt that Brennan has been spewing all over these witnesses in this courtroom, the belittling, the treating them like they're idiots. Oh, how the tables have turned. How the tables have turned. And she isn't afraid at all to show us how dumb she thinks a lot of this is. Hank, you don't even know what these words are that you're using in your cross-examination. You don't even know what they are. You don't even know about the Glasgow coma scale. You think it's something else. You're up here trying to say these other things. You don't even know that. I love this role reversal. Just feeding it right back to him. Oh, you thought you were going to come and flex and get somewhere? Here's a flex for you. Here's a flex for you. It didn't hit him, so the speed doesn't matter. There's a flex for you, Hank. You thought this was a small, frail little woman with some breathing problems, one who might be able to be pushed around. And it turns out she's a solid brick wall you just ran right into, isn't she? Of course you didn't look at speed. It doesn't matter, you dumbass. He wasn't hit by a car. Why would it be relevant? All of his little tricks, his little ways of like implying that there is something that she should have done that she didn't, that would be stupid. She's just saying it. She's just saying it how it is. Now, from my perspective, differential diagnosis, she considered the motor vehicle accident. She knew about the details in this case. Didn't look at all this other stuff. Bev did not allow her to testify. In her opinion, no motor vehicle collision here. This should open the door. This should open the door. You've already gotten into it now. Yes, she did consider it. Yes, she did consider it. And now, thanks to you, we know that there was no collision. The car didn't hit him. So no, of course the vehicle data and stuff like that doesn't matter. It didn't hit him. You can tell from his body. His body told her what happened. You opened the door, Hank. I don't know how she doesn't get to revisit this on redirect, but something tells me it's going to still be off limits. It doesn't really matter at this point anyway, does it? Hank has got it all out by implication, doing the defense a big old favor for him. I'm sorry. I'm a tofu fan, okay? I'm a big fan of tofu, but I felt the world become one with Dr. Laposata. When Brennan's like, the brain is soft like tofu, and she just went, ew, ew. At what? The very thought of tofu. I understand. Guys, tofu really, it can be amazing. If you haven't tried freezing your tofu, you just take that block of tofu you get at the grocery store, take out, you throw it in the freezer, okay? And then thaw it out. You can literally wring it out like a sponge. Cook it up that way. Completely changes the texture of your tofu. It's like a completely different product when you do that. Try that sometime if you haven't tried that. Try freezing some tofu and cooking it. But I felt the whole world as one. Ew, tofu. I mean, she's relatable. She's rock solid. She knows her stuff. She's on message. She's got the counters. You think you're gonna get her to be like, oh no, I should worry about I didn't.
All right, so
That
Joyce,
matter?
rather than keep you here
No.
and do things, I'm going to excuse you for lunch. Lunch will be about 50 minutes or an hour, and when you come back, we will go straight through the afternoon. We're going to do everything we need to do now.
Please follow me. Close your notebooks, please.
Okay.
Early lunch. I think we're going to be coming back to do stuff, so I don't want to jump away from the stream too fast. But we'll give them a minute to see if they're going to come back in. Yes, I had a feeling they would.
Excuse me.
May be seated.
All right, so Mr. Brennan, if you can briefly tell me what it is you want to introduce through this witness.
To remind the court, on direct examination, the defense promoted Dr. Laposata's credentials, including specifying her successes with the station nightclub fire and her running of her office. I have an audit from 2005, State Department of Rhode Island, Department of Health.
Oh, the
In that audit,
autopsy.
it paints a very different picture than was presented on direct examination. In that audit, they investigated chief medical examiner, and they compiled the history of statistics for the medical examiner, which was Dr. Laposata. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals
Where does
that
it
weren't
say
properly
extraordinary?
attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr. Laposata's office would need to change because of the extraordinary backlog of cases regarding autopsies. In addition, it was noted that the incomplete reports confirmed that there was significant concerns with the historical management practices of the medical examiner's office shortly after Dr. Laposata resigned. In addition, it was promoted that in the station nightclub fire, Dr. Laposata had a heroic effort, and in her testimony, she also noted that there was a failure, or implied there was a failure because the medical examiner or somebody did not go to the scene to look at the turf in front of 34 Fairview Road. She suffered the same criticism for hours and hours after the station nightclub incident. She was contacted with a request to come to the scene. She refused to come to the scene, did not appear for at least 17 hours, directly on point to the claims that she's making against other people. Is the
How is she
same
making
conduct she
claims against
engaged
other
in,
people? She said we look at
on a more
photos.
extreme scale. She testified in Commonwealth versus Tompkins. In Commonwealth versus Tompkins, she was listed and testified as an expert, attempted to testify as an accident reconstructionist, which was denied. Inevitably, the court made conclusions. Actually, in that case, her efforts to be an accident reconstructionist were denied. Then she testified in a case called Patino.
She
And
handed
in
your
Patino,
ass to you, so now you're going for the
after
smear.
testifying, she received great scrutiny and criticism from the court. The court noted on page 1025 of the transcript, when Dr. Laposata gave the testimony, she knew the boy wasn't like this because he fell off a bed. She knew the mother was lying. She read the text messages and knew the defendant had beat the boy. The only reason I conclude that she offered such testimony was to distance the defendant from causing those bruises, setting up an argument against malice, but instead destroyed her credibility. On cross-examination, she came across as a hired gun. Sometimes it's seemingly small things that impeach a witness's credibility. Inevitably, on the credibility determination by the court would agree. The jury gave greater weight to the testimony of Dr. Gilson and Snelling than they did Dr. Laposata for the reasons I addressed previously. The jury was justified in discounting her testimony and concluding the other doctors testified apparently impartial. While she appeared as a paid advocate, at least on this occasion, without impugning the witness's integrity, because that witness is known to the court, but in this case, when she testified, she was not credible. That's a direct credibility determination by another tribunal.
Yeah, and
about
guess
her
what?
testimony.
You don't get to do
so
in
I would
court.
like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding her run as medical director that led to resignment after she was audited and left 1,500 bodies unattended or incomplete. Also get into the criticism she received for her handling or lack of handling of the station nightclub fire, and finally get into the adverse credibility determination in the Patino case.
So I'm not familiar with the Patino case, so I'll need a copy of that.
Yes.
All right, Mr. Jackson, I'll hear you.
Thank you, Your Honor. First of all,
You really don't need a copy of Patino.
Mr. Brennan
It's
said that
explicitly
the audit established
allowed.
that, as the chief medical examiner, the audit revealed that she left 1,500 bodies unattended, was his quote. Bodies unattended. That's absolutely not what happened in that situation. It was a political situation. The medical director for Rhode Island came in and took over. He began to change protocols and cut quality control. He said he did not want a second set of eyes on any of the reports, not the autopsies. There was never a suggestion, ever, that an autopsy was not performed efficiently and timely. Never. The reports that were attendant to the autopsies it was a two-tiered set of criteria that Dr. Laposata put in place to establish quality control and quality assurance. First, the medical examiner conducts the autopsy and writes a report. Then the doctor herself, the chief medical examiner, because she is a perfectionist, determined that she was going to establish a protocol in which she would put eyes on every single report. Hundreds and hundreds of reports per year. In doing so, she had to prioritize which reports were going to take a priority, which ones were being subject to litigation, which ones were going to be subject to criminal cases, and which ones were never going to be subject to any review at all. For instance, if somebody was found, let's say somebody that was without family, etc., found and unidentified, there's no litigation attendant to that report, she would put that report aside and get to that report after she dealt with the reports that were on sort of on the front burner, if you will. After, by the way, none of the reports were ever not done. They were all completed. There were a small fraction of reports, according to the audit and according to Dr. Laposata herself, that had to take a back seat. When the medical director came in 2005, by the way, this is 25 years ago, right? These are autopsies that were performed, and the audit was performed for autopsies and reports dealing with the year 2000. It's 2025. This is 25 years ago. When the new medical director came in for Rhode Island, he said, I don't want any review of any of the reports because it's more efficient and it's faster to get the reports out in a timely fashion. She resisted and said, I will never, ever, and she was published saying this, I will never, ever sacrifice quality for speed. I want the highest quality coming out of this office. They had a difference of opinion. She walked away because he was asking her, the new medical director was asking her to sacrifice quality of the conduct that she was undertaking as the chief medical examiner for the state of Rhode Island. So it's a very different circumstance than was just suggested. No bodies were ever left unattended, ever. Certainly did not involve the other phrase that was just used is negligence and malfeasance. It was a backlog, and they had a very public political fight over it. Number two, with regard to the station nightclub fire, her staff was on location immediately. She, as the chief medical examiner, was there the same day. So that's of no legal moment. That's of no consequence. It certainly has nothing to do with her opinions and conclusions in this case. The Tompkins case, we've already talked about that in voir dire, Your Honor. The Tompkins case dealt with an issue dealing with accident reconstruction, which she's not undertaking. I'm not asking her, and she ain't saying.
I've excluded that part of it based partially on the Tompkins case.
Right, and I don't know anything about the Patino case, and what I would say is, given the fact, look, we don't know what the facts of that case were. We don't know what the trial was about. We don't know what the cross-examination was about. We don't know why she was called. We don't know what she looked at. We don't know why she was looking at what she did look at. We don't know why she didn't look at things that she might not have looked at. We don't know why her opinions and conclusions were ultimately rendered. We would have to have a trial within a trial, which I would be happy to undertake if someone gives me a file. Happy to do that. But I don't think we want to do that. I don't think the court wants to do that. Also, I will say, I don't think that attacking this witness's credibility is in good faith by the Commonwealth. Mr. Brennan himself has hired Dr. Laposata personally no fewer than 4 or 5 times. Maybe it's 3 or 4 times. He knows her qualifications. He knows the quality of her work. He's actually undertaken to consult with her as a medical examiner and a consultant. So I don't believe that these last 2 issues are in good faith. I don't believe the station fire has anything to do with anything, because she was late, according to Mr. Brennan, in coming to the actual location. She was there the same day, and she had an entire staff that was there immediately. And in terms of the audit, it's a 25-year-old political fight that isn't quite what Mr. Brennan made it out to be. So I don't think any of these things are relevant for cross-examination. I'll submit.
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr. Laposata 4 or 5 times. And so that is just a mischaracterization which he likes to do for the public. But the reality is, I've used her a few times, and the last time I used her, I'm not going to disclose why I don't use her anymore, because it would be unfair without her in the room. But the suggestion that somehow I'm endorsing the qualifications of this witness, I am not. That's what I'm going to say on the record.
You don't use her anymore because
so
you're for the Commonwealth.
First 2,
and she doesn't support your opinion.
The backlog issue, if we can call it that, with the ME's office, I'm going to allow the Commonwealth to get into that through questioning. Same with the station nightclub fire, based on the testimony already in evidence. Those 2 areas, and Mr. Jackson, without leading, you can certainly go back and rehabilitate her. But those 2 will come in. I'm not going to do anything with Tompkins because I used it for the basis of keeping out what appeared to me to be biomechanical engineering opinions of this witness, and she's not qualified to do that. So I have not read Patino. I will read it over the lunch break and see if we get anywhere with that. Okay, so I need a copy of that. I want you to give Mr. Jackson a copy as well.
I will.
Okay?
He has a copy.
Okay, so,
I didn't know that. I appreciate that.
all right.
The only other thing, I don't know if you want to hand it now or after lunch or later, but I want to address the issue of the 3 personnel.
Okay, so let's mark those now.
Sure.
Can we mark them all as 1 A, B, C?
I have no preference one way or the other. It's just 3. They're all
Mr. Jackson, if you can I just see it?
Of course.
Just hold up the size. ID, yeah.
Yeah, it would be, yeah. It's to mark them.
You know what, show me that one again too, please.
H, quadruple H, and I, through I.
Oh, all right. All right. Mr. Brennan, there's no objection to these coming in through another witness, so you agree that they'll be coming into evidence?
I'll stipulate
All right. And what's the objection to them coming in through Dr. Laposata?
it's not part of her report or opinion. And she's gone beyond her report, talking about the fact that she's studied x-rays and given an opinion. I think that suffices.
It's the x-rays.
It really, I think, is beyond the scope of her testimony to begin with. I'd be gracious with it. Stipulate to these, I'm sure Dr. Rentschler will utilize them if stipulated.
So you'll stipulate to them prior to Dr. Rentschler?
I will.
So you can use them with Dr. Rentschler?
I expected that I could because he certainly used them in his analysis and opinion. But I should be subject to the
703.
entry of evidence in the defense case in chief. I understand I can use them in Dr. Rentschler's testimony, but I want to use them with Dr. Laposata. She's a medical doctor.
Would you
consider them for purposes of her opinion? I cannot understand.
So what do you want to ask her about them?
Are these the x-rays that you reviewed? Yes, that's it. That's
Okay.
it.
Okay. So go ahead.
And if that's all he's going to ask, I won't have a problem.
Okay. Yeah, I have no problem with that in that form.
That's it. Literally, these are the x-rays that we talked about a little bit earlier. Yes. This is the right hand. Yes. That's the arm. Forearm. Yes. That's the upper arm.
All right. So they're cumulative, but if they're coming in anyway, I will let you put them in.
Thank you.
All right. So the last thing is Dr. Rentschler. I need to hear argument from both sides. I have a new PowerPoint. So I'll hear both of you. Mr. Brennan, I'll hear you on your motion.
Because we should start with him today.
We've received the most recent update to Dr. Rentschler's PowerPoint. There are some additions, different analysis in that PowerPoint. This is within 24 hours of him testifying. There are opinions on page 6 and 8 of his May 7, 2025 report. And there are a number of numbers that we have objections to. Dr. Rentschler just generally shouldn't be allowed to express opinions and conclusions about what he thinks about the case or about other witnesses.
All right, so I'm looking, I think, at the new,
Do you have a copy of the new one?
from today, page 6. So what I have are just photos with measurements, so I don't know what the testimony that corresponds with those. I've read, obviously, the report of Dr. Rentschler from May 7th. That does not seem to detail everything, and that's no criticism. I'm just saying it's a scant report, so I don't know what the opinions are regarding these.
I'm sorry. Yep.
I didn't want to speak over Mr. Brennan, I apologize. I just wanted to let the board know to cut that out. Now, we went through, based on Mr. Brennan's suggestions last night, and significantly edited the entire thing. Literally every single slide that you had a problem with. There were a couple that we just completely left, but it's very, very.
I see that a lot of the hearsay's been removed.
Okay.
And I can identify this report as helpful.
Thank you.
I'm sorry?
I can identify this report as helpful, the ones that were changed.
All right.
Very hard to hear them.
So what do you both, I'm going to hear from Mr. Brennan first. What are you objecting to as the report now stands?
I have a most recent copy of the report now. So 9 through 27
Slides 9 through 27 or pages?
Slides 9 through 27 now have Dr. Rentschler identifying and attempting to match different abrasions with different holes in Mr. O'Keefe's sweatshirt. And so basically what he is trying to do is to suggest that there are a different amount of abrasions relative to the amount of holes, or perhaps he might want to testify about that the holes in the sweatshirt were in a different place on Mr. O'Keefe's arms than the abrasions. The reason why this is concerning is because there is no background for him regarding fabrics. This is a different and new opinion that we have not prepared or obtained an expert for. We probably have very little time to get somebody to rebut this analysis regarding fabrics. I don't see anything in his CV or his history that allows him to equate the number of holes in fabric
Hard to
with the
shop
number
for
of
somebody
abrasions
to
on
say what you
somebody's arm,
want.
but does not consider or account that there could be multiple wounds from one hole, or there could be holes that don't create wounds.
So cross
whatever
on
the
it.
implication is going to be by Dr. Rentschler, we're not very sure, but it obviously would require some type of expertise, which I do not think that Dr. Rentschler has a foundation for. So those are 9 through 27 generally, and then specifically, I can run through quickly the individual objections I have. Slide 6 tries to define the theory of the alleged incident. Doesn't say whose theory it is. It implies it's the government. It's an improper suggestion.
Hold on. Okay, so which one of 1, 2, and 3 on 6?
1 is objectionable. What's the core issue of the case? It's an ultimate issue for the jury. An expert reconstructionist or a biomechanical engineer shouldn't be defining the core issue of the case. And then 3, first event is alleged contact between the rear of the Lexus and Mr. O'Keefe's right arm. Again, that's offering an opinion that doesn't have facts and evidence, not in a position to
Oh, really?
draw that opinion.
And is 2 okay? Or are you moving to the whole slide?
No, on number 6, all 3 of them shouldn't be there. Asking what the core issue is in the case, Dr. Rentschler or no expert should be defining what the core issues in the case are. They should talk about their training experience, any testing, observations, evaluation, and then give their opinions, not core issue in the case.
All right.
Slide 9 outlines perhaps his process, the first step of the analysis to determine if the arm injuries are consistent with the physical evidence, evaluate the abrasions and compare the evidence. I suppose this is what he's done. This is one of the less offensive ones, although unnecessary. It doesn't provide an opinion. I could live with that. The next one,
You could live with what?
number 9.
Okay.
Oh, good for you.
Number
Good for you,
23.
Hank. Hope you got your oxygen tank ready, because you should have to live with all of it.
Again, this gets into that new core opinion about trying to identify or, I think, compare the abrasions to the different wounds. I think the part that's objectionable is the words measurements, question mark. I'm not sure if it's implying failure of somebody else. It seems to be an opinion, and I'm not sure of the context of it.
So ask him about it, Hank.
24.
Cross is 4.
The expert is trying to define what Dr. Welcher had done. It may be that he's saying he conducted his testing based on the position of Dr. Welcher's arm. I think that would be an appropriate comment, but it's not clear what they're saying. The pain transfer test, number 2, is the only test noted with respect to the arm.
So without the text, are you objecting to this
No.
slide?
No.
Okay.
31 posits questions regarding ultimate opinions. I think it's inappropriate. And then 32 I think is improper because it ultimately endorses or vouches for the witness's credibility. I think he certainly can give an opinion that the evidence is inconsistent with the injuries to Mr. O'Keefe's arm, but I don't think it should be on the slide bolstering his opinion.
What? You can say it, but you can't put it on a
33.
slide.
Again, it's posturing the weight of the evidence. And it's resigning the government to a particular study, one study. It's really a commentary on the government's case. It goes like this. Number one, Dr. Welcher only did A, and second part, A is insufficient. So that's really what this is saying. It's commentary, it's hearsay, it's inappropriate.
No, it's opinion and
34.
criticism and confrontation.
I think if one said that that's what he did, I, Dr. Rentschler, took a step to determine the kinetics of Mr. O'Keefe's arm during the alleged incident and asked how would this arm move, I think that would be appropriate. But he shouldn't be giving an opinion on what steps should have been taken by Dr. Welcher. Number two,
That's
on
what an
slide
expert
34.
does.
And number three, I don't have a problem with. The next one is 46. Again, this is bolstering the expert's opinion by putting it in writing on a slide. I think some of these opinions are appropriate for Dr. Rentschler to share with the jury, but his final ultimate opinion shouldn't be endorsed on a slide.
What's the law for that? Where's the
47.
exclude the slide law?
Again, this is self-endorsement of the success of his tests and giving his opinion about his success.
Yes, he gets to do that.
Number 1 and 2, I think, are inappropriate. Number 3 has really no context standing alone. And number 4, if he notes that's his next step, I wouldn't have a problem with number 4. Slide 54. Again, number 1 gets into his opinions.
So imagine that, an expert talking
Number 2,
about
he
their
gives an opinion
opinion.
about a different expert, a medical opinion. And number 3, it's, again, self-endorsement on his own opinions. So all these are opinions either bolstering himself or somebody else's work. I don't think it should be in a slide. 55. I think it's accurate. I think it's proper testimony. I don't think it's proper for a slide. Same with 56.
Bizarre.
I don't know that he has the basis for number 1. Number 2, I don't have a problem with on slide 56. And number 3, again, it's bolstering his opinion. So I think 1 and 3 are improper. 2, not. Slide 58. I don't know what the basis for number 1 is. I suppose we'll have to see. If these are Dr. Rentschler's views, I don't know how they're relevant to the Commonwealth's case, but certainly I think he has the experience to make these conclusions, but it shouldn't be in a PowerPoint. He shouldn't be commenting on the reports of another expert in a PowerPoint.
Of course he should.
Number 3. And number 4 is ultimately an opinion that he's self-endorsing.
Yes, that's what experts
66.
do.
Again, it is an opinion. I don't think it's an admissible opinion, and it shouldn't be in the slide. He's trying to draw a conclusion on what the jury should conclude based on the Commonwealth's evidence. He's not in a position to do that. 67. Parts of this are objectionable. I think that he certainly could testify. He hasn't seen any simulation by Dr. Welcher, but posturing it about in a manner that suggests there should be doubt in some way is inappropriate.
No, it's not. It's called having a defense.
68, I don't think Dr. Welcher's report was introduced. And putting in a fraction of a report, I can't appreciate the significance of it. It's hearsay. Perhaps there's a reason he'll be able to point to the report or talk about the report. I understand that, but putting in a random page from a report is hearsay. Should not be admissible. I don't know if there's going to be a conversation about trying to introduce the entire report, but one page will take it out of context. 72.
But that's what Welcher did, isn't it? Took little snips of the reports out of context, put them up.
I think the expert probably can, I think the expert has a basis for the opinion. I don't think opinion should be, ultimate opinion should be in PowerPoint because it's self-endorsing. 74. Again, it's a conclusory opinion. It's bolstering. Some of these can be said but shouldn't be in PowerPoints. Same thing with 75 and 76. They're ultimate conclusions. And so I'm not in agreement with all of the conclusions that the expert may try to introduce, but testifying about an ultimate opinion and putting it on a board to self-endorse shouldn't be permitted. And those are my objections.
Okay. Ms. Little?
Thank you, Your Honor. First of all,
Please go to the mic.
Stand here, only be said that to be able to reference the PowerPoint.
Yeah, that's fine.
Thank you. First of all, there were no additions, just to be clear, to the PowerPoint. The only changes that we made were directly in response to the objections that are filed by the Commonwealth. We did delete a large section, trying to accommodate some of their concerns, as well as shortening some of the opinions. So those were the only changes. I just wanted to be clear to the court. There are no additional opinions that have been set forth in the PowerPoint. With regards to slides 9 through 27, that was not one of the issues that was identified in the Commonwealth's motion. They objected to slide 9. There's half of those slides are not referenced.
I do agree. It's a new objection. I just don't know when there's an objection raised how a biomechanical engineer is qualified to testify to tears and clothing.
So this is a direct test. His testimony is going to be based on his knowledge of forces and forces applied to certain objects and how that results in injuries.
And I understand that, but some of the specifics that he says, I'm just saying I had a concern, so I understand it's new.
I think that we'll be able to satisfy the court's concerns by laying the proper foundation for controls.
All right, so we can come back to the fabric argument or whether it's beyond his scope of expertise. But actually, Ms. Little, if I can just ask you, and I can hear you later, as I assume everybody wants lunch and we're coming back in at about 20 of, quarter of at the latest. Can you just explain to me why these slides, if Dr. Rentschler is permitted to express these opinions, why we also need them on slides? That's the problem I have.
I think that's a great question, Your Honor. And the reason we didn't do these on slides is because we objected to Dr. Welker coming in on his PowerPoint.
So I looked at that yesterday.
Copy of the specific opinion that's placed up on the screen with regard to his opinions and conclusions. That was done over the defense's objection.
So which one? Because I did look last night at that and did not see it.
It's slide 136, Your Honor. The totality of the evidence.
Hold on one second.
Yep.
Is
She's
it a
right.
conclusion page?
I don't know.
Hold on.
He's exactly right. The court said no ultimate issue problem.
And it states the totality of the evidence is consistent with the right rear corner of the big 2021 Lexus in front of the gun. And Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground.
Okay.
So if he's allowed to do that,
So that is different than what I said he could be asked on his ultimate question, right? But it still came in?
that came in.
Was there, I'm sorry?
Yes, that came in over the
All right. Because what I did note is that I was very careful to say exactly what the ultimate question could be from Mr. Brennan. In fact, there were objections. I sustained them twice, so I wrote out exactly what could be said, and Mr. Brennan asked a variation of the first one, and there was no objection. So I didn't remember that this came in. All right, so I will take a look at that. What I would like to do in the interest of time, so maybe we can talk about that in the conclusion page, but where he outlines everything else, there's so many pages with text that I may not have a problem with testimony regarding this, but why do we need testimony and text so much here?
This is to assist the jury.
It's what?
This is to assist the jury. There is a significant amount of information that needs to be relayed.
Okay.
See, this is an 80-page PowerPoint. This
Okay.
is solely to make sure that this is efficiently and effectively. I think it's helpful for these. We've narrowed down the text on the slide significantly. It's important to see those PowerPoints.
Okay.
Just to the major issues. I think we've streamlined this a lot, but I think having the PowerPoint will allow us to make this go smoothly and quickly.
All right, so I will look at these. What I'll try and do is if there are any changes in the first 15, I'll try and get those done during lunch, and then we can have this argument afterwards.
Thank you, I appreciate that.
All right. We'll see everybody no later than 1:15.
So we're coming back in a half an hour. This is just some of the most ridiculous objections. I swear. I've seen some dumb stuff. Some of this is just, it's just nuts. Okay. Just some of the dumbest stuff I've heard. He's offering an opinion. You can't put that on the slide. It's literally what an expert does. It's offer an opinion. And there's no reason why you can't have words on a slide. Hank, Brennan had, or Welcher had his slides full of words. It's fine. It's because you can distill it down. It's helpful to the jury. They can see it. They can listen. They can follow it. They know what we're talking about. That's all it is. Bolsters the witness on his own opinion. Yeah, I know this might shock and amaze you, Hank, but the witness is allowed to believe their own opinion. They really are. They're allowed to have a good faith belief in their own opinion. And they're allowed to state it. And stating it doesn't inherently bolster it. Okay? Goes without saying. They're taking that position on a witness stand in a court of law. They believe the opinion. That's okay. Your remedy to that is to show why we shouldn't. Show why we shouldn't believe his opinion. Hank, that's cross-examination. That's what it's for. We spent half an hour on this. Okay, we've spent how much time at Sidebar today relative to testimony? All the concern we have about not wasting the jurors' time. And Hank Brennan just pops off for like half an hour about some of the most ridiculous objections I think I've ever seen to a PowerPoint. You can't offer an opinion on the other expert's report? Of course you can. That's why you're an expert. You're here to rebut the other expert. You get to do that. So yeah, you get to describe what they did and why it's wrong. That's also perfectly proper and allowed. It's called testing the Commonwealth's case. Just a little thing that's contemplated by the Sixth Amendment. Yes, he can absolutely have an opinion on what steps should have been taken by Dr. Welcher. He can absolutely talk about here's what the government did and why it's not sufficient. That's what we're here about in this case. It's called a Bowden defense here in the state of Massachusetts. That's what they call it. So yeah, they get to present evidence on that. And here Bev is giving it life. Well, I don't know why this needs to be in a slide, because there's no problem with having it in a slide. It's not illegal. It's not improper. It's not prejudicial. He's saying it anyway. You put it on a slide so it's easy to follow the presentation, just like Welcher did. This ain't rocket science. But she's going to give it air. Well, so we got about 25 minutes left. Let's do our recap. Let's get through our recap as fast as we can, because we had to start with some motions. New motion from the defense that the Commonwealth opened the door to having Laposata, Dr. Laposata, testify about dog bites because they cross-examined Dr. Russell. Hank cross-examined Dr. Russell very specifically about Dr. Laposata's work, her report, and very specifically relating to dog bites and her opinion about the dog bites. And then the implication, because Russell said I didn't get to see her report and I really wanted to, it leaves the impression that the reason why Dr. Russell didn't see it is because it's negative. It's a very good point. It's a very good point. It's the same methodology. She's taught 13 classes on how to recognize pattern wounds, including dog bites. Exactly the same methodology that Dr. Russell used. Brennan, what's his response? It's typical. He's going to, respond on the attack. Nobody's attacking Hank here. We're just pointing out, what you did, and what you did is what opened the door. And so how does he have to respond to that? It's persistent, repetitive activity contrary to court orders, or they use the witness to introduce inadmissible hearsay and bolster other witnesses. This is what we call projection, Hank. This is what we call projection. You're literally the one that just yesterday mandated a cautionary instruction. Should have been a mistrial, but you got a weak-ass little cautionary instruction instead because you elicited false testimony, didn't you, Hank? You elicited false information. You presented something to the jury that you knew was not true, that those holes were caused by road rash. You put that in front of the jury. Literally you, Hank, just yesterday. To such an extent, we had a mistrial motion. We haven't forgotten. Just because Bev has the memory of Dory the fish, okay, doesn't mean the rest of us do. We actually remember yesterday and what happened. So he tries to blame shift because that's what he does. He darvos. He blame shifts. He uses these abuser tactics. Not a coincidence. Dr. Russell opened her own door. She brought in Dr. Sheridan agreeing with her. Then we had the little argument because AJ gets back up to rebut. And he says, Brennan said it. And Brennan interrupts him. No, I didn't say that. And AJ interrupts him. Excuse me, let me finish. I'm at the podium. It's my turn. And Brennan says, no, I won't. And keeps talking over him. And Bev does nothing. Bev does nothing. She does nothing about that. She just says, I heard what Hank said, AJ. Appeasing. She's appeasing Hank here. She's appeasing Hank. AJ, you don't have to do that. Give Mr. Brennan what he wants. You don't have to say it. I heard it. She's appeasing him. AJ's not having it though, right when I read the exact words. And so she does. He read the exact words that Brennan uses in his questioning. He elicited both the specific issue of the dog bites and then also Dr. Sheridan's opinion about the dog bites. He did that. It was not Dr. Russell opening her own door by volunteering thing, literally his question. And the purpose of it The reason why she brought up Dr. Sheridan at all is because he'd asked her any other experts' opinions that you're aware of that agree with you. And she's not allowed to say Laposata. Laposata apparently doesn't get to testify about dog bites. She doesn't know. She doesn't have Laposata's report. That's the implication. There was a report, Laposata, dog bites. You didn't review it. You don't know if anybody agrees with you. She just happened to remember Sheridan from the first trial. But it does. I think this is a very astute observation by AJ. That's exactly what Hank was doing. He's implying that they were hiding Laposata's opinion about dog bites, keeping it from Dr. Russell because it would be harmful. Nope, Bev's not going to allow it. She'll give a curative instruction on burden shifting. AJ pushes back, and we get to she can testify that it's consistent with an animal bite. An animal bite. Why is that okay? Who the hell knows? Because we have no idea what the standard is here. There's nothing that we can all rely on and go by talking about objective standards. Absolutely nothing we can go by to say what's going to be allowed here. We're supposed to have rules, these things that we call laws that are supposed to tell us when it's allowed and when it's not. But there's no sense here. There's no sense to any of this. Why is it okay to say an animal bite but not a dog bite? You said before it's a qualification. How is it a qualification this way but not dog specifically? She said dog bites, 50 to 50 autopsies that she herself has done and probably 75 more supervised dog bites. So there's just no sense to any of this. But we get in animal bite. So we finished up with the direct of Dr. Laposata. She agrees that the eyelid laceration was not consistent with being hit by the spoiler on Karen's car. You would expect bruising, specifically like a ribbon of bruise, because it's a linear object. There's nothing in his injuries consistent with that. She agrees that the coup contra coup is from that is what it is, and that it resulted from a fall back. Because of the extent of the brain damage, you could see the hemorrhaging in the brain stem. That is a harbinger of immediate death. It is life-threatening. She believes it would have resulted in immediate consciousness because of the amount of the energy that's being inflicted to cause those skull fractures. Then the brain would swell, and within 50 to 20 minutes, heart and respiration would stop. So finally, we have some sort of a time frame about, give us some sense of the interaction here between the death process and the cold process. And like, how might these relate? How long would he be alive outside generating his own body heat, and able in order to like resist the environment, the loss of heat that you're going to get from the environment. Once you stop generating your own body heat, you're probably going to cool faster, I would just assume. But once you're dead, you're going to cool. Unless you're in, a temperature in an environment that's over 98 degrees, which is, you're probably not, but you might. You're going to cool. You may die in a hot tub, like, for example. But that's not our situation here. So finally, we have a little bit of information to help us sort out what's caused by death and what's caused by cold. 15 to 20 minutes, he could be dead. So if he's dead outside in the cold like that, I'd love to know, what's his temperature going to be? I hope we're going to get some of this from Dr. Rentschler, because they sure are setting this up for him to be the pinnacle of all of this. And that's why Hank is making such ridiculous objections to it. He doesn't want it in our face on the slides how clearly John was not hit by a car. So then she also described that because of the nature of the injuries, that she believes John fell back onto something that was raised and that had a linear or a ridged pattern, and that it had some granularity to it. She later describes that as pebble-like, kind of like concrete, huh? Concrete has like, and there's different styles. You have very, very smooth concrete, but it's still going to, you know, have grain to it. You can have, you know, concrete floor that's got a little texture, got a little inlay and stuff. Something pebbly, she described. It was not smooth. So based on that, normally it would be the police's job, the investigator's job in a death investigation to go back to the scene and find a thing matching that pattern. Lo and behold, what did they not do here? They didn't do that. Don't get to talk about the garage where perhaps there was a similar surface. We will never know if that surface might have been inside the garage. So she knew generally the area where he was found. She knew that because of his injury, he wouldn't get up and move around. Bev sua sponte strikes this out. She's already testified to it. Yeah, that's what she said. Immediate incapacitation, 15 to 20 minutes death, to a medical degree of certainty, reasonable degree of medical certainty. But for some reason, saying John wouldn't get up and move around. Problem for Bev, doesn't even wait for the objection, goes ahead and strikes that one on her own. But there's nothing in the yard that would have caused that injury. The ground isn't going to cause it. If you fall on a flat surface, the tear in the scalp is more like a scar. You wouldn't have that vertical scraping in the skin. There's also no grass in the wound, no pattern from the flattened grass. You don't see any of that present. Then we move on to hypothermia. She has 100 or more autopsies from hypothermia that she herself has performed. She's experienced in this diagnosis. She disagrees with Squirty Bellow's conclusion that hypothermia contributed to the cause of death. She agrees with the head injury, but she does not agree that the body had hypothermia. Points out, okay, he had an 80-degree rectal temp. Okay, so it's a rectal temp. This also helps us a little bit too, because the rate of cooling, I think, is supposed to be based on internal body temperature. And I don't know how close rectal temp is going to get to you to like your average core body temperature. I thought it was still going to be considered an external type of temperature, like under your tongue. Thermometer under your tongue is also but I'm not 100% sure about that. But it is just a fact. We finally know that now. That's how they got the body temperature. It was a rectal measurement. And so, yeah, you have to sort out how much of you being cold is because you're in the cold while you're alive, and how much of being cold is because you're dead and the body cools when you die. So then we looked at we didn't look, but the audience in the courtroom and the jury looked at the photos of the Wisniewski spots, compared that to John's stomach. John does not have Wisniewski spots, according to her. He doesn't have ulcers. He's got a little bit of red mucus, and that's pretty much it. Otherwise, it's normal stomach lining. So he did not die of hypothermia. She doesn't agree with that. The cause of the darker red areas of his stomach we then get into, and we start looking at the Lucas machine, and she's got the photos of the Lucas machine, the graph of how it compresses on the organs underneath. It might push them, into the spine and cause injury that way. He doesn't have any signs of frostbite is another factor in no hypothermia, because if somebody dies from exposure to low temperature, you expect to see some frostbite changes. So in her opinion, the sole cause of death is the brain injury or the skull fracture that's due to blunt force trauma to the head. Then we go to the arm. Yes, pattern injury exists on his arm. It's animal wounds, both claws and teeth, some punctate wounds, some linear abrasions, some bite patterns. It can be from canines. It can be incisors. She talks about a lot of different ways that these wounds can be produced. She talks about the difference between an incised wound that's a cut from a sharp object, and then claws, however, and bites cause more of a scraping injury, not like a knife. A knife is an incision. Claws is technically a blunt force and abrasion. But she doesn't get to ask. She gets to say there's a difference between these things, but as far as these wounds, apparently the forensic pathologist doesn't get to have an opinion about whether the injuries are incisions or abrasions. They were inflicted prior to death. We had heard that before. We heard that in the first trial. They have to know that because they have to rule out post-death predation, scavenger activity. Not super uncommon. And so here's how we know. She's such a good communicator, makes it very simple that if you have a bite like that when you're alive, you have the damaged blood vessels have blood in them. And so it will bring like a redness to the wound. But if it's after death, they're more yellow or brown because there's no blood flow. So in this particular case, you can tell it's while he was alive. Don't know why that's okay to say, but we can't say if it's an incision or an abrasion. No rhyme or reason to any of this. Any sign of investigators going to look for animals at the scene? Objection is sustained. Not sure why she can't testify to that going into the basis of what she reviewed. So then the differential diagnosis is part of how you control for bias by keeps you from making a quick decision of your first reaction, your first impulse when I see this thing, oh, it's probably that, and then just running with it. Instead of taking the time to think about what are all of the things that could cause it, and then how can I rule those out? It helps you be more systematic and more objective. She has done it many times with motor vehicle collision. It's sustained repeatedly, motor vehicle and pedestrian collisions. General injuries she expects to see. With a pedestrian, you expect to see crushed tissue where the vehicle impacts the tissue, and that creates a bruise. The skin can break with more force, but that's objected to and stricken. Don't know why. Not allowed, apparently, to testify about whether John O'Keefe's arm was injured by a taillight. We have, multiple objections to that that are sustained, and her testimony is stricken. It doesn't correspond. Ultimately, what she's allowed to say is it doesn't correspond with plastic pieces impacting his arm. They have to have a whole sidebar over this. There's no tissue damage from an impact injury. There's no random damage like you'd expect from the shattered taillight. There's not a random pattern of cutting injuries like that. There's no bruising on the arms or torsos. There's no bruising on the legs. In spite of the fact there was special leg dissection, there were x-rays taken, x-rays of the arms, x-rays of the hands, x-rays of the legs. All the bones were intact, no breaks. That was the conclusion of direct. We went to cross. And cross has just been a glorious experience of watching this small woman hand Hank his ass. Just absolutely dog walk this prosecutor. Thrust? What do you mean by thrust, Hank? I know it's a foreign concept to you. Maybe someday you'll meet a nice woman and learn. But this one, nah, doesn't know what you're talking about, not going there. You're going to have to be more clear about what you're talking about. What she means is she's talking about he falls backwards and there's a significant amount of force. Tries to argue with her about, the force, how much. You don't treat living patients. It don't matter. You're not going to shake her. She deals with dead people. She's very familiar with the processes, the timing. She knows what the neurosurgeon is going to do. It just doesn't really matter because this guy is dead. Doesn't matter what a neurosurgeon is going to do. Sometimes they talk to a neuropathologist, but you don't do that type of thing on living people. It's only on dead people. She is firm in her opinion. Process of death would start in 15 to 20 minutes. That is, you don't have any objective. Actually, I do. It's based on the severity of the injury and the brain swelling that's observable. Okay, she's not the only one with eyes who can see, oh, hey, look, there's brain swelling here. It's herniating down into the base of his skull, into the foramen magnum. And she just keeps coming back with that. When he asked dumb questions, you saw John O'Keefe's brain in this case after he was dead. Well, obviously, I love the contempt she shows for the stupidity, the dumb questions. I love it. He doesn't know or how to say the Glasgow coma score. He doesn't know how to say any of this stuff. She keeps correcting him. Don't know what you're talking about, do you, Hank? And yes, she can say all of these things and hold all of these opinions because she understands the process. Treatment would not be effective here because of the extent of the fractures. Well, a third of them can survive. Well, she doesn't know what you're talking about. A third of who? A third of who? Remember when Dr. Wolf was on the stand and it was like 66% of his patients die? We focus on how many of them died, but now it's like, but a third of them might live. They might. Perhaps if they have minor injuries. Again, she just keeps coming back to this is an extensive injury, a lot of force. I understand the physiology. No matter what, even if you go with Dr. Wolf's 2/3, 1/3, odds are he's going to die. Soon as you get a basal skull fracture, odds are you're going to die. You're more likely in that 66%. But it's going to depend on the case, how much force, how much swelling. In this case, it started immediately after impact. Brennan just keeps trying to feed her fastballs, and she just keeps knocking them over the center field fence. You know, you don't know, isn't it? You don't know how long. And she just says the brain swelling started immediately after the impact. And what does he have to respond to that? Yeah, that's right. That's right. This expert is up there. Not getting pushed around or intimidated or insecure or anything like that by you whatsoever. It's a medium large force, can't quantify it, but she's comfortable with that because it's based on her training. She doesn't have to be there that night. The body told her what happened, and she knows the time that it took because of how significant the injuries were, the swelling, the fractures. The brain was swollen. You would have to have that to have herniation of the brain stem. So it's not something you have to read that somebody else concluded. She can tell by the process. So just keeps repeating. Yes, you can tell how quickly the process happened because of the injuries. If it was just a single skull fracture, it might be different, but this was major skull fractures, so major force, so the brain swells rapidly. We got into the periorbital ecchymosis and the causes of that. Hank is really trying to focus in on, the brain hitting it. It's not from, application of force from like the face side. But she also acknowledges it can radiate. It can happen within minutes because as soon as the skull is fractured, as soon as the orbital bones are fractured, that leakage is going to start. And so depending on, I would think, how bad it is, you could potentially start to see it within minutes. May not be fully developed for a while, but you might be able to see it within minutes. Every wound is different. Oh, but do you have a particular article about the time or about, time for the ecchymosis to begin to develop? No, she doesn't have one, sir. It's all of her experience. I could look it up and bring it to you. Is he going to take her up on that? I doubt it. So the wounds, it depends on the impact surface. They could be different. In this particular case, she saw the photos of the general area. I love how she keeps coming back to the general area because that's how Yuri excused not documenting specifics. Well, it's all in the same general area. That's right. You liked that? You liked that tasty meal when you were serving it up? Go ahead and have a bite yourself, Mr. Brennan. Go ahead and chew on that for a little bit. You can't see what's under the dirt and grass, though. Well, you dumbass, the dirt is under the grass. What kind of dumb question is that? The dirt is under the grass. It's smooth, it's flat land, there's grass on it. The baseball hat would not cause that pattern. If he's on an incline, he could slide, but after falling, the body is not really going to move. You just have, some momentum from the impact, but it's not going to be significant. 1 to 1.5 vertical abrasions to her. Just to repeat, he landed on something with a ridge. There was just a little bit of movement to cause scratches, and there's a pebbly-like surface. Then the brain is soft like tofu. Ooh, that's disgusting, but it depends on what kind of tofu. At least he didn't ask her, can you stick your finger right through a brain? So she agrees it's a radiating fracture. It started from the back. And, possible that the brain movement also contributed to that. But of course, the basal fracture has to do with those eye injuries. No depressed fracture here. That's when something pushes the skull inward. That can happen with a blow from a sharp or a pointed object or from a hammer. As far as the patterned injuries, they are superficial abrasions. She agrees. Most are teeth scraping, but there's possibly some punctures near the elbow. So then points to 6 or 7. I see 6 or 7. It's a point-like penetration of the skin. She sees 6 or 7 things that she identifies as punctures, and she agrees. Medical experts can disagree when you come to classifying the injuries like that. The wounds from the broken shard, it would have come from a different angle and would have been more random. Then Hank asked, you considered the motor vehicle a possibility in the differential diagnosis of a motor vehicle collision. She knew about the details in this case. Let's go list through all the things she didn't consider. It doesn't matter because the car didn't hit him, so it didn't matter how fast the car was going. So no, she didn't consider that. She can tell by looking at the body. Another little wall you walked into there, Hank, with that one. That was that was almost like a bouncing Betty. Like that one, you just stepped on that and set off a disaster right there. Walked right into it. Doesn't really care about the defendant's statements either. She's just very good at being dismissive of the stuff that doesn't matter. Reaffirms severity of the impact resulted in immediate unconsciousness, and then she doesn't know exactly what time the injury took place, but that after that, there was no purposeful activity. Hank's trying to tie her in with the phone data. He would have stopped moving after 12:32, and she sidesteps that. I don't know what time it was, just that after that, he would not have engaged in purposeful activity. So then we had to break for lunch early so that Hank can bring up the sidebar about how he wants to smear the doctor, since he's not getting anywhere other than punching himself in the face with cross-examination on the substance of her opinion. Now he needs to come back and smear her. So you got to review all the ways he wants to smear her. The audit from 2005, when she was the medical examiner of Rhode Island. Oh, I can't wait to see if he's going to try to use some of this lingo, leaving bodies unattended with her, how she's going to maybe respond to that. I'm looking forward to see how that kind of exchange goes. The Station nightclub. Now, he said she implied that there was somebody like failed by not going to the scene. Perhaps I missed where she said anything about that at all. Who did she accuse of not going to the scene? Who did she say needed to go to the scene and didn't? She's been very consistent that the medical examiner routinely relies on photos. So I don't know where he gets that argument from. This sounds to me a little bit more like Hank just making stuff up again. I don't remember that at all, but if anybody in the chat remembers that, who was supposed to, go to the scene but didn't? I don't think she's ever said like the medical examiner should have gone to the scene. Then of course the Tompkins case we heard about. Now there's this new case where the court said, in this situation, he disagrees with her, thinks she destroyed her credibility. This is classic. Not admissible for a whole lot of different reasons. You have constitutional implications when you go in and try to introduce somebody's opinion about another person's credibility, because the opinion on credibility is one of the ultimate issues in the case. It's for the jury to decide. So other people's opinions are not particularly relevant. But then we also have Section 608 in the Massachusetts Guide to Evidence that talks about like general impeachment, character for truthfulness or untruthfulness. That's what this is getting close to, right? You're trying to say she's a hired gun. She just said whatever without regard for being truthful, because she was being paid to in that case. But it's very clear under those guidelines that you can bring in reputation evidence, general reputation in the community. If he's got folks that would come in and say, Elizabeth Laposata has a reputation among expert witnesses, prosecutors, lawyers, whatever, as being dishonest, as being a hired gun, as being willing to say anything as long as you'll pay her, reputation evidence is admissible. However, specific instances of misconduct showing the witness to be untruthful are not admissible for the purpose of attacking the witness's credibility. This is a specific instance. This is a specific case he's trying to bring in to say, look, she lied in this case, therefore she's a liar. You don't get to do that. It's plainly clear under the rule that that's not the way you get to impeach somebody for something like that. So pushback on the audit from Mr. Jackson, a little bit more context of what was going on. It was a political dispute. It had to do with the time that it was taking for reports to be issued, nothing to do with bodies being left unattended, no issue with regard to negligence or malfeasance. It was simply a backlog of completing reports, and it was based on different priorities between her and the incoming medical examiner. Brennan himself has hired Laposata 4 to 5 times. Ha! Love it. Love it. Love it. Brennan gets up and says he just makes things up. He hasn't hired her. He just makes it up. Oh, it's almost as if this witness on the stand might have knowledge, Mr. Brennan, of how many times you've hired her and what for. Almost like she might have told that to AJ. Why don't we ask Dr. Laposata, Hank, shall we? Shall we ask her about your guys' relationship? I think that would be a fun voir dire myself. But then he goes and tries to imply that it's because of her. You know, I won't disclose why I don't use her anymore. I did use her, and I won't disclose why. Well, she probably thought you were a jackass and expected her to sell, her words to you, support whatever you wanted her to say for money, and she didn't. Just putting it out there. Maybe that's a guess. She wasn't useful to you anymore, Mr. Brennan. That's why you discard people. So Bev is going to allow the backlog at the Rhode Island Medical Examiner's Office and the station nightclub stuff because it's already come up. She's going to read Patino over lunch. Then we go through this ridiculous slide-by-slide objection to Rentschler's PowerPoint, where all, 99% of it is fine, but he just doesn't think it should be in a slide. He doesn't want it in a slide. And it's actually giving that.
Back to session, you may be seated.
All right, the jury is coming over. I just wanted to tell you what I was able to do during the lunch break. So, Mr. Brennan, you argued for 4 points of admission regarding this witness. I'll allow in 1 and 2. I've had a chance to look at 4. I think I already told you I would not allow in 3 because I've already considered it. I've now looked at the 4th one, the case. I'm not going to let you get into that during cross-examination. If the door is open and you think you can get into it after redirect, please come to sidebar.
Thank you.
All right. And also, I had a chance to look at the actual exhibit regarding what came into evidence from Dr. Welcher and Ms. Little. Contrary to what you said and what Mr. Alessi was nodding to, page 136 did not come into evidence. It's a blank page. So that PowerPoint did not come in. I had a chance to look at Dr. Rentschler's PowerPoint, and at least for now, maybe you can persuade me otherwise, any text that has hearsay on it that you say will help assist the jury, what I want to say is I think we have to give the jury some credit here, okay? They have been listening to this case intently for weeks. I don't find that anything that you've recommended here comes in to assist the jury is necessary to assist the jury. So before Dr. Rentschler testifies, those slides that were objected to that have text are out.
Can I have a moment just to examine the Dr. Lopata PowerPoint?
No, not right now. You can look at it, yes. You can look at it while we're bringing the jury in.
Okay, because we have 4 copies of the PowerPoint, and I know that I'd like to be able to. 137 is the report. So you can
Mr. Alessi, please. (136), 137, and 138 are all blacked out. All right, are the jurors here? Are the jurors on their way, right? Okay.
Got it, guys. Words aren't helpful. Words aren't helpful. It's hard to keep track of like what's so obvious that the jury, you know, can decide for itself. Like, you know, police investigations and stuff like that. So obvious the jury can decide for itself. You know, what's already in evidence in the case that the accident reconstructionist relied on. Not helpful. The jury can't possibly know that. But guys, you need expertise. You need very special expertise to be able to count the number of holes in a sweatshirt and also count the number of wounds on an arm and see if they match. Did you realize that's beyond the scope of expertise of an ordinary layperson? You need a textile expert to be able to do that. So just as long as it's real clear that you know, the jury is completely competent except for when they aren't, you know, understand that and you'll be able to perform a trial perfectly well in this courtroom. Just bear that in mind.
Court is in session, please be seated.
All right, Mr. Brennan, whenever, I'm sorry.
Thank you. Good afternoon, Dr. Laposata.
Good afternoon.
Are you on point now?
You are.
You were asked on direct examination about your qualifications. You were a medical examiner for the state of Rhode Island, is that fair to say?
Yes, I was the chief medical examiner.
For 20 years?
12 years.
I'm sorry, 12 years. When's the last time you worked as a medical examiner?
In 2005.
When's the last time that you conducted an autopsy?
I've done probably a handful of autopsies, private autopsies in my consulting practice.
Since 2005?
Correct.
When do you think the last time you did one is?
Maybe 4 years ago, four or 5 years ago.
4 or 5 years ago?
Yes.
Okay. Since you left the medical examiner's office, have you had any specialized training in brain injuries?
It's all part of keeping up with the medical literature and knowing the forensic pathology literature, reading medical literature. So it's a continuing endeavor to keep yourself educated with medical updates.
Since you left the medical examiner's office, have you had any specialized training in brain injuries?
I've not gone to a course on brain injuries.
Since you left the medical examiner's office, have you taught any students on brain injuries?
Yes.
Have you given any classes or seminars on brain injuries?
Yes, I have.
And coup counter coup, how many times have you experienced that as a medical examiner, that condition?
Well, I myself haven't experienced it, which was good, but in cases, hundreds of cases, it's a common injury.
You said you did differential diagnosis. That is to exhaust any potential bias you have, correct?
Well, a differential diagnosis is to think, how many ways can you get this finding? And it does help prevent bias.
Did you say on direct examination part of the benefit of differential diagnosis is to make sure that you don't have a bias?
Yes, yes.
In order to eliminate bias, you're supposed to look at all reasonable alternatives, correct?
Yes, that's part of it, making a differential diagnosis.
So you don't just look at a person's body, come to a conclusion, and ignore other evidence. That would kind of defeat the purpose of differential diagnosis, wouldn't it?
Well, you always have to look at all the evidence.
And so if you didn't look at all the evidence and you disregarded some of the evidence because you had already made up your mind, that really wouldn't be the proper study of differential diagnosis, would it?
Right, I don't do that.
I'm sorry, ma'am.
I don't do that. I always look at all the evidence.
And would you look at all the evidence even if it was contrary to whatever opinion you want to give in court?
Well, the evidence allows me to come to an opinion. So it's not like I decide on some opinion I want to give and then look for the evidence. The evidence is going to tell me what happened to the body.
So you would never say, like, I don't need to look at that evidence. If it's presented to you, you would look at it and study it and consider it in differential diagnosis?
Sure, it may or may not apply, but I'd look at it.
Because if you did that and said, well, I don't need to look at this, and it was relevant evidence, that would defeat the whole idea of differential diagnosis, correct?
Well, you always want to look at all the evidence that's going to help you decide what happened to the body.
If you were to ignore relevant evidence because you already made your mind up, that could create some type of bias, even if you're not recognizing it, correct?
Well, I don't make my mind up. I make it up on all the evidence I have. Then if something else other evidence comes up later, I have to reevaluate everything and consider that new evidence.
When you were talking about car collisions, I don't want to belabor the point, but you didn't major in physics, did you?
In what?
You didn't major in physics, did you?
No, I took physics, but no, didn't major in it.
Okay. And the last time you took physics was probably, what, undergrad?
Correct. Thank goodness.
You have no study in biomechanical engineering?
No, I'm not a biomechanical engineer.
Understood. You never taught courses in accident reconstruction, have you?
Only in terms of looking at the injuries on the body and showing how that they could or could not have occurred from impact with a motor vehicle.
Have you taught classes in accident reconstruction?
Only as far as it would affect the findings on the body.
Do you know what I mean by when I say accident reconstruction?
Well, accident reconstruction meaning, and I'm telling you that my expertise in accident reconstruction is restricted to looking at the body and then understanding how impacts may or may not have occurred to the body. I don't take a car and look at mileage and such like that.
You don't do any studies of the actual vehicles, you're focused on the body?
I'm focused on the body, but I also look at the vehicles to look at the points of impact that might be possible.
You do not have any advanced study in biomechanics, do you?
No.
Okay. Now, you had mentioned that when you were in the medical examiner's office, you had a number of higher profile cases.
Well, every case is important because somebody's dead.
You pointed out some pretty specific ones on direct examination. Were those more important, the ones that were highlighted, or is that the same as every other case?
I don't know what you're talking about.
Well, you had mentioned the Egypt airline crash, Station nightclub fire. Those were highlighted or pronounced on direct examination. Are they equally important as every other case?
Oh, absolutely. Every person is my patient.
You talked about some of your commendations. The Station nightclub fire, you received quite a bit of criticism on that, didn't you?
Well, there was a flurry of negative press without any basis.
You had mentioned that a doctor, a medical examiner, should have gone out to the scene to look at the area where John O'Keefe was found to make observations. Did you suggest that in any way on direct examination?
You have to know what the scene looks like, and usually that is documented in police reports and in police photographs who document the scene.
The Station nightclub fire, that had numerous victims, didn't it?
Yes, 100.
And you received criticism because you were repeatedly requested by emergency responders and police officials to come to the scene, and you refused?
That's incorrect. First of
Okay.
all, nobody called me to come to the scene, and medical examiners are not first responders. As soon as I got a call that there was that fire in the nightclub, my investigator went right to the scene, and I was in constant communication with him throughout the early morning hours of that horrible accident. And I went into the medical examiner's office because I had to start getting ready to run our office 24 hours a day to not only take care of the poor individuals who expired in the nightclub fire, but also the regular work of the medical examiners. So there was no need for me to go to the scene because I had my investigator there, and my job would be at the office to get things all set up to handle the influx of deceased.
Did you receive criticism that over 17 hours there was an effort to have you come to the scene, but you refused?
There was,
I'm going to allow it in a different form.
yeah, that's incorrect.
Hold on,
Oh, I'm sorry.
Oh, no, I didn't mean to scare you. Just
Okay.
hold on for a second.
Yuri loves her. Yuri loves her.
Did you receive criticism that officials?
I'm going to allow it.
Did you
based on the
receive
ending.
criticism?
Pursuant to the ending, let's hear it.
Did you receive criticism that for over 17 hours officials were asking you to come to the scene and you refused?
It was untrue. It was printed in the newspaper. We looked up all the phone records and provided it to the newspapers and showed that nobody called me to go. I would have gone if I needed to. I had my investigator there. It was just bullshit. No, it was erroneous stuff.
You said it.
Was there other criticisms in 2005 before you left the office?
No, there was a flurry of stuff in the papers. There were union issues, new director of health, new governor. So yeah, there was a little flurry of stuff, which was not substantive.
So you inevitably did resign in 2005.
Yes, because my budget was going to be cut, and I knew that if I had to get rid of a medical examiner, we couldn't do a good job for the state, and I'd done it. I'd been chief for 12 years. I'd been on call 24 hours a day for 12 years, which was an honor, really. But then if I couldn't do a good job, if we cut the budget, I had to get rid of a medical examiner. I couldn't serve the people of Rhode Island well, so I resigned.
Did you resign shortly after the audits and criticism?
No.
Same year?
Oh, I don't even remember.
Okay. After you resigned, you opened your own company?
Yes, I started an independent consulting practice.
How much of your business is consulting?
It's a consulting practice.
Yep. How much of your business, how much of your income is consulting?
100%. It's consulting.
Do you consult in both criminal and civil cases?
Yes, I do.
What percentage of cases are criminal cases?
It's maybe half and half.
Half criminal, half civil?
I don't keep track of it in that way, but that would be a guess.
I'm sorry, I'm sorry, I didn't hear you.
I don't keep track of numbers of civil or criminal cases that I'm consulted in. If I had to give an estimate, it would be half and half. I've worked on over 1,000 cases in my private company.
And fair to say you get compensated for your time?
Yes, I get paid for my time.
Dr. Laposata, you had mentioned that there were some scratches that you had taken a look at on Mr. O'Keefe's body. If we could have Exhibit 165, please.
Boy, did that all fall flat, didn't it?
Now, would it be fair to say, Dr. Laposata, you do not know the genesis of that cut on Mr. O'Keefe's right eye?
I do not know what caused it. I can tell you what didn't cause it, but I don't know what did cause it.
You said that was from blunt force?
It's from application of blunt force to that little area that broke the skin.
When you were asked a question about whether that was consistent with a punch, You opine that it was consistent with a punch, yes?
It could be consistent with a punch.
You weren't saying it was consistent with a punch to a reasonable degree of medical certainty, were you?
He actually wasn't
That would
asked
be
that.
within my differential diagnosis.
It could be consistent with all other types of blunt impact, or many other types of blunt impact, couldn't it?
That's correct.
Ground, perhaps?
No.
No, an object?
If it was an object that could get into that area under the eyebrow, yes.
You mentioned the spoiler on the back of Miss Reed's Lexus. Do you remember that?
I remember that.
Do you know how tall John O'Keefe was?
He's around 7 foot, 5'11", I think, 7'2", something around in there.
No, he's more closer to 6'1". Does that make sense?
Sure.
Okay.
He got lost on 70 inches,
And
71 inches.
That spoiler on the Lexus, do you know how high off the ground that is?
No.
Did you ever try to measure it or ask for photos or any information about that?
I looked at the photos.
Did you ever ask for any measurements or try to take any measurements?
No.
Could I have Exhibit 166, please?
Oh God, the blue paint.
Did you see this cut on Mr. O'Keefe's nose?
Oh no, okay.
That's a scratch. It's not made by a sharp instrument. It's not a cut. It's a scratch.
Is there any scratches on the left side? Do we have a photo of the left side? Please. And that, you say that's a scratch, not a cut?
Correct, because a cut means it's made by a sharp thing, like a knife, and a scratch is made by something that's kind of rounded that has a little point on it, but it's not sharp.
Okay. Do you have any information or basis to say where that scratch came from?
No.
Did you do any differential diagnosis on that scratch?
I don't know what caused that. There could be a number of things that caused it.
There was no scratch on the right side of Mr. O'Keefe's nose?
I don't see one, no.
Could you zoom in, Ms. Gilman? So the only scratch is on the left side?
Looks to be, that's not a good photograph because there's some blood obscuring the skin.
Yes.
If my memory serves me, there is a scratch on the left side of the nose and maybe a small scrape on the tip of the nose.
And we can go back to the left side? And you said that could not have been caused by a sharp object?
Correct. It's not an incised wound. Incised wound means a bladed, sharp cut. This is a scratch, not made by a blade.
Were you aware the defendant made a statement that she pulled a piece of glass from the defendant's nose?
No.
And
You
you
don't
would
know
say
that it was from here.
wound is inconsistent with being caused by glass or a sharp object?
It would not be caused by a blade. It could be caused by a piece of glass that was thick.
I thought before I offered you that statement, you had said that it could not have been caused by glass. Do you now have a different opinion?
I don't remember saying it couldn't have been caused by glass.
Didn't you say it couldn't have been caused by glass or a sharp object?
A sharp object.
What
Like a sharp object, like it's not an
take that down, please.
incised wound made by a blade. It could be caused by something sharper that's thicker, but does not have a thin blade. So it could be caused by a thicker piece of glass.
If somebody is deceased, does any blood pressure from their heart still move in their body?
No, they're dead.
If somebody removed a sharp object like glass from somebody's face, would they spurt blood if they've died?
If you're dead, there's no blood pressure. So if you're dead and you remove something, there may be some superficial blood, but it's not going to have blood flow because your heart's not pumping blood out of the cut ends of the blood vessels.
So it's not going to spurt if you pull something out of a person's
Almost
skin
like
if
Karen
they
didn't say
pass.
spurt.
You wouldn't get a spurt of blood from arterial pressure.
I just want to ask you a very few questions about hypothermia.
Sure.
You mentioned that Mr. O'Keefe's body temperature at the hospital was 80 degrees,
Yes.
and there's different ways to take somebody's or body's temperature, isn't there?
Yeah, that was a rectal temperature, so that's a good representation of the body temperature.
Okay, good to know.
Is the variance between a common practice of taking temperature and by somebody's mouth and rectal, is it about a 3 or 4 degrees difference, or do you have a different experience?
It can be different. A rectal temperature gives you a better internal body temperature. The oral temperature, if you're breathing in or if you just had something cold in your mouth, may not register a proper temperature. So the rectal temperature is the preferred temperature for a medical diagnosis.
98.6 is an important temperature, isn't it?
Yeah, it's our usual normal body temperature.
And so, is there a standard? Is 95 degrees considered hypothermic?
If you have, then clinically you would start to worry that the person might be experiencing bad effects of hypothermia.
At 95 degrees?
At 95, you start to worry about it.
And could some of the things that happen is labored breathing?
Is what?
Labored breathing?
What about labored breathing?
Well, if someone is hypothermic, if they're 95 degrees, does it affect their breathing patterns?
Not especially.
Okay. Does it affect the way their respiratory system works?
No.
Does it have any effects on the human body if you're hypothermic at 95 degrees?
No. You're still okay.
If that temperature continues to decline, it starts to become dangerous, doesn't it?
It can.
Mr. O'Keefe was evaluated, and at the hospital, his body temperature from a rectal reading was 80 degrees at about, what, 6:37?
Correct.
Did you know that before he got to the hospital, first responders had him in an ambulance?
Of course.
Did you know they turned the heat up and put blankets on him and tried to provide warmth to him before he got to the hospital?
Yes, that would be standard practice.
And that standard practice would usually add temperature to the person, wouldn't it?
Well, it might.
So it's possible it could, but it might not.
It usually doesn't add that much.
I see. And so inevitably, at 6:37, Mr. O'Keefe's body was 80 degrees.
Yes, when he got to the hospital, his rectal temperature was 80 degrees.
And so that is a drop from the standard, or what's expected, of 98.6 degrees. That's a drop of at least 18.6 degrees.
Yes.
You mentioned that Mr. O'Keefe, after suffering his head injury, would not have moved other than twitching.
Correct. No purposeful movement.
Were you aware that he had an iPhone with healthcare data on it?
No.
If there's no movement, assume for a second there's no movement of Mr. O'Keefe after 12/32/16, and he's found a little after 6 a.m. in the morning. That's about 5 hours or 5.5 hours, correct?
About.
And if somebody is in the cold for 5.5 hours, that's consistent with dropping from 98.6 degrees to 80 degrees in body temperature, isn't it?
If the person is dead, yes.
If a person is outside in the cold and still alive, will their body temperature decrease?
If they can, people can die of hypothermia, but that's not the case here.
Well, not the ultimate death, but if somebody's outside and they're alive and they're lying in the snow and it's below freezing, will they lose body temperature?
They will, especially if they're not bundled up well.
And body temperature can drop from 2.5 to 4 degrees an hour?
in a dead body.
Okay. In a living person, it can drop 1.5 degrees.
No. A dead body at room temperature will usually lose body temperature at like 1.5 degrees an hour. If a dead body is in a cold environment covered with snow and avalanche environments, the dead body can cool at 4 degrees per hour.
And so a person who is in cold conditions, starting to be covered by snow, less than freezing, they can lose body temperature when they're living, can't they?
If you're sure, you can. People die of hypothermia, but that's not the case here.
Well, someone could be alive, lose body temperature, and not die. That can happen, can't it?
Yeah.
Right. So if someone is in the cold, let's assume they're not dead for a second. They're in the snow, below freezing, not moving. Can that person lose body temperature if they're still alive?
Sure. They just lie there. They can become hypothermic and die.
Even before they become hypothermic, can they lose body temperature?
Well, losing body temperature makes you hypothermic. Thermic is temperature and hypo means below. So your temperature goes down and you're hypothermic because it's going down.
And people can survive from being hypothermic if they get the right care.
Sure.
And so in that 5.5 hours, it is consistent with a person being outside in the cold and starting at 98.6 and ending at 80. That's consistent with being in the cold for 5.5 hours, isn't it?
For a dead body, yes. That's how a dead body would cool in a snow-covered cold environment.
And it could also be consistent with somebody who is alive for some time and then dies, correct?
I don't understand your question.
Somebody could be out in the cold, under the snow, sub-freezing. They could be alive for some time. Their body temperature could drop. And then when they pass and die, their body temperature could continue to drop probably at a more rapid pace. That still fits within 5.5 hours, doesn't it, Dr. Laposata?
No.
Because if someone can drop 4 degrees of body temperature in an hour,
A dead body.
yes, it would only take about a little over 4 hours if it was at 4 degrees to go from 98.6 to 80. Yes?
Correct, yes. So he was exposed to that cold environment for 4 to 5 hours.
If somebody was alive for a couple of hours, it's a lower rate. Say they lose 3 degrees. And then,
You don't
after that
lose 3
couple
degrees
hours,
as you're alive.
they lose body temperature at 4 degrees. That
That's
would
what she
still
said.
fit and be consistent with a drop from 98.6 to 30 degrees,
No.
to 80 degrees, wouldn't it?
No, you were saying a dead body cools in a cold environment at maybe 3 to 4 degrees an hour. And that has nothing to do with a living body and how long they can stay at a body temperature.
Do you disagree that somebody could be alive, lose body temperature, out in the cold, freezing temperature below 32? They could lose body temperature at a certain rate, then die, and then continue to lose body temperature. Is that possible?
Anything's possible. It's just what's important is what happened in this case.
I'm asking for your medical opinion, though, rather than to be an advocate. As far as your medical opinion,
So sustained, and I'll strike that.
as far as
Dr.
your,
Laposata,
Yes.
could you listen to the question, please?
Of course, thank you, Your Honor.
as far as your medical experience, could somebody be alive, outside, in the cold, below 32 degrees, not moving, covered by snow, still alive, and lose body temperature?
Sure.
And then could they, after an hour, 2 hours, could they then die and continue to lose more body temperature?
Sure.
But not here.
You mentioned your opinion about injury on Mr. O'Keefe. And at one point you said that his injury was inconsistent with a taillight, and you said because there was no damage from the bumper. Do you remember saying that?
I don't think I said it quite that way.
Okay. Do you remember how you said it?
No.
Do you remember discussing or raising the issue of a bumper as part of your equation, that the injury to Mr. O'Keefe was inconsistent with the injuries?
He has no injuries on him that are consistent with being hit by the back of the SUV. That includes the spoiler, that includes the bumper.
Okay, if we could play video E, please. I want to ask you, Dr. Laposata, have you seen this video before?
The blue paint. Oh no.
No.
Thank you. You can take that down. Did you see anything in that video that would suggest any contact between that mannequin and the vehicle's bumper?
Objection.
I'm going to see you at Sidebar on this for just a minute, please.
What does this have to do with medical? Is she supposed to have a medical opinion about a mannequin? A mannequin is not actually a dead body, so this is really not proper impeachment. This isn't impeaching anything she said. Yeah, there was contact between a car and a dummy. That doesn't have anything to do with his injuries and her medical condition. But it is ironic, isn't it, to see just 5 minutes ago, wasn't Hank going off about how she's not an accident reconstructionist or a biomechanical engineer and not trained to do any of that stuff? And now here we are asking her questions about accident reconstruction and biomechanical engineering. In fact, why don't you critique the actual work of the accident reconstructionist in this case? This is so far beyond the scope of what she has expertise to do. But I sure love how Hank hasn't learned. He hasn't learned how not to open the door for her. Remember raising the issue with the bumper? Yeah, I remember that he has no injuries consistent with being hit by the back of the SUV, either the bumper or the spoiler. Bev had barred that. That wasn't going to be allowed. So thank you for that, Hank. You went ahead and gave that gift yet again of there was no collision. You just went ahead and gave him that gift. Good job. Prime work there. Somehow he thinks like being snide, asking you as a medical doctor, not an advocate. Somehow you think that's going to overcome the absolutely devastating substantive effect of this testimony on your case. This jury loves her. This jury loves her. Okay. When the judge surprised her and she jumped and they all had to soothe her and everybody laughed. The jury loves her. They were concerned about her. When she had that startle scare. I love that she just came right out and called the criticism bullshit. She just came right out and said it. Yeah, there was a lot of criticism of the station fire. It was bullshit. I mean, it was erroneous. Oh, that was classic. That was classic. This woman, she's an absolute gem. Protect this woman at all costs. We're gonna put her and Isaac Perush together. We're gonna crown them on a stage of the king and queen of witnesses. She's just phenomenal. All of your hypotheticals. First off, we're gonna repeatedly point out how you're an idiot because the 4 degrees an hour cooling is dead bodies. That has nothing to do with live people. So your hypotheticals, no, a live body is not going to lie there and lose 3 degrees. That's idiotic. But none of it matters anyway because It doesn't have anything to anything to do with what happened in this case. Nothing to do with what happened in this case. And yeah, as a matter of fact, instantly dying and then cooling because you're dead, it's perfectly within that 5.5 hour time frame. Doesn't make a lot of sense. Makes it a lot harder for John to get down to that 80-degree temperature that he was found at, for him to be remaining alive for any extended period of time. Not capable of intentional movement. We'll just rehammer on that a couple of times. Checking the message from Jen McCabe and hitting the lock button on his phone. Yeah. Sticking the phone back in his pocket. Not going to be consistent with the brain injury. John was not capable of purposeful movement after he received that injury.
All right, so jurors, I am going to strike the last bit of questioning of this witness and the video as it goes to this witness. All right.
Dr. Laposata, after you received materials, did you ever ask for any additional materials?
Let's see, I always make sure I have all the scene investigation, autopsy, medical records, police and witness investigate and witness statements. So I felt I had a pretty complete database. I didn't get the x-rays until a couple weeks ago, so that was delayed.
That was newer?
Yes.
You said a medical examiner has to make a determination in 90 days. Is that the rule?
When you work in a medical examiner's office, when you get a deceased in, our national standards want us to have the autopsy report completed and all the associated tests done within 90 days.
Can investigations occur and the additional accumulation of evidence happen after that 90 days?
Oh, sure.
Okay. Thank you, Dr. Laposata.
That's it. Yeah. 3.5 years later, it could still be happening, couldn't it, Hank? Still waiting to get that homicide finding, are you? You're just hammering home that she hasn't made the finding yet, despite it being 3.5 years of investigation later.
Dr.
Okay,
Laposata.
hold on one second. Jurors, when I strike something, that means disregard it. And what I've struck through this witness, the video that you just saw and some of the testimony means that if it's in evidence, it's in evidence, but it is not part of your consideration with this witness. Okay. All right, go ahead, Mr. Jackson.
May I proceed? Thank you. Dr. Laposata, you were just asked a series of questions about body cooling, correct?
Yes.
Does a body, as it's cooling, does it know if it's indoors or outdoors?
No.
If there's a very cold environment, be it indoor or outdoor environment, would it still cool?
Oh, absolutely.
And it would cool at would it cool at the rates that you earlier described?
Yes.
Even if indoors, if that indoors was cold?
Absolutely.
Your Honor, may we approach along with the Commonwealth very briefly?
So up to 4 degrees, even if it's in a cold inside environment, like, oh, I don't know, like an unheated garage. Like if you were inside in a cold, unheated garage, the dead body would still cool at the same rate. Good point to bring that out. Good point to bring that out, because we definitely know John wasn't out on that lawn since 12:30. We definitely know that. Why do we know that? Because not a single person saw him. None of the people leaving the house. Not lucky. He wasn't there. So we know he wasn't there. But the cooling still works if he's indoors somewhere cold, like maybe a cold, unheated garage. But yeah, it is a natural process. You know, another thing that she, I don't know if it's worth getting into or if we should get into it or not, but the effect of the cold temperature on things like rigor mortis, it's going to slow down the process. Being out in the cold is going to slow down a lot of the ordinary processes of death. And so like rigor mortis is it's like a chemical, my understanding anyway. It's like the process of a chemical reaction as the body starts to break down and you start to have cells, you know, dying, cells, you know, releasing their contents and stuff like that. There's a word for it, but now I can't remember what it is, except that it has lice in it, you know, LYS. That's the Greek root. But it's a chemical process. And so that occurring at a very low temperature it slows it down. Like, probably not always the case. I don't think. I don't know. It's been a long time since I took chemistry. I'm not sure it's always the case that cooling something down will slow the chemical reaction, and that heating it up will speed it up. But I think that's pretty common anyway. You just have more activity in a warmer environment. So I would definitely be interested in how that factors in too, because we didn't hear anything about like signs of rigor mortis when John was first discovered. And if he's been out there for 5.5, 5 hours, you know, whatever, would we expect that or not? Normally, I think everything else being equal, I think you would expect that. I think 5 hours is plenty of time for rigor mortis to start to set in. But the cold environment could potentially slow that. Just be kind of interested in seeing if she can flesh any of that out. Thank you, CH. See the mods. These are my mods. These are my mods. They're on it. Autolysis. Thank you, CH. That was what I had in mind. And it's just the cell wall basically breaks. Like the lyse is it's the Greek root for, I think, cut or something like that. Anyway. Somebody has got some good information here. Sparkly starfish, potassium increases in the blood. Didn't know that. Didn't know that. Today I learned. Chemical, thank you. Chemical degree, lower temperature slows all chemical reactions always. Thank you. I love when somebody can give me an absolute, because of course, as a lawyer, I can't do absolutes. Everything has to be, and it depends. It always depends. And it gives me so much just comfort when we can have certainty about things, right? Like, this is why I found Welcher in particular so offensive with the blasting off into space, because the one thing from an engineering standpoint that we can be certain about with that Lexus is that it did not and could not blast off into outer space. We can actually be completely certain about that. So his acting like that's a "it depends" type of question, was particularly obnoxious to me. So I appreciate certainty when I can get it, absolutes when I can get them, hardcore rules. I'll never forget this now. Lower temperature slows all chemical reactions always. Thank you. I'm so glad that I know that and I can rely on it, especially biological chemical reactions. Now, this makes sense to me, right? This definitely makes sense to me. Your biological being of any kind has to, has a certain range of temperature where it can function. Gets too cold, it can't. Gets too hot, it can't. So it would make sense to me that within, that particular system, you need certain constants for the chemistry to work the way that it's predicted to work. But I'm just trying to imagine like hypothetical scenarios, I don't know, stuff going on at the bottom of the ocean or, inside a glacier, like just, trying to think of extreme environments. I don't think there's a lot of chemical. Oh, I shouldn't say that at all. There's actually probably tons of chemical reactions happening in space, but not like in deep space, Just trying to imagine, are there any sort of chemical things happening where cold isn't necessarily going to slow it down. So I appreciate it as a general rule. I'll take it. I like a good absolute. So only a Sith deals in absolutes. But they're so comforting. They really are. That's why it's so successful for the Sith. That's how you're able to to get more Siths. You're able to get more people coming over to the dark side. Absolutes are very, very comforting. It is. It is. I'm just very skeptical of them. Just recognize it's kind of a limited set of circumstances where we can have absolute certainty about things. But those hard sciences, that's one of them. It's one of those areas where we can have a lot of certainty. So maybe that's just me like fetishizing science or something like that. I'm looking at it from over here in my great, it depends career of the law and imagining how nice it is to deal with predictable rules and laws, ones that actually don't change and behave consistently over time in different contexts, regardless of which person you're talking about. Maybe that's just why I have this have this fetishization of hard science. Boy, doesn't that sound nice? Having rules that that you can rely on. They're always going to be the same, and it doesn't matter who you're talking about. Don't know why this is such an extended sidebar. See, I'm just, this is why I learn about all my mistakes in life. This is how, the chat lets me know. I apparently I should have gone into chemistry. Apparently maybe that would have been a better choice for me. Maybe that would help with, keeping the blood pressure low and the quality of life good and so forth. I don't know. We talked about coping yesterday. I guess I'm good enough at coping with, not having the rules and so forth. Maybe I just ended up where I belong. Chemistry has too many exceptions. I'll bet it doesn't have more exceptions than the law does. Bet it doesn't have more exceptions than the law does. Maybe it would. Maybe it would. Let's find a chemistry equation or some proposition from chemistry that's in the ballpark of no longer than a paragraph long. And let's see if we can come up with 251 pages of exceptions to it. Just putting that out there hypothetically. Still quiet, but just camera guy getting ready to trying to give us something to pay attention to. Nirav Singla tells us rigor mortis occurs as the body needs ATP to relax muscles. Since the person is dead, no ATP, hence the muscle is stiff. This makes great sense too. Makes sense too. So you're going to have, I would assume, you're going to have some it's gone. And so that's going to be why there's a little bit of a delay in the process.
Yes, thank you. Dr. Laposata, stand back here for a quick second. Before I sat down the last time, I asked you a little bit about x-rays.
Yes.
And the effect of x-rays on an evaluation by a forensic pathologist. Do you remember that?
Yes.
Are x-rays important for a forensic pathologist to consider?
Yes, they are.
Did you find any, you reviewed the x-rays, correct?
Absolutely.
I'm going to relegate my question to just the right arm of John O'Keefe.
Yes.
Did you find any deformities, defects, breaks, fractures, or hairline fractures of that kind on any of the x-rays that you reviewed?
None.
May I approach your Honor?
Yes, I have a question for you. When you printed these, did you print them from a flash drive?
May I have a look?
Sure.
I have some assistance with this.
Because you have them up on the,
We do have electronic versions of this.
why don't we do that instead of the big, the large?
As long as I can mark the large ones, I want those marked and moved into evidence for reasons that we discussed at sidebar.
So those will be, you're objecting to this, Mr. Brennan? Okay, well, even if the Commonwealth objected, I'll allow those in, but I'd prefer to give the jury a flash drive with these on them instead of these big. So we will mark your flash drive, and you can just go ahead, do it in evidence. We'll mark the flash drive. The flash drive will go in with the jury rather than these very cumbersome additional pieces of paper, and you can go ahead and show them.
If I did, I don't want to have full discussion in open court. If it,
All right, jurors, we're going to make this one really quick.
Judge, you're literally the one that's making this difficult. You're the one that's necessitating this. Cumbersome pieces of paper, really? Cumbersome? Big pieces of paper? You know how cumbersome it's going to be for the jury to look on that thumb drive? That's what it's really about, isn't it? If they want to go in and look at it in the jury room and it's on the thumb drive, they're going to have to ask permission, and then you know. Then you know that they want to look at it, and you know that they're interested. There is... Guys, you know, I know I'm a dinosaur now, but back when I started doing trials, you didn't have all these thumb drives and these digital exhibits and things like that that come into evidence. Surprisingly, for hundreds of years, people functioned just fine by putting their exhibits on large pieces of paper like this. And it didn't cause any undue burden for anybody. It wasn't a problem. Doesn't make it better or worse evidence. It's just a large piece of paper.
thank you so much. Sorry. I'll show these to you and then I'll put them on an overhead. May I approach, Your Honor?
Yes.
Do you recognize this document?
Yes, I do.
How do you recognize it?
I recognize it by the medical examiner identification of Mr. O'Keefe, and I recognize the x-ray of the right hand, the right wrist, the right femur, and I can also tell by the R designation here that that's the right side of the body.
Is this what you reviewed in coming to your opinions and conclusions concerning injuries to his right hand?
Yes.
Thank you.
So these now will mark whatever the next exhibit in A, B, and C.
A, B, and C, yes, Your Honor.
The HHH is now 229A.
May I approach, Your Honor?
Yes.
I'm sorry, I need to wait. May I approach?
Yes.
Dr. Hughes, is here.
Sure.
Do you recognize this document?
Yes, this is a x-ray of the body of Mr. O'Keefe from the medical examiner's office. The R indicates the right side, and we see here the two bones of the arm. There's no injury to them. We see the pelvis bone. There's no injury to that bone. They're perfectly normal, and there's no abnormal soft tissue swelling. It's a normal right arm.
Thank you. I mean, it's marked as next to your B.
That may obviate the need to put it up, right?
It could.
229B.
May I?
Yes.
Thank you. Doctor, do you recognize this document?
Yes, this is another x-ray at the medical examiner's office of Mr. O'Keefe. And again, it shows the right side. We see some of the ribs there. We see the shoulder and the humerus, the upper arm bone. And the upper arm bone is totally normal. There's no soft tissue swelling around it. There's no breakage or microfractures.
Thank you, doctor. With the court's permission, next in order, sub C is in Charlie.
Yes.
Dr. Laposata, that's all I have for you. Thank you for coming.
Anything, Mr. Brennan?
No, thank you.
All right, Dr. Laposata, you are awesome. Thank you, Your Honor.
You are all set.
All right, is there anything else today?
May I have a moment?
Yes.
Are we going to start with Rentschler or not? Maybe not.
John, may we approach?
Okay, jurors, feel free to stand up and stretch.
Oh, man. These jurors. Jurors can't catch a break, can they? They get brought in late after being told, guys, we're going to absolutely make sure that we do it on time today. We have all kinds of sidebars. We have the extended lunch when they're out because court has to hear all this argument. Sidebar, 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 sidebar. Remember, she's told them we're going to try to minimize this, guys. Sidebars really shouldn't be necessary, but we are in the defense case now, and so we can't be too cautious if the defense is trying to present evidence. We really have to make sure that they're not doing anything untoward, like defending their client.
Your Honor, with the court's permission, I would ask the court to invite Dr. Andrew Rentschler to join us.
Okay. I'm going to start with him. Great. We can at least start getting through his qualifications and so forth before we go into the PowerPoint, or maybe start the PowerPoint. I'm excited. I've been waiting. I've been waiting for Dr. Rentschler. I feel like the defense case this time has been structured to lead up to him.
If you're so sure the evidence the court and jury in the case down here is for the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I'm ready.
Feels good.
From the lovely city of Pittsburgh, all those beautiful bridges.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Sir, could you please, pull that to you. You're a little on the tall side. Pull that to you right up under your chin if you can. And in a nice, clear voice, tell the jurors your name and spell your last name for us, please.
Dr. Andrew John Rentschler, Rentschler.
Sir, what do you do for a living?
I'm a biomechanist, a biomechanical engineer, and an accident reconstructionist.
Where do you work?
I work for a company called ARCCA, LLC.
Tell us a little bit about ARCCA. What is ARCCA?
ARCCA is an engineering consulting firm. So we do litigation type work, both civil and criminal, where we look at, for instance, I do biomechanics. So I look at injury causation in different types of events, motor vehicle accidents, pedestrian, automobile incidents, sports related injuries, industrial accidents. We also do accident reconstruction, as well as all types of really forensic type engineering. And we also do R&D, research and development, for private and governmental entities.
What's your current title?
I'm a vice president and director of biomechanics for the Midwest Division.
The director position that you hold, that's the official position at ARCCA?
That's correct, yes, sir.
How are you ARCCA's senior biomechanist?
I'm one of them, yes.
And how long have you held the position of director of biomechanics and human factors?
It's been at least 5 years. I don't recall exactly how long.
What exactly does is it biomechanist or biomechanist?
Biomechanist, yeah.
All right, I'll get it right by the time we're finished. What is a biomechanist? What do you do?
So a biomechanist really looks at the human body, and we look at the response of the human body to forces and accelerations. We apply traditional engineering, but to the human body. So a mechanical engineer, for instance, might look at a piece of steel, and you know the dimensions and size of the steel. If you apply a force in a certain direction with a certain magnitude, that steel will bend and eventually it'll break. Was a biomechanist or biomechanical engineer, I do the same thing, but I look at the human body. How much force has to be applied in what direction to get a specific type of injury? Whether it's a fracture of your humerus, a concussion, intervertebral disc injury, any type of injury has what we call an injury mechanism. So we look at the response of how the body reacts to forces in different environments. Ultimately, our hope is to actually help prevent and mitigate accidents. You know, motor vehicle incidents, we look at the design of airbags and seatbelts, sporting equipment, how can we reduce concussions and injuries associated with that. So ultimately, we try to figure out how to make the environment and the world safer for people in whatever type of interaction you might have.
Is that sometimes called injury causation analysis?
It is. That's one aspect of it. Injury causation analysis is looking at how an injury occurs. So if someone sustains an injury, as a biomechanist, I can look at the events surrounding that incident and determine how the injury occurred. Now, how someone was positioned, how much force had to have been applied to certain parts of their body to actually produce a given injury.
Why is injury causation analysis important in the broader field of biomechanics? Why do you want to know the causation of certain injuries?
Well, like I just said, our main goal and interest is to really mitigate and prevent injuries from occurring. So in order to do that, you have to know how they occur. You have to know, for instance, hockey, we do a lot of work with the NHL, how certain injuries occur, cervical injuries, concussions, shoulder injuries. So if your intent is to prevent injuries in certain settings and situations, you have to study how the body reacts, how those injuries are created, and then you can determine or attempt to determine how to prevent them from occurring in different events and situations.
What sort of contracts or commissions does ARCCA routinely engage in?
We have a number of different contracts. We've worked in the past with the United States military. I helped design what we call the energy absorbing seat for the MRAP vehicles.
Hold on 1 second, Dr.
Sure.
Okay.
For the MRAP, which are the mine-resistant, ambush-protected, armor-plated vehicles that they had over in Iraq and Afghanistan. And the issue there is that when they go over an IED, an improvised explosive device, it would blow the vehicle up off the ground. So we were seeing very severe accelerations and forces going through the vehicle, through the seat, into the soldiers' spines. And we're seeing severe spinal and head injuries as a result of that. So we worked with the military to design what we call an energy-absorbing seat design. As the vehicle gets blasted up off the ground, the seat's designed to absorb that energy and that force from the blast and the movement of the vehicle and help protect the soldier's spine. We also, as I said, do a lot of work with the NHL. We work with the Department of Player Safety there, the National Hockey League. We look at the equipment, we look at helmets, trying to help prevent concussions, skate guards, how to prevent cuts and injuries due to the skates. One of the big things we did was actually redesign part of the rink. It used to be at the player area, at the end of the player area was a 90-degree stanchion of plexiglass. And what was happening was players were getting checked into the boards at the player area and then slamming up against the glass. And they were sustaining head and cervical injuries. I've mentioned before, it was actually the Boston and Montreal that caused the NHL to take a look at it, the hit of Chara on Pacioretty. He sustained a concussion and a cervical fracture. So they gave us part of the rink to the Winter Classic, the outdoor contest, and we used crash test dummies, hybrid 3, 50th percentile male dummies, and threw them into different configurations of glass. And ultimately, the new design that we developed is a curved piece of spring-loaded Lexan or plexiglass. So now when the players get checked into the boards, it absorbs that impact and they glance off of it. And it's helped prevent and pretty much mitigate any type of head or neck injuries as a result of player interaction at that part of the rink.
Hockey players tend to be pretty big guys, right?
They do, yes.
You said you used the 50 percentile hybrid 3 as a crash test dummy, an ATD, to do your work in furtherance of the NHL contractor commission, correct?
That's correct.
Did you need to use a hybrid 3 that was the same size as these big, tall, 6'4", 230-pound hockey players?
No, not at all.
Why not?
There's a 95th percentile male dummy, which not many people have or use. The 50th percentile male is basically the gold standard for crash test dummies. And you're probably most familiar with it if you see automotive manufacturers and the ads on TV where they put the crash test dummy in the car and run them into walls and flip them over. Well, they use the 50th percentile for all of those tests. And then they scale the actual injury assessment reference values to different size people. So they record the force off of that, and they might say, well, for the 50th percentile average person, you can sustain 180 Gs of acceleration to the head before you see a severe injury. And then they'll scale that and say, well, the hybrid 3 has to record, say, 300 Gs before someone twice that size gets hurt. So you just use one size dummy, and then you scale that to whatever size person you're looking at or you want to actually investigate.
Is that undertaking of mathematical scaling, is that an industry standard in biomechanics?
Absolutely. And I mean, it's set forth in NHTSA, the National Highway Traffic and Safety Administration. They set, well, the government sets the Federal Motor Vehicle Safety Standards, and that's all the crash tests that vehicles have to go through. And during those tests, they have to ensure that the values on the dummy, on the head, on the neck, on the spine, on the arms are below certain values to ensure that they're safe at specific speeds. And they scale, they have a certain papers, a lot of papers actually, which talk about scaling the values for different size people.
Is that an accepted methodology in the scientific community?
Oh, it certainly is, yes, sir.
Dr. Rentschler, do you specialize in any particular research and analysis at ARCCA to evaluate the relationships between crash injuries and crash forces?
I do, yes.
What about kinematics?
Kinematics is one of the specialties, yes, sir.
Fancy word, probably nobody knows. I didn't know it before I met some of the folks involved in this case. What does kinematics mean?
Kinematics is just motion of the human body. So it's looking at how the body moves in different situations. Whether you're in a vehicle and it hits a wall, how does your body move? It moves forward. Will it load into the seatbelt? Does the airbag deploy? Or if you're a pedestrian and you're struck by a car, how does the body move as a result of that interaction? That allows us to look at the loading to the body. Forces are exerted on someone's body because their body's loaded by different objects or different forces. So kinematics is one of the first steps. If you're going to look at injury causation, you have to determine the kinematics of an event.
What are human tolerances?
Human tolerance is really just looking at how much force it takes to cause an injury. So there's been generations of testing to look at different forces. For instance, the humerus, the upper bone in your upper arm. How much force does it take to cause that fracture? They've tested the cadaver bones. There's a lot of research for decades out there looking at different parts of the body, the ulna, the radius, the two bones in your forearm, skull fractures. Almost any type of injury, again, has an injury mechanism, and in order to determine how it occurs, we have to look at tolerance. How much force can the body withstand before you start to see a specific injury occur?
Doctor, how long have you worked at ARCCA?
I've been with ARCCA now for about 17 and a half years.
How many cases have you been a part of in terms of investigating or conducting crash injury analysis?
Over my whole career, probably thousands of cases. I've been doing this since 2004, so for about 21 years total.
Dr. Rentschler, are you able to estimate how many of those cases that you just talked about, those potentially thousands of cases, have involved motor vehicle pedestrian circumstances?
Oh, I'm sure over the year there's been hundreds of cases. A lot of them are motor vehicle accidents, but certainly a large percent's automobile pedestrian type impacts.
What education, training, and background qualifies you to perform the duties that you just told us about as the Director of Biomechanics and Human Factors at ARCCA?
Well, I got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanics from the University of Pittsburgh in 2002. And then I got my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
2004. Thank you. Are you a member of any professional associations associated with your field?
I'm a member of SAE, the Society of Automotive Engineers, as well as the American Society for Mechanical Engineers, ASME.
Are you also a reviewer for an outfit called Archives of Physical Medicine and Rehabilitation in Biomechanical Engineering?
I have. I've done peer-reviewed articles for those journals before, yes, sir.
When you say peer-reviewed articles, you're the peer reviewer?
That's right. If you want to submit a scientific article to a journal, you'll write that manuscript and then submit it to the journal, and then they'll send it out to other experts or peers in that same field, probably 3 others normally, and then they'll review that transcript, send it back with any suggested revisions, and then usually the author will make changes, send it out again, and that's how it gets accepted. Usually it goes through several different iterations before a paper is actually published.
Have you received any additional training following your PhD, formal training or otherwise, in the field of biomechanics?
I have, yes.
Describe some of that for us, please.
Throughout the years, I've taken classes through the NTSB, National Transportation Safety Board, as well as SAE, as I said, Society of Automotive Engineers, and at different universities, Virginia Tech, different seminars and classes with respect to biomechanics.
Is that normal to, even for someone at your education level, a PhD, to take continuing education to stay up on issues in your field?
It is. You take continuing education and then also just working with your peers. And when you work in a certain company, for instance, at ARCCA, we don't do just litigation. We do the research and development. We have an epic sports branch at ARCCA where we look at sports performance of athletes, how to help them perform better, whether you're a baseball player or volleyball player. So it's really the experience and the work that you do that also helps keep you up to date with technology and the different aspects of that field.
Does some of that additional education include biomechanics of high-impact injuries that was offered by the NTSB?
Yeah, that's correct, yes.
Methodology and techniques of crash data retrieval offered by IPTM?
Correct, yes.
What is the IPTM?
That's the Institute for Police Technology and Management. It's actually a school down in Jacksonville, Florida, that offers basically vehicle crash reconstruction and biomechanical classes.
What about human factors in traffic crash reconstruction, also offered by the same outfit?
Yes.
Did you take a course in automobile safety and injury biomechanics from, is this the one from Virginia Tech?
That's correct, yes.
Okay. Did SAE offer a course in injuries, anatomy, biomechanics, and federal regulations?
Yes, that was in Detroit, I think, where SAE is based.
And you took that seminar as well?
Yes.
What about vehicle accident reconstruction methods offered by the SAE?
I've taken that class before, yes.
Linear momentum analysis offered by CAARS?
That was, yes, in a class out in California.
Motor vehicle accident reconstruction offered by SAE?
I've taken that class as well, yes.
Advanced collision investigations out of California law enforcement?
Yeah, I believe that was a 2-week class I took. That's the introductory class that they give to the sheriff's department and police officers out in California.
And what about the post-collision passenger vehicle inspection and seatbelt analysis offered by CARS, C-A-A-R-S?
I've taken that as well, yes, sir.
Have you published in peer-reviewed articles and book chapters? You said you were a reviewer. Have you actually published yourself along with you and your colleagues?
I have published, and that was mainly when I was in graduate school doing graduate work. I worked at the Human Engineering Research Lab. We helped people with disabilities, so we looked at people in wheelchairs, manual wheelchair users, looked at the forces acting on the arms, how to help reduce injuries, rotator cuff tears, carpal tunnel syndrome, things such as that. So I did publish primarily when I was in graduate school at the University of Pittsburgh.
When you were in graduate school, approximately how many publications did you participate in, either yourself or with colleagues?
Probably 10 or 12 papers, and then some abstracts, and I believe a book chapter as well.
Have you been qualified in other courts to testify as an expert in the area of biomechanics and accident reconstruction?
I have, yes.
Approximately how many times?
I've testified throughout my career probably over 150 times in both state and federal courts throughout the country.
I want to talk to you for a second, Dr. Rentschler, about how you began working on this particular case, the case that's before the bench. When were you initially retained in connection with this case?
We were initially retained, I believe it was for the first trial. It was, I believe, maybe it was the fall prior to that actual trial. That was last year.
All right. When you were, by the way, initially, were you hired by the defense?
No, we were not.
Were you hired by the Commonwealth?
We were not, no.
Was that a separate agency that hired you?
It was, yes.
It wasn't an insurance company, was it?
It was not, no, sir.
Okay.
Good.
What were you initially asked to do by this separate entity?
Initially, we were kind of constrained in what we were asked to do and to review, but we were asked to evaluate whether the injuries sustained by Mr. O'Keefe were consistent with being struck by the Lexus.
And who at ARCCA was assigned on the team to undertake this commission?
There was myself, Dr. Dan Wolf, and I believe Mr. Scott Klein was another engineer who was involved.
And did all three of you join in the analysis that ultimately ended up in a report that you authored, or the three of you authored together?
We did, yes, sir.
What materials did you review in furtherance of your initial consultation in this matter?
Obviously, I looked at the medical records. We looked at photographs of the vehicles, information about the vehicle, photographs of the actual incident scene, various information pertaining to the Lexus itself.
You know who Dr. Dan Wolf is?
I do, yes.
Is that the other person, the Dan Wolf, the Dr. Wolf that you just mentioned?
That's correct, yes.
Did you and Dr. Wolf look at basically the same set of information? You were provided the same set of information?
We did, yes. We were provided a tranche of information that all three of us looked at, yes.
Can you explain the difference between your area of expertise and Dr. Wolf's area of expertise? I don't want you to get into his analysis, just what area he covers. In other words, you're dealing with a Lexus and pedestrian, Mr. John, correct?
Correct, yes.
What's the difference between the analysis that you undertook and the responsibilities of Dr. Dan Wolf?
So Dr. Wolf really concentrated looking at the vehicle itself and the damage to the vehicle, the damage to the taillight, which is really the only damage we have to that vehicle. And so his analysis pertained to evaluating the force associated with producing that damage, what's consistent with causing that type of fracture and damage to the taillight itself. Whereas my part of the investigation was really looking more at the injuries and looking at Mr. O'Keefe and his kinematics and his alleged or any interaction between him and the vehicle, and whether that would be consistent with his injuries as well as the damage that we see to the Lexus as evaluated by Dr. Wolf.
Did you ultimately issue a report, an initial report summarizing your opinions and your conclusions following your analysis?
We did, yes, sir.
About when was that report issued?
I believe it was sometime in February.
February of what year?
It would have been February of last year, 2024.
2024, okay,
Correct.
thank you. Were you able to provide an analysis, given the information that you had, were you able to provide an analysis for the biomechanical aspect of the analysis of the case?
I was, yes, sir.
All right, did you review medical records and other materials?
I did, yes.
Did you make note of anything with regard to Mr. O'Keefe's injury or injuries based on what you reviewed initially when you began your analysis?
I did, yes.
Can you describe what you noted in terms of Mr. O'Keefe's injuries?
There were really just two basically different areas of injury. There was injury to the head. There was a laceration on the rear kind of right occipital region of the head.
Oops. Pardon me, guys. Trying to move stuff around
Which
here.
resulted in fractures, an occipital skull fracture, which is the rear part of your skull, as well as basilar skull fractures that propagated up through the skull. And then there were injuries which were noted or diagnosed to be superficial abrasions along his right arm.
What is a subscapular hemorrhage?
Subscapular is?
Yes.
Yeah. With respect to the head, is that what? Yes.
As it relates to the head.
Yes. Well, so when we talk about there's subarachnoid, there's pia hemorrhages, but basically they're hemorrhages, and scapular is hemorrhage under the scalp, but above the skull. So subdural is within on the surface of the brain, but scapular means that it's a hematoma or bleeding that occurs under the scalp but above the actual skull.
Did you note subscapular hemorrhage in your analysis of Mr. O'Keefe's injuries?
There was, yes, I believe there was extensive subscapular hemorrhaging.
What about skull fractures?
There were, as I described, occipital skull fracture in the back of the skull that then propagated forward the calvarium as well as the basilar or the base of the skull.
You mentioned subdural hemorrhage as one of the issues that you would look at normally. Did you note whether Mr. O'Keefe suffered from subdural hemorrhage?
He did, yes. He had sustained subdural hemorrhage as a result.
And also subarachnoid hemorrhage?
Correct, yes.
What about bilateral orbital ecchymosis?
He did, yes, bruising along the eyes, basically.
What does bilateral mean? Both?
Bilateral means left and right, correct.
Did you note a 1 centimeter or approximately 1 centimeter laceration to the upper right eyelid?
There was, yes, 1 centimeter, yeah, and so, that's a little less than half an inch laceration right above the right eye.
What about abrasions to the anterior and left aspect of the nose?
There were some abrasions on the nose, and then I believe a few lacerations as well.
Laceration on the right anterior tongue?
The tongue was lacerated, yes.
You know,
haven't heard about that
with
yet.
With regard to one of Mr. O'Keefe's extremities, abrasions along that extremity.
Superficial abrasions, that's correct, sir.
Describe which arm we're talking about and what part of the arm.
It was the right arm, and it was from the forearm up towards the top of the shoulder. And there were various abrasions what were diagnosed as superficial abrasions along that kind of posterior aspect of the arm, the elbow, forearm, and the upper arm.
When you undertake an analysis, do you use biomechanics and kinematics both to try to evaluate whether or not a specific set of injuries are consistent or inconsistent with a proposed set of facts? Or I guess I'll just leave it there, a proposed set of facts.
Yeah, I mean, those are basic steps to look at how an injury occurs. I mean, first you have to identify the injury, and that's by looking at the medical records and determining what the diagnosed injuries are. And then you have to determine the kinematics and the kinetics associated with a certain event. So how did the person move? How was their body moved? Did they interact with anything? And how did that result in loading or force being applied to the body? Those are basic steps of a biomechanical injury causation analysis.
How did you go about undertaking those steps in this particular case?
So in this particular case, we looked at how those injuries are actually produced or created. So occipital skull fracture, you need a sufficient force. You need a force of around maybe 1,400 or 1,600 pounds applied at the back of the skull to actually cause a fracture like that. The abrasions, superficial abrasions, and an abrasion is basically rubbing or scraping or friction that kind of scrapes away the top part of your skin, the epidermis. You have the epidermis, the dermis, and then the hypodermis. An abrasion is just gets into the top epidermis and doesn't get any farther. A laceration is an actual tearing or ripping of the skin, usually down past the epidermis into the dermis. And so that takes either a blunt object or a sharp edge, depending on whether it's an incision or laceration, to actually produce that type of an injury.
Did you look at patterns of injuries on Mr. O'Keefe?
Yes.
Did you also, the other side of that handshake, did you also look at damage to the vehicle, physical damage to the Lexus?
We did, yes. Our goal or what we were tasked with was to determine whether the injuries are consistent with the damage to the car. So clearly, you look at how these injuries are created, what injury mechanism you need to produce them, and then you look at the damage to the car. Can you line up contact between where those injuries occurred and how they occurred with damage to the vehicle?
What kind of materials did you review, in addition to, I'm guessing, photographs?
Photographs, yes, autopsy photographs, as well as photographs of the vehicle and the damage to the Lexus.
What about medical records, hospital records, things of that nature?
Absolutely. That's the first step, looking at the injuries to find what the injuries are, what are the diagnosed injuries, as well as it's important to determine what injuries don't exist, because that's also helpful in determining whether certain impacts may or may not have actually occurred.
Did you receive a full file from the medical examiner's office in this case?
I did, yes, sir.
Did you also receive police reports, follow-up reports, witness statements, things of that nature in this case?
We did, yes.
Did you receive any data concerning the vehicle itself, contained either in police reports or follow-up reports or expert reports?
We did, yes.
Mr. Jackson, I'm just going to ask you to slow down cadence of your voice a little bit.
It's late in the day and I'm doing it again, aren't I?
Cadence.
I'll slow down. I forgot where I left off, but let me ask you sort of openly, was there anything else that you considered and analyzed in at least building a database from which you would build an analysis?
Well, yeah, I mean, we review all the materials that are provided to look at all the injuries, to look at all aspects of the vehicle, damage to the vehicle, information about what the vehicle may have been doing. Any other evidence that may help contribute to looking at what either caused the injuries or what may or may not have caused the damage to that vehicle.
When you and your teammates undertook this analysis, did you even know who we were?
Initially, we did not. No, initially, I personally didn't know anything about the case, and we were asked not to do any research or to look up anything about it. We were given certain parameters, certain information, and that was it.
Did you follow those instructions?
I did, yes.
The undertaking, the analysis that you did, was it in keeping with the accepted methodology or methodologies in your field of engineering?
It was, yes.
Did you ultimately reach some opinions and conclusions based on that initial investigation or analysis?
I did, and we did it at ARCCA, yes. Myself, Dr. Wolf, and Mr. Klein did.
Did you reach any opinions or conclusions with regard to the force required to produce the occipital skull fracture that you noted with Mr. O'Keefe, his head being struck by the rear tail lamp of the subject Lexus?
I did, yes.
Tell me what those opinions and conclusions were.
Well, again, we determined by looking at research and tolerance values that it would take about 1,400 to 1,600 pounds of force to cause an occipital skull fracture. Now, we were tasked with looking at, again, could that result from impact with the car? So one of the things we did is we took a head form, the head from a dummy basically that's instrumented with accelerometers, and we dropped it onto a taillight cover to attain a speed of 15 miles an hour. And so that would be comparable to the vehicle striking the head at 15 miles an hour. And I concluded a few things from that. A, that the force wasn't sufficient, or the acceleration wasn't sufficient to produce enough force to cause a skull fracture at 15 miles an hour. And also, when you look at the position and configuration of the occupant, it really wasn't possible to get a skull fracture by hitting the taillight and not sustain any other significant fractures. For instance, where the taillight's positioned to have an impact to the back of the head, you really couldn't have someone positioned in such a manner to strike just the head and not have subsequent concomitant injury to the neck or any other part of the body. So my findings with respect to the skull or the occipital skull fractures was that it likely did not occur as a result of contact, specifically with the taillight cover on the rear passenger side of the Lexus.
So as to the question of whether Mr. O'Keefe suffered the occipital skull fracture as a result of being hit by the tail lamp at 15 miles an hour, were you able to scientifically rule that out?
I was, yes, sir.
Was that to a reasonable degree of scientific certainty?
It was, yes.
Did you reach any opinions or conclusions regarding the abrasions on the right arm that you noted earlier on Mr. O'Keefe's body?
Yes, I believe my conclusions with respect to the abrasions are that it was inconsistent with contact to the tail light, and that not only that those injuries are inconsistent, but you would expect additional injuries, likely fractures to the hand and or the forearm, depending on the actual speed of the vehicle.
Other than the expectation that you would see fractures or other damage to the arm, what was the basis for your opinion that the linear abrasions would not result from impact with a non-damaged taillight traveling in reverse?
What you have to look at the kinematics associated with that, and that in order to get just superficial abrasions, that doesn't take a significant amount of force, but essentially that to have an arm contact the rear of the car, and we weren't really given any theory of how the arm contacted the car. So initially, we weren't privy to any theories or allegations of how this may occur. So just generally speaking, looking at the arm, how it would contact the car, and subsequent movement and interaction with the light cover, my opinion was that the injuries would be inconsistent, or the injuries that Mr. O'Keefe sustained on his right arm and didn't sustain would be inconsistent with actual interaction with the taillight.
Doctor, were your opinions and conclusions, along with those of your colleagues, reduced to a report?
They were, yes, sir.
Was that report, to your knowledge, ultimately turned over to both the defense and the Commonwealth in this case?
To my knowledge, it was, yes, sir.
And then who was able to hire you?
I'm going to change gears for a second and bring us forward to the spring of 2024, after February of 2024, moving into the start of 2025. Did the defense at some point reach out to ARCCA and contact you and Dr. Wolf?
They did, yes.
That was back in 2024 after the spring, correct?
That's correct, yes.
At some point, did the defense engage you specifically to testify?
Yes.
This year?
This year?
This year, meaning
yes.
This trial?
For this trial, yes.
Okay.
Yes, correct.
Were you asked to conduct further testing in furtherance of your potential testimony in this trial?
We were, yes, sir.
And were you provided additional materials from the defense in furtherance of your potential testimony and your testing?
We were, yes, we were provided additional material with respect to, yes, the theory of how this may have occurred and how Mr. O'Keefe may have sustained his injuries, allegedly.
Included in the materials that you were provided in anticipation of your testimony in this case, in this trial, were you provided anything from a company called Aperture?
We were, yes.
What were you provided from Aperture?
We were provided a written report from Aperture, a PowerPoint presentation, about 140 some pages from Aperture, and then a file material, I believe, what was reviewed and the results of some testing that Aperture had conducted with respect to this case.
Was it your understanding that the Aperture PowerPoint was authored by a particular individual?
Yes, sir.
Who authored that PowerPoint as far as you knew it?
As far as I'm aware, it was Dr. Judson Welcher.
Okay. Your Honor, may we approach briefly?
Okay. Might not be ready to go any further until they get whatever needs to be sorted out with the PowerPoint sorted. It looked like there was some confusion and perhaps some disagreement about what part of Judson Welcher's presentation was actually shown to the jury. And see, this is part of what happens when you get really messy about, oh, I've got a paper copy of this, and I've got a thumb drive of that, and we're marking different things and we're showing different things to the jury, is that they don't always correspond. They don't always match. The thing that is on the thumb drive doesn't always represent the same thing that is in the paper copy. So Bev's up there with the binder saying these pages are blank, but we watched this PowerPoint presentation from a digital file that was on the screen. And so they're not the same thing. We don't know. I don't know. I don't recall off the top of my head, of course, if we saw that slide or not, but both Mr. Little or Ms. Little and Mr. Alessi both thought that, that slide from Dr. Welcher's presentation where he set out his ultimate conclusions was in fact shown to them. We know he testified to it, but seems to be some question about what the jury actually saw or not. So likely they have to sort that out, because if she's wrong, just because it's not in the binder isn't what was shown to the jury. Then, they need to bring that up and they need to make their record of it. Otherwise, we'll just continue on with how we're going, but he may more than likely have to go in and keep tweaking his PowerPoint to be able to comply with all of the various detailed mandates that come down from the bench. Take out you can't have words on your PowerPoint now. Apparently, for some reason, that just becomes a bridge too far when the defense expert wants to have words on their PowerPoint. We gotta just take that off. Why? Who knows? Did we get a citation to a case saying you don't get to have words on your PowerPoint? No, of course not, because there is no such thing. It's perfectly fine to have words on your PowerPoint. We're just in a courtroom with no consistent or predictable standards. And so you have no idea what you're going to be allowed to do or not do. This guy has testified more than 150 times. Okay. He's made a few PowerPoints in his career. Wonder if this is the first time he's ever been told you can't have any text on your PowerPoints. That's just a real problem. It's not going to be helpful to the jury to have words on your PowerPoint. You'd think if he'd been told that before, he'd probably be cautious about putting words on his PowerPoint. But I'd say there's pretty good odds that 150 plus prior times, he's never been told, don't put words on your PowerPoint. Because it's not actually a rule. It's just a thing that Bev has thought up here in this courtroom as a way to make it difficult for the defense to come to an end in their case, take up all this time and annoy the jury because they're sitting here. They've been in this courtroom now for almost 7 hours. I guess they were out for their hour, maybe hour and a half for lunch. How much total time have they spent actually hearing witnesses testify versus how much are they sitting here twiddling their thumbs, staring at the ceiling, not having, their phones to look at and stuff, not having a book, nothing to do, but just look around. They have spent a lot of time But it's the defense case, so, you know, gotta make it clear that the defense trying to do things necessitates us having all these conversations about it so that we make absolutely sure that you don't hear things that sound like you should perfectly reasonably be able to hear them. Some of them, in fact, you've already heard, but for some reason you can't hear it again. You know, got to have all these conferences, so no rules here. Just you know, Hank got his ass handed to him today, and so if he's gonna recover from that, from Dr. Laposata, he might need a little boost, making it difficult for Dr. Rentschler. Because even his preliminary conclusions here, the very first opinions he reached before they were ever contacted by the defense, before he ever heard about Welcher, any sort of theory of the interaction here, already reached the conclusion John's skull was not fractured by hitting the taillight. The abrasions on the right arm were not caused by some kind of contact with the taillight. You would need to have some additional injuries.
We picked up a lot of time today. I think it was because we did spend less time at Sidebar and less time doing things outside your presence.
Oh, you did?
We're back on track, and we're going to let you go for today, and we're expecting a full day tomorrow. I can tell you, the lawyers tell me that we're definitely winding down. Okay, so please, those same 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And please continue to be very careful with your social media use. So we'll see you ready to start at 9 o'clock.
Fewer sidebars. I don't know what trial you're watching, Bev. But it looked to me like, you know, the jury maybe got a couple solid hours out of today, and the rest of the time they spent staring at that fan, twiddling their thumbs, waiting for you to figure out how you're going to make it more difficult for the defense to defend.
You're all set, Dr. Rentschler. I
Thank
should
you.
have told you. I'm sorry. So we'll see you tomorrow morning as well. So, okay? Thank you. All right. So first of all, anybody object if I give Ms. McLaughlin back the paperwork on the State of Rhode Island versus Michael Patino transcript or whatever she was giving me? Any objection to that? All right. Thank you. All right, so Mr. Jackson, for purposes of your edits, so the text will be removed from 5, 6, 8, 9, 23. The word measurements, I think, is perhaps the only word there. 24, 31, 32, 33, 34, 46, 47, 54, 55, 56, 58, 66, 67, 68, 69, 71, 72, 73, 74, and 75, and 76. Separately, pursuant to what will be an upcoming evidentiary ruling on whether foundation has been made, if you could separately have a way to exclude, if it becomes appropriate based on whatever ruling, based on the foundation that you're going to attempt to put, slides 9 to 23. Now, as I said to you at Sidebar, once you do this, or if you talk to the Commonwealth, if there's no objection to some of those numbered slides that I said needed to be edited, if the Commonwealth agrees that they come in, you can go ahead and put them in, because I would allow them if it's by agreement.
Thank you.
Okay? All right. So do you expect that we will?
As long as I wasn't both.
Okay.
Depending on how it goes, if he has an hour and a half, I expect that'll probably be about an hour, maybe an hour and 10 minutes.
Okay. All right. And then we'll figure out where we are Thursday. It seems that the case may be ready to go to the jury Friday.
Oh, you
Maybe
think?
Monday at the latest. But that's,
By Monday, based on our conversation.
does that seem like a fair estimate to you, Mr. Brennan?
I think we'll be ready Friday.
Okay. All right, so we'll see. Okay. All right, thank you. We'll see everybody tomorrow morning. Yes.
Should I have Dr. Welcher in for tomorrow or wait for Wednesday? Oh, tomorrow's Wednesday.
Tomorrow's Wednesday already. Can we, Mr. Jackson, can we reevaluate that mid-morning or the luncheon break and see where we are, whether we need Dr. Welcher here in the afternoon?
Of course.
Okay. All right, we'll do that.
I think Mr. Alessi would have one issue you want to address before.
Yes, Your Honor. With regard to various exhibits that Your Honor said would be admitted based upon the issue that we had with regard to the Exhibit 88, Your Honor said you would...
Yes, we'll put those into evidence.
Thank you very much.
Okay.
That was the only item pressing for today.
Yeah, I said yesterday they'd come in, they're coming in. Okay, so those will be in evidence. Mr. Brennan,
What
you
number are
noticed
they?
yesterday that I was letting those in. Okay, all right, we're all set. We'll see you tomorrow.
All rise for the court, please.
Call me crazy for not trusting her. You said yesterday they're coming in. So are they in? Are they on the exhibit list? Do they have numbers? That's what happens when they're in. Has that happened? Has that happened? They're talking about all the things that she said that, you know, to correct the issue with Hank pointing out the holes in the back of the sweatshirt and trying to imply that that it came about during the accident. And it's not. It's based on Maureen Hartnett, and there were several documents, a chain of custody, the photographs, and so forth to illustrate. She said all of those will come in. But to come in, you know, they need to be in. They need to be on the clerk's list. They need to have numbers assigned to them, evidence numbers assigned to them. Has that happened, Bev, or is it just going to? See, until it's actually happened, I'm the lawyer. I'm probably going to keep nagging you until I'm sure that it's done. Because if I'm not sure, then I gotta make sure. I gotta make sure we got the record and that it doesn't just get overlooked as the result of a very unfortunate oversight. Don't want that. Well, we came right back in after lunch, didn't we? I didn't get too much time to get up and move around, but it's okay, guys. I did take some. We're all good. Jeff was kind enough to go and look after the trees for me. So we were able to do our recap basically up to the lunch, all of the ridiculous objections, which he's now heard. She's given Hank everything he wanted. Bolstering his own opinion, shouldn't be on a slide. He can say it in his testimony, but you just can't put it on a slide. See, that's the rule today. So when we came back after lunch, no Patino, and then we got the whole contrary to what you said, Ms. Little, and what Mr. Alessi was nodding his head to. Page 136 did not come into evidence. Welcher's report did not come into evidence. See, it's just a blank page, 136 to 138. It's all blacked out. Maybe in your paper copy up there on the bench, but anybody gone back and checked the testimony yet? Anybody gone and looked at the live stream? See if his PowerPoint came up. Of course, I haven't been able to do that, but probably somebody out there already has. So that's not a difficult question to answer. So the text is out. There's nothing in the words that's necessary to assist the jury. It doesn't have to be necessary to assist the jury. Is it relevant? Is it unduly prejudicial? It's really your standard. Is it relevant? Yeah, it is. Yeah, it is. You're not saying it's not helpful so he doesn't get to testify to it. He gets to testify to it. It is helpful. The words are helpful. You just don't want them on the slide. It's your last Hail Mary to keep the jury from seeing the inevitable here. That Dr. Laposata just rubbed Hank's nose in. Didn't matter what speed her car was going because it didn't hit him. He doesn't have any sort of injuries that would be consistent with that. Great work there, Hank. Great work there. That's one of the finest own goals I think I've ever seen. You had an absolute gift of a ruling from this judge that this highly qualified medical examiner would not be able to testify about motor vehicle collision causation, whether that's consistent with his injuries. You had an absolute gift of a ruling, and you just pissed it away. Didn't you? You just went ahead and elicited all that yourself. Quite some work. Quite some work. So we came back to continue the recross of Dr. Laposata. Boy, did she handle that well. The whole issue with being in the Rhode Island and the fire, the station house fire. Handled that extremely well. So he went on to this, general line about, if you disregard stuff, it wouldn't be consistent with your differential diagnosis. No, she reviews everything relevant. She reviews everything relevant. I know Hank is trying to set this up to be like, well, but she said you'd have to do that, but she herself admitted she didn't look at the phone data and the car data and stuff like that. Yes, Hank, because she told you it's not relevant. Doesn't matter because he wasn't hit by a car. Nothing in the phone is going to overcome the defect you have with the lack of injury. That has been the case from day one. It's always been the problem with this case. It's always been the big hurdle that the Commonwealth has to clear at trial. Prove that man who, just going by the eye test, looks pretty much like he's been in a fight, like he's been in a fist fight, and all his blood is dripped down his front, just like it happens when you're in a fist fight. Show me where that man was hit by a car. Show me how any of that's consistent. Can you overcome that eye test? No, it's always been the problem with this case. So, big piece of why that's so devastating, and it doesn't matter. Karen Reed could have driven home at 80 miles an hour. She could have treated this SUV like an Indy car on the way home. Doesn't matter. Doesn't matter how fast she reversed in front of 34 Fairview. John wasn't hit by a car. Pretty devastating. So he spent some time on that to, try to make a point. Imply, oh, well, but she disregarded stuff, therefore she's biased. Wouldn't want to make up your mind ahead of time. No, because you look at all the evidence that's relevant. Nope, not a biomechanical engineer. She's not a major in physics. She did take physics at a college level. Good for her. Bless her. I didn't have the stomach for that. Wish in hindsight I had. I wish in hindsight I hadn't been so STEM averse, but woulda, coulda, shoulda. There's always so many different paths that your life could have taken. It's funny to look back sometimes, and you don't always recognize like important decision points at the time when they happen. Sometimes you have to have the hindsight to be able to recognize, wow, that was a big moment when my life went this direction. Could have gone a whole different direction. You don't think about the time at in high school. Hey, I could take AP Chem, or I could just take fewer credits and go get an after-school job. I'll go get that money. Go get that money. Just never really think about how that ends up potentially having significant impacts on your the whole course of your life. So her experience, no, she's not a biomechanical engineer. She's not a physicist. She looks at the impacts to the body and to the vehicle to the extent that she's looking for possible points of impact that could produce those injuries. The Egypt airline and the station nightclub fire. Yeah, she received negative press. It had no basis. It was bullshit, in fact. In fact, it was bullshit. She was criticized for not coming to the scene. Yeah, it was bullshit. One, nobody called her to come to the scene. That was not true. She actually looked up the phone records and gave it to the press to prove that it wasn't true. And she's not a first responder. She sent her investigator out to the scene. She prepared to be running this office 24 hours a day so that they could process the 100 people that died in that fire. That had to be pretty exhausting and time consuming. So it made no difference whatsoever that she didn't go to the scene. It was bullshit. Yeah, it was erroneous. Gave herself a little correction. Oh, I love it. Say it like it is. Flurry of criticism. She resigned in 2005 from Rhode Island because the budget was going to be cut. She couldn't do a job. Good job without the other medical examiner. She wouldn't be able to afford another examiner, so quality would suffer. She said no. That's all he got out of that. That's all he got out of that after the whole argument with the neglecting bodies and so forth. No, that's it. All he got is, tell me the story about how you resigned because they wanted to cut your budget and you said, not on my watch. That go the way you thought it was going to go, Hank? Because it just makes her sound a lot more stand-up, doesn't it? She's not there to kowtow to the policymakers. The cases need what they need. And you don't like it? Find someone else to run it. Find somebody else to do it. Makes her look principled. Started her consulting practice. Yes, Hank, it's a consulting practice. So 100% of it is dealing with consulting. It is, in fact, a consulting business. Yes, of course, she gets paid for her time. None of that lands. None of that lands. The scratches on the right eye, she doesn't know what did cause it, but she certainly can tell you what didn't. I love that. I love that answer. You can rule things out, but not everything. You can't rule everything out down to definitively identifying one particular thing. We can sure say it's not a spoiler, but a punch, it could be. Can't rule out a punch. It could be an object as long as the object can get into that area under his eyebrow. That's what a knuckle does, guys. That's what a knuckle does. Gets right in there. That's how it works. Then the scratches on his nose. It's not a cut. It's a scratch. Doesn't know what it comes from. Could be a number of things. Also a small scrape on the tip. These are not incised wounds, meaning it's not caused by a blade. Wasn't allowed to go into that with the arm on direct, but on cross, allowed to talk about it with the nose. Oh, don't ask me to try to find the consistency in that. It could be caused by a piece of glass if the glass was thick. Oh my God. She really just, you're not going to catch this woman. He's like, didn't you say? He's starting to play the tricks, right? Didn't you say this? Didn't you say that? No, she didn't actually say it. And she'll tell you, I don't remember saying that. I don't recall saying it could have been caused by glass. It could have been caused. Make him read you your words back. If he's going to say you said that, you don't recall it, make him read it back. Funny how he doesn't do that. So it could be a thicker piece of glass that would cause something like that. There's no blood pressure if a person is dead. So there might be some superficial blood that would result from, like, picking a piece of glass out of the nose, but not a spurt that's got, like, arterial pressure behind it. That's quite a spurt. Probably not going to get that from your nose anyway, but. Hypothermia. We learned more about the rectal temperature is a good representation of the body temperature. It can be 3 to 4 degrees difference from the oral temperature, in part because of breathing and stuff like that. So it's a better representation of the body temp. 98.6 is normal. Clinically at 95, you'd start to worry about possible hypothermia, but No, it doesn't especially affect breathing. No, it doesn't especially affect radiation. In fact, at 95 degrees, really no effects on the body at all. You're still okay. Remember, Hank, she just said you'd start to worry about it, as in like you'd probably take preventative measures to try to keep the person from deteriorating to the point where they would have some type of harm, some type of danger. So 80 degrees at 6:37 a.m. No, he didn't get warmed up in the ambulance. It might add a little bit, but it doesn't usually add that much. Go ahead and discount that explanation Hank has come up with. He was actually colder, but then got warmed up in the ambulance. No, it doesn't add that much. No purposeful movement. If we assume that the phone, we know what the phone says, but if we assume that John himself didn't move after 12:32:16, it's about 5 hours later that he's found, 5.5 hours later that he's found. Then all these series of questions, if a live person is outside in the cold and they don't die right away, but they start to get cold, but then they die, and she just cuts him. That's not what happened here, because he didn't die of hypothermia. That's not what happened here. So at room temperature, the dead body is going to drop about 1.5 degrees per hour. In a colder environment, it can cool up to 4 degrees per hour. That's a great piece of information to know. Hank, thanks for feeding that to us. Makes it pretty clear John had to die pretty quickly, which is probably one of the best, most merciful pieces of news that we've heard so far in all of this. People do die of hypothermia, but not in this case. So yes, he kept trying to get there. And we finally get to this hypothetical scenario where, yes, losing body temperature makes you hypothermic, Hank. That is the definition of hypothermic. If they were in the cold, not dead, they could lose body temperature and thereafter become hypothermic. Yes, Hank, losing body temperature is itself what you mean when you say becoming hypothermic. It is consistent, in her opinion, with being out in the cold for 5.5 hours for John's temperature. So then Hank tries to argue with that. But if you were alive and you lost 3 degrees an hour, nope. Stop right there. This is dead body stats. That has nothing to do with the rate of heat loss of a living body. Hank got pissy, but I'm asking you, and not as a doctor, I'm asking you for your medical opinion, not your advocacy. That's objected to, that's sustained. She was like, "You're going to pay for that, bitch." And then asked if she remembered raising the bumper. She got him right back, didn't she? You remember talking about the bumper and how, he couldn't have gotten injuries because he wasn't hit by the bumper. And so she'll just go ahead and state her opinion that Bev had excluded Hank, but you've gone ahead and elicited it now. That John has no injuries consistent with being hit by the back of the SUV, either the bumper or the spoiler. Hey, great. Thanks for spelling that out. Bet you wish you hadn't been such a little catty bitch to Dr. Laposata, huh? She sure answered that right away. Then tries to get her to critique the biomechanical demonstration or the accident reconstruction demonstration from Dr. Wolf's video. That all got stricken. Had to, of course, have a sidebar first. She only got the x-rays a couple of weeks ago. That was interesting, wasn't it? That was interesting, wasn't it? Because Welcher was very insistent that there were no x-rays. He was very insistent. You don't know that there's no fractures. They did an x-ray. Didn't see any x-rays. Best practice would be to x-ray. No, they actually dissected his limbs and x-rayed him and still found no injuries. So I find it intriguing. Where did these x-rays come from? Why have they been missing the whole time? Something the Commonwealth should have. Should be produced in discovery. Should give it to your own expert. But somehow they just kind of vanished and didn't materialize until a couple of weeks ago. Where did they materialize? How were they found? Would love to know that story. There is a national standard where they would like the autopsy report to be completed within 90 days, but there can be more investigation after that. Sit down now, Hank. Sit down now. You're done. That's the best you're going to get out of this witness, is that they can continue investigating after the 90 days are up. And guess what hasn't happened 3.5 years later after that original undetermined finding? Hasn't changed. Hasn't changed. All the investigation of the last 3.5 years, you can just go ahead and call that out if you want, because it didn't change anything in this case, did it? Didn't change Scorty Bello's opinion one bit. Don't know if that was quite the winning point you wanted to end on. Then we got this sua sponte correction to her instruction to the jury. When I say strike something, I mean to disregard it, but when it's already in evidence, that's okay. It just means don't consider it as to this witness. The jury is sitting there going, what does that even mean? Don't consider it as to this witness. We have to pretend it doesn't exist if this witness is sitting here. If we're talking about this witness's testimony, we don't get to consider that there was biomechanical accident reconstruction work going on. Like, that's got to be quite confusing. Disregard that as to this witness. Well, what does that mean? You consider all the evidence as a whole when you're evaluating if Karen is guilty or not. So it's this kind of strange limitation, the way that she's worded it, because it's not really correct. Of course, they can consider the video. They can consider the video in relation to this witness's testimony. What she means is don't consider the specific questions you were shown and the fact that this video was shown to the witness. That's what she means, but she just can't come out and say that. It's got to make it very complicated and confusing and technically incorrect. So then we got to redirect. Oh, let's talk some more about cooling. Yes, the body will still cool if it was indoors, and potentially if the body was indoor somewhere that was cold, it would still cool at that outdoor kind of rate. The X-rays, then we get into evidence. No breaks, no hairline fractures, no injuries, no soft tissue swelling. These are perfectly normal X-rays. Nothing on them. So yeah, I'd say based on that, Dr. Welcher notwithstanding, we can be pretty confident between the X-rays and the dissection of the limbs that they didn't just happen to overlook some broken bones. That's not an explanation for why, John was hit by a car, even though it really doesn't look like it at all. It doesn't even pass the layperson's eye test, honestly, but even according to the experts, nope, not a single medical person has got up on the stand and said this is consistent with being hit by a car. That's definitely something for the defense to hammer on in their closing. Not a single one of the medical professionals are willing to say, yeah, this could be caused by a motor vehicle collision. This is consistent. Nobody's saying it's consistent. They're all saying it's inconsistent. The only person willing to say it's consistent, that's Dr. Welcher. And what's he basing it on? Great question. Not his science. We know that. Not his science. The facts, science, and data, not enough. We can't know. It's just too complicated. But I hear there was some DNA. So we did get a little intro to Dr. Rentschler. We got to start off his testimony today before we concluded. Did have time to do that. I have high expectations. I hope they're not too high, but primacy recency, guys. Defense is choosing to close with Dr. Rentschler. They're going to finish their case. He's the last thing that they hear. Their theory of the case, there was no collision. We got that hammered home by Dr. Laposata for sure. So if we're going to close with Rentschler, he's got to have even better goods than that. So that's my expectation. We'll see if it works out that way. So generally what he does, he applies traditional engineering principles to the human body, looking at force, how force acts on the body, and how much force and directions and things like that to get a specific injury. In other words, to analyze the mechanism of how that injury was caused. Thanks for spelling out to us that it's very normal to do this type of testing using a 50th percentile dummy, and then you scale the values to the size of the person that you're dealing with. That makes sense. You're not going to test it separately on, you know, how many dummies do you need? I mean, for every possible incremental weight of a person, that can become infinite at some point. You know, 200 pounds, 225 pounds, 200.5 pounds. Maybe there's a difference there. We better go with 200.1, 200.2. Of course, you're not going to just have a 200.1 pound dummy and then a 200.2 pound dummy and then a 200.3 pound dummy and have to test all of them separately. Makes perfect sense. You just use the 50th percentile because that's the average. Use the average and then scale the injury values to the different size of people. Lots of study behind that. Perfectly acceptable methodology. So the fact that the arm that they use is the 9.38 definitely doesn't matter from the injury standpoint. So kinematics, explaining what that is. It's looking at the motion of the body and how the body is loaded by different forces. Tolerance is looking at how much force is involved to create a specific injury. In other words, how much force can the body withstand before you see a certain injury occur. Lots of research on this for decades, looking at these different things. He himself has handled probably thousands of cases since back to 2004. When he got his PhD, he is, you know, studied, published, done all of those things, qualified in court, state and federal, probably more than 150 times. Now, in this particular case, hired by a separate agency, not the Commonwealth, not the defense, and explicitly not an insurance company, somebody completely separate, asked to evaluate if John O'Keefe's injuries were consistent with being struck by Karen's SUV. Given a fairly limited bit of information and set of, you know, questions to focus on. So they were given their tranche of data. All three of them looked at it. They issued a report in 2024. He was able to provide a biomechanical analysis. So you start by identifying what all of the injuries are. You've got superficial abrasions. You've got the scapular injuries, extensive. That's the stuff that's under the scalp but over the skull. We've got the skull fractures, the subdural and subarachnoid hemorrhages, the ecchymosis, the laceration on the right eye, the abrasions on the nose, tongue lacerated. Hadn't heard that before. We heard it in the first trial, but we hadn't heard that before yet. Yeah. Tongue lacerated. A lot of ways that can happen. Could definitely happen. Laposata described how you might have some seizure movement as a result of an injury like this. You might go into seizure. It's that extensive. Definitely cut your tongue that way. But guys, there's a reason why you walk into the boxing gym. You want to get into that ring. You must have your mouth guard. You must have your mouth guard. They call it the gum shield in the UK. I always kind of enjoy that, the gum shield. It's just amusing to me because it sounds like it's doing something that it really isn't doing. It sounds like it's there to protect your gum, but it's really not. It's not about not losing teeth. It's so you don't bite your tongue off. So you have, you got the protection on the one side. You can still bite your tongue off with just your bottom teeth, but it's way less likely. You're not going to get so injured. Very common to bite your tongue, get a tongue injury in the course of a fight. Very common. So that was new. Of course, the superficial abrasions to the right arm. So after you've identified the injuries, then you go and you determine the kinematics and the kinetics of the event. So you're looking at how did the body move? Did it interact with anything? And those are the basic steps of a biomechanical analysis. Why are we pointing this out? Because we didn't hear anything about Welcher doing that. This is basic. This is basic. We didn't hear anything about him doing that. So we started with 1,400 to 1,600 pounds of force necessary to cause a skull fracture like the one that John experienced. So we've got a number finally. You know, it was also mysterious to Dr. Welcher, but this part of it for Dr. Rentschler, that part's easy. How much force does it take to cause that injury? 1,400 to 1,600 pounds. Then also the abrasions would not require a whole lot of force in and of themselves, but they did come in a pattern. So he looked at the pattern of the injuries and the damage to the lexus to consider the injury mechanism. Looked at lots of photos, everything that he was given. By the way, he didn't know who anybody was when he first started doing this work, doesn't know who they are. Just got to make sure we hammer that home. So he did reach some initial opinions. They dropped the head form, took the instrumented dummy head, dropped it onto a tail light from a sufficient height that it would accelerate to 15 miles an hour. And then that will mimic the tail light hitting the head at 15 miles an hour. That force was not sufficient to cause the skull injuries. And he couldn't really figure out a position that you'd have to be in to get, hit by the tail light in the back of the skull and not suffer some other type of injury elsewhere, like your neck or your lower body or something like that. So he ruled out the possibility that John's skull fracture was caused by a direct hit from the taillight itself to his head. That didn't happen. Also concluded that the abrasions on the right arm were inconsistent with contact with the taillight, in large part because you would expect additional injuries like fractures to the hand and to the forearm. So just to get the superficial abrasions alone, it wouldn't take much force. And initially, they weren't given any sort of theory about how the arm would have interacted with the car. We know they've been given one now. And so he concluded that those injuries were not consistent with any kind of actual interaction with the taillight. The report was turned over to both the Commonwealth and the defense back in February of 2024. Commonwealth has known this, jury. We're sitting here in June of 2025, and the Commonwealth has known about this, for over a year and a prior proceeding. They know that now. So then defense reached out to them to testify, do some additional testing for this trial, provided some additional materials, and a theory of how it might have occurred, how the injuries were sustained, consisting primarily of the written report, file materials, and the PowerPoint prepared by Welcher. So that's the point where we paused. Jurors, we are back on track. We were able to do so much today because of the fewer sidebars. I don't know that they were fewer sidebars. If you thought the jury was done yesterday, I'm not sure today really helped them. I'm willing to bet they were pretty done with the sidebars today too. Nevertheless, full day tomorrow. Lawyers say that we're winding down. So then we have the ruling, the edits to the PowerPoint that have to be completed before we can finish with Rentschler tomorrow. Everything Hank wants. Just take all the text out of all the slides. Then additionally, guys, haven't ruled yet on the evidence, but be prepared to exclude all these other ones. Haven't ruled yet on the foundation, but be prepared to exclude it. Oh yeah, you haven't ruled yet. Haven't ruled yet, but you got to be prepared about that qualification, special knowledge that you need to have to count the number of holes in a sweatshirt and count the wounds on an arm and determine that they're inconsistent? Jury couldn't possibly handle that themselves. They need a witness with specialized training and expertise in counting different things. Tearing the fabric, apparently we need some very significant expertise on how to tear fabric. Apparently something that's going to be beyond the common experience and knowledge of an average layperson. It's not like any of us has ever torn a piece of clothing, right? Ever snagged it on something. Ridiculous. Be prepared to exclude all that. But if you agree, I'd allow it. Yeah, no shit. No shit. We know that. Why is Hank going to agree? We know Hank's not going to agree. Just kind of ridiculous. Yeah, case might be ready to go to the jury on Friday, as if that wasn't your plan the entire time. Bev, you're so transparent. We knew that was the plan the entire time. You're going to get the jury the case on Wednesday because then you're done. Holy cow, you can go home, put your feet up. You don't have anything else to do until it's time for the verdict to come in. All this work you're having to do, it's done. It's done. You get a whole weekend to recover from it. We know that that was the plan. And then Mr. Alessi clarified for us that when you gave that cautionary instruction to the jury yesterday, when you were fixing, according to you, the consequences of Hank's little stunt there with the sweatshirt, you said you were going to put other things in evidence. She's like, yeah, I said that and it's going to happen. Great. So has it happened? Are they in evidence? Has the clerk noted them? Do they have exhibit numbers? Has it been formally entered into the record? Because until I get that confirmed, yeah, I'm going to keep checking, because you saying it will happen is not the same thing as it happening. It would be nice to trust the institution, would it? It would be so nice, but we're just not in that position. So speaking of that defense motion, guys, we have the defense's motion for a curative instruction. Let me pull that up, see if you guys can see that. Make it a little bit bigger here. Let's just take a look here. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to issue a curative instruction as set forth below to address the intentional misconduct of the Commonwealth, which occurred before the jury and this court on June 9, 2025, regarding Exhibit 88. Footnote: attached as Exhibit A is the re-cross-examination of Dr. Wolf by Mr. Brennan and the redirect of Mr. Jackson. This is not an exact transcript, but rather produced by the defense to the best of their ability from the recording available on YouTube. Such a great resource, this trial stream. Really easy to go find stuff. We can go back and watch this trial stream and see if Welcher showed us the slide. The Bev's like, no, it didn't happen. It was blacked out. Very easy to check that. Go back and see. Why do I suspect the defense is going to be doing that? This was created to offer context and clarity for all parties if necessary. Great. Ms. Reed also requests that exhibits YYY, ZZZ, AAAA, and BBBB, which were marked as part of Ms. Reed's motion for mistrial with prejudice, be admitted into evidence. Ms. Reed respectfully submits that the instruction issued by the court on June 9th was not curative or otherwise sufficient. This point is underscored when one reads the deep level of prejudice that exudes from the questioning of Dr. Wolf by Attorney Brennan, which is attached as Exhibit A. With this intentional misconduct being deeply and directly intertwined with the central issue in this case, whether or not an impact between Ms. Reed's Lexus and Mr. O'Keefe even occurred, Ms. Reed's constitutional right to a fair trial and due process compel the requested further curative instruction by Your Honor. The intentional misconduct of the Commonwealth also wrongfully impugned the credibility and competency of defense witness Dr. Wolf by asserting that he did not properly account for the holes in the back of the sweatshirt and incorrectly posited to the jurors that the holes on the back of the hoodie sweatshirt of the decedent, Mr. O'Keefe, were caused by alleged events occurring on January 29th, 2022. See Exhibit A, especially the yellow highlighted part, where Attorney Brennan appears to cut off Dr. Wolf from noting the holes on the back of the hoodie sweatshirt were the subject of cutting. This, therefore, must also be part of the curative instruction. On June 9th, Your Honor initially proposed the following language outside the presence of the jury. Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt, and I instruct you that those holes were made by Ms. Hartnett during the course of her inspection and sampling on May 18th. Footnote 2 attaches Exhibit B as a portion of the discussion between Your Honor and Mr. Alessi before the jurors returned. As with Exhibit A, not an exact transcript created through YouTube. So this was not at Sidebar, or we wouldn't have it on YouTube to be able to create a transcript. So that's what she proposed, but the court then instructed the jury with the following language. So, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt. So she didn't include that predicate part. Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. Ms. Reed respectfully proposes the following language to address the misconduct and its harm to Ms. Reed. During the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about the holes in the back of the sweatshirt, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the MSP Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. So that is very strongly worded, particularly falsely insinuating. Falsely insinuating as to Mr. Brennan. That's some strong language. Yesterday, the court agreed to enter into evidence and allow the defense to display YYYZZZAABBB. This has not been done yet. Here's why we're following up. She said it will be done. It will be done. Great. So is it? So you're doing it right now then? This information regarding the clippings from the crime lab still needs to come into evidence and be displayed to the jury. It unequivocally establishes Maureen Hartnett cut clippings out of the gray hoodie sweatshirt and that the damage was not from any alleged event on January 29, 2022. For the foregoing reasons, requests the curative instruction in furtherance of her constitutional right to a fair trial and due process. This is an inflection point for this trial and public confidence in the judicial system. I don't know. We spent the morning looking at the 1983 case law, the outline from the Ninth Circuit, and how prosecutors can absolutely lie, misrepresent stuff in hearing, fabricate evidence even. And they're not personally accountable for that. They're in fact absolutely immune from civil liability for doing anything like that. I think this is the inflection point for public confidence. This is just making it clear what the game is. This is just making it clear how utterly dependent our system is on the integrity of the people that are there serving it, and how simultaneously the structural incentives of the system don't require any integrity at all. None. No skin in the game. No skin in the game. Well, she's not going to give that instruction. He's pointing out the reason why Alessi brought this up at the end of the day today, it's still got to come into evidence. They still need to be able to display it. And those things have to happen before the parties close their case, before they close on the evidence. They need to be able to do that. Once the evidence is in, the evidence is in, and you don't take any more evidence. And typically you don't go on to do your instructions conference until you're done with the evidence, because the instructions that you have to give often depend on the evidence. Great example, proposed instruction about Karen not testifying. Very common instruction, defendant chooses not to testify. They have the absolute right to do that. You cannot hold it against them. You cannot infer anything negative about the decision not to testify. You don't actually know if you need that instruction until the defense has rested their case, because they can decide at any point in time Karen's going to testify. So if we wait until the instructions conference to deal with getting this stuff into evidence, guess what? It's too late. It's too late, Judge. So you're a little offhand dismissal. I'm just not even going to deal with this until we get to the instructions conference. That's why Mr. Alessi is bringing it up, because you need to deal with it. And we know you don't like to deal with it because, yeah, it's a mess you got to clean up. It's a mess that your little lapdog created over here, all over this courtroom on this floor. And guess what? Yeah, you got to clean it up because it's your lapdog. You created this monster. You've allowed it to behave like this. So we know you're annoyed about that, but we don't really care, because you being annoyed at having to clean up your mess is way better than us sitting here having to smell it the whole time. So just do your job, Bev. But no, not in a million years is she going to give this instruction. She's never going to say Mr. Brennan falsely insinuated that the holes were sustained on January 29th, even though that's exactly what happened. That's exactly what happened. We all know that, but she's never going to say that, not in a million years. So, bottom line, the main difference, I think, the main difference really between the instructions she said she was going to give and the instruction that she actually gave was leaving Mr. Brennan out of it. The fact that he asked the question. He brought it up. Jury can sit there and remember context in which he brought it up. Oh yeah, because we were talking about road rash and the possibility of road rash. And we'd gone and looked at Rescue Randy and how there were holes all over his clothing, all sides of his clothing, even the close-up that the Commonwealth really focused in on initially. It's the wrong arm. Oops. Never once were they able to get puncture, tear holes from the taillight itself. Never able to get anything but road rash. That was the context. And when she's bringing up the holes on the back, it's not just localized to the right arm. Well, yeah, it was. Yeah, it was. Because you know perfectly well Maureen Hartnett did those cuts to the back. So it's leaving Mr. Brennan and his role in eliciting that and in raising that and the context in which it was done. That being left out of the instruction is what the defense is taking issue with. I don't see anything here that's probably going to rise to the level of like appealable error if she doesn't do it. You got to look at what's the harm that resulted. The harm is the risk that the jury is going to be misled by Mr. Brennan. And so you fix that by making it clear the holes didn't exist on January 29th. Holes were created by the criminalist. It's not a great clarification, but is it sufficient? Probably. The holes were made by the criminalist during her inspection. That minimizes the risk that the jury is going to misunderstand and think that the holes were in fact road rash caused on January 29th. We know definitively they were not. The minimal instruction that she gave does cure that risk of being misled. It doesn't address just the basic due process problem that prosecutors aren't supposed to lie. They aren't supposed to be misleading. They're supposed to have a good faith basis, in fact, for the kinds of questions that they ask. But that's an issue that really goes to ethics and that goes to sanctions. Doesn't necessarily go to what the jury needs to consider. I mean, I'm sure that the defense would like the jury to understand loud and clear Hank Brennan is a misleading liar who lies. But frankly, it's not clear to me that they need this instruction to see that. We're able to watch this and watch Hank talk about, you said this, you said that. And we're like, no, you didn't. We already know that. He just did that a few times with Dr. Laposata. About things she hadn't talked about at all. I'm not sure the jury necessarily needs help to get there. So it's a problem. Brennan being misleading is a problem. But it's not one this court is inclined to fix. And the curative instruction really isn't the way to fix that problem. The way to fix that problem, make Mr. Brennan have some skin in the game. Make him have some accountability. But Bev isn't going to be the one to do that. We already know that. We definitely already know that. So that's where we are at for the motion that she's not going to bother with that right now. Wait till the instructions conference. Guys, let's get back to your thoughts about all this, everything that we've seen today. Edward Foster, won't the appellate court be offended by her refusal to state her reasoning? I don't know that they will be offended. They might be annoyed, but it's not illegal to not state your reasoning. So if it's not illegal, they can't really do anything about it. They have to do their role, which is to evaluate, is there any basis that would allow this ruling to be affirmed? Is there any basis? And you get to rely on the parties to present that to you. Presumably the prosecutor is going to assert a couple. Here's a couple of reasons why it was an error. So no, I don't think they're going to be offended. Even they might be annoyed. It's not a good practice, but it's not against the law, and there's nothing really they can do about it. Melinda Gar, it makes me want to explode when Bev says your rights are saved. It's like a big F you. Thanks for your coverage, Andrea. It is. It's a very annoying turn of phrase, isn't it? Your rights are saved. Your rights are saved. My rights shouldn't be in jeopardy at all. Like, one thing that should not be in question the tiniest bit in a courtroom in the United States of America is whether your rights are protected. Should be able to take that completely on faith. No question at all. But apparently not in this courtroom. Apparently not in this courtroom. It's a very obnoxious turn of phrase. The words, can other judges kick her off as a judge? No. Nope, no provision for any kind of authority like that. The worst that the judges can do is just kind of like any other person can do. You can socially ostracize people. You can be like, that person sucks. I don't want to be around them. I'm going to block that person on social media. By the way, guys, in the chat, I know sometimes there's, conflicts, different personalities and stuff like that. We try to be a free speech zone here as long as people aren't being assholes, but differences of opinion are allowed. But I definitely encourage you, if you run into folks that just aren't to your liking, don't interact well, whatever, go ahead and block those people. It's very effective. Very effective. So judges can do stuff like that, but as far as removing her from the bench, they don't have any power or authority to be able to do that. James Green, I was under a WC, a workers' compensation judge that had been overturned in appeals in 65% of her rulings. Ugh, oh my Lord. That's a nightmare. When you're like wrong by a supermajority, there should be a way to remove judges for incompetence. There should be like a baseline of how many times you can be wrong before it just establishes you're not qualified for this position. You're not suited for it. It's not working. Too many mistakes. I mean, you can be in some pretty basic professions, okay? How many mistakes can you make on the line at McDonald's before you lose your job? I don't know, but I'd be willing to bet there's, a cap. General cap on the mistakes you can make on the line at McDonald's before you lose your job. How important is that relative to this judge's decisions, the magnitude of the effect that will have? You mess up on the line at McDonald's, somebody's lunch is going to be a couple minutes late. It's seriously annoying. Super annoying. Bev messes up her job. Somebody goes to prison, loses their livelihood, loses their life. Family is traumatized. Community is traumatized for nothing. Kind of a little bit more important, but there's no cap on the mistakes that a judge can make. You just get to keep on being a judge. There should be some kind of standard, shouldn't they? 65%, that's ridiculous. That's a person who definitely does not belong in a position like that. Kathy, your realtor living in New Jersey. Listening to highly intelligent people who aren't condescending is like listening to a symphony. Really enjoyable, as sad as the situation is. I enjoyed listening to Dr. Laposata so much. And there is a kind of intelligence that goes to being able to communicate and simplify things, being able to translate this very, very technical stuff into something we can understand. This is where the Commonwealth's doctor, Dr. Wolf, I didn't hate Dr. Wolf or anything like that. He, maybe a little bit odd. He just seemed a little too gleeful when he was talking about things like putting his finger through your brain, or, if I jammed a knife up all the way into your brainstem, what would happen? Little bit odd. But his real problem as a witness is he just wasn't a good communicator. He's throwing out all of these technical words, these anatomical terms and things like that mean absolutely nothing to a lay audience. So he might be very good at teaching doctors, not very good at teaching lay people. Dr. Laposata, it's like night and day. I mean, she barely used technical language at all. She used just very, very descriptive, very simple kinds of terms to describe what she was talking about. And that makes it understandable. That is a form of intelligence, being able to do that, a type of verbal skill that she has, verbal communication talent. I agree. I love listening to smart people talking about the stuff that they're smart about. It's like really one of my favorite things. Chappie, maybe I missed it, but why won't Bev allow anyone to talk about inside the garage? Make it make sense, please. It's the catch-22 situation. You don't have any evidence that anything happened in the garage, so you can't present any evidence about the garage. Meanwhile, you can't generate evidence about the garage that would show the possibility that something happened in the garage, because you can't ask anybody any questions about the garage, because you got to keep the garage out of it because you don't have evidence. See, it's a catch-22 problem. That's why. Apparently, the mere hint that a garage would have a cement floor, it's too prejudicial. Jury might come to the conclusion they aren't supposed to come to, which is that maybe something happened inside the garage. There's no evidence of it. Yeah, but we can't rule it out, can we? And if we can't rule it out, then it's a possibility that it happened. And if it's a possibility that it happened, especially if it's a reasonable possibility that it happened, it's what we call reasonable doubt. That's what putting on a defense is all about. Pointing out alternative reasonable theories for the circumstances that present themselves to the jury. You can explain it a different way. Hey, we know John has location data moving in this general direction. We know he has step data moving in this general direction. We know about the timing of it. We know that the witnesses in the house claim they didn't see him. We know there's this other door over here. And lo and behold, appear to be conditions inside there that look like the kind of conditions that might produce this head injury. But that's not enough to prove that something actually did happen. So you don't get to put it in So you don't get to raise it as a reasonable possibility to the jury. That's the limitation on the being able to present the defense. So I think that's her rationale, guys. It's the catch-22 rationale. You can't prove it, therefore you can't put it in. And since you can't put it in, you can't prove it. And Cat 100, everyone with medical education and experience finally hearing sensible explanations. The Commonwealth's theory never made medical sense, may never get to blood pity. Yeah, I don't think they will. It doesn't seem like they're ever going to get to where's the blood? Where's the blood? I mean, maybe it's just not the strongest point. I don't know. Maybe there is an explanation for where the blood is. It doesn't seem like we're going to have an issue with, like, you're wanting it all ways where the ground is frozen. If the ground is frozen, there's nowhere for the blood to go. It's going to pool on top of the ground and freeze. So where is it? Where's the big frozen blood puddle? You went and blew all the snow away. Where is it? If, on the other hand, the ground isn't frozen, the blood can seep into the ground. But if the ground isn't frozen, then you've lost your last vestige of trying to find some source of John's head injury. Real pathetic explanation anyway. Frozen grass. I just I've forever pictured Dr. Wolf in my head now. Are you talking about frozen grass? Indeed he is. Yeah, indeed he is. That's all they got. But if you unfreeze the ground so that the blood can seep away, now you don't have a way to cause a skull injury. So they wanted every which way, but just doesn't seem like that's going to be a focus in this particular case. Alyssa Ramirez, I'll bet 5 subs that Brennan asks about dog bites on Cross. All this fuss for nothing. He didn't do that. He didn't shoot himself in the other foot. Didn't shoot himself in the other foot, just shot himself in the motor vehicle collision foot. So not a bad bet, though. Not a bad bet. Andrea, how usual is it for a judge to behave the way this one is? I found her exclusion of Laposata on dog bites shocking. Does this kind of thing happen commonly in cases? Love your channel. So we're going to have to kind of like define terms a little bit to talk about this, because no, this is not the majority of judges. This is far from the minority, from the majority of judges. Most judges are trying to do a good job. They might get tired, they might get irritated, they might not have the expertise in this particular area, and so they get confused, they make mistakes. Some of them, frankly, just may not be all that smart, may not have all that good of an understanding of what they're dealing with that they have to rule on. So there's a lot of different ways that judges can make mistakes. But the majority of judges, you don't see just outlandish, one-sided rulings and behavior like this. It's not the majority of judges. But is it common? As in, do you see it? Yeah, you definitely do. It doesn't take very long in the criminal justice system. You don't have to visit very many courthouses and very many court systems before you will run into a judge like this. A judge who is a prosecutor on the robe, who is there to do nothing but to justify whatever it is that the prosecution wants to do. It doesn't take you very long at all to find one of those judges. They're not the minority, but they're common. Yeah. Unfortunately, the system depends on the integrity of the people that are serving the system, and that is not something that we can count on. Aaron White, I have felt trial 2 will most likely end in a mistrial. Since the witnesses this week, my opinion has shifted to believing the jury will actually come back with a not guilty verdict, and they may even do so rather quickly. I know we want that. Definitely. That would be vindication, right? That would be a major smackdown to the prosecution in the decision to bring this trash into court in the first place. A quick, rapid acquittal. We would love it. We would love it. How long were they out for ASAP Rocky? How long were they out? Was it like an hour, 2 hours, something like that? Was it even that long? It was not long. Oh, we'd love something like that in this case. Just can't bet on it. You can't bet on it. I am still probably on the 51% likelihood side of the mistrial, just because of all of the variables. It's so hard to control, so many different people, so many influences. Just hard to say. But you know, I said last time too, I don't see a conviction coming out of this, and I feel the same way this time. Really don't see a conviction coming out of this. You just never know though. You really don't. Duncan, Idaho, Laposata getting in that bit about canines and incisors before Bev called the sidebar. Chef's kiss. That was pretty good. She got into a lot of detail with that explanation. Hey, it was Hank that elicited it. Hank wants to talk more about the animal bites. Yeah, we'll talk more. He thought he was going to get her on the punctures because that's something that she disagrees with Dr. Russell about. Dr. Russell said, I don't, there's no punctures here. She says, I see 6 or 7, and she's perfectly comfortable with that. So Hank really thought he was nailing her down on, you know, having to question her testimony or impeach her or something like that because of the characterization of the puncture wounds. But all he did was just invite her to give a much more detailed explanation about the sort of pattern that you see from animal bites. BW, judge told the jury to disregard testimony multiple times today, but failed to tell the same jury to disregard and strike all back sweater talk yesterday. Didn't tell him to disregard it. No, that's true. Didn't strike it. Didn't tell him to disregard it. Just gave this instruction that, you know, regardless of the questioning, the holes were caused by the criminalist doing her testing. So they're not prohibited then from considering that questioning Dr. Wolf's answer and all of it. They're just told it's not from road rash. Probably worth considering. It's a good point you're raising. Good consideration should be given to striking it, but defense isn't asking for that either in their motion. So just sticking with the curative instruction. Duncan, Idaho, I promise I'm not trying to lick any boots here, but is not some degree of administrative immunity necessary to maintain the function and order of a system? That's the argument. That's the argument in favor of having this broad immunity, is that these judges are put in a position of having to make very, very difficult calls, very difficult judgment calls. Lots of times there's close questions. Lots of times there's you're dealing with novel legal issues. You don't know how the higher court is going to rule on those things. And so if you put the judge in a position where they are going to be personally responsible for that, they'll just either try to avoid making the hard calls, or they'll just knee jerk to the one that they think is least likely to make them liable. So instead of actually exercising good judicial judgment about what's the right answer, you default to self-protection. So that's the general rationale behind it. Yeah, it does make some sense. Of course, there's other ways that you could account for that. You could have, insurance or something like that. Insurance is a pretty common way of mitigating liability risk. And then, judge doesn't have to worry about it. Yeah, you make a mistake, but you got insurance. What happens? Your insurance goes up. Not ideal. But at least there is some kind of, recompense for the person that's been victimized. So, possible other ways that these same types of concerns could be protected. It's not a bootlicker question. It is actually, it is legit. They didn't just make it up for no reason. They do have a reason for it. The outline that we were looking at was, if you are inclined to go read any of those 251 pages yourself, it's got some citations in it to U.S. Supreme Court cases where they talk about, here's the policy reasons why we need to have these types of immunities, why they're recognized at all. It isn't just out of the blue because it's the king. That's just the context, though. The context is we inherited this common law tradition from England, and these immunities inhered in the common law made by the judges over there. And the whole idea of immunity stems from this idea of, you can do no wrong because of the authority with which you're entrusted, whether that be directly from God, as in the case of Louis XIV, the Sun King, l'état c'est moi, or whether it's because you've gotten some subsidiary authority to do important governmental things. Summertime, as of right now, how do you see jury voting? Thank you. I'm going to go with, like, as of right now, I'm seeing like a 10-2 hung, 10-2 in favor of acquittal. I'm seeing something like that. I don't think you get a single holdout. It's rare and difficult to have a single holdout because it's just usually one person can be flipped, one person can be leaned on, one person can be bullied into going along with the majority. But if they have a partner and they can stand together, you're much more likely to be able to withstand pressure to change your decision. So I don't think it would be like a strong majority. I don't think it would be a lot of people that favor conviction, but that's kind of where I'm leaning. I would lean in favor of 10-2 acquittal. Just enough to hang it. The rural juror. Do you find in your practice that jurors get very curious about what they are not being allowed to know? I almost feel like all these objections and rulings in front of the jury may go in the defense's favor to the jury. It's real variable. A lot of jurors, as soon as they're done with the verdict, like, they're done. They're done. They could care less about anything else. They don't want to talk to you. They don't want to know anything else. It doesn't matter. It's immaterial. Some jurors don't want to know. That's often the case if you got a situation where, like, the client's got the defendant has prior convictions and you can't bring those up because it's too prejudicial. It's not admissible. They're not crimes of dishonesty. They're not impeachable. It just makes them look like a bad guy or like they've got a criminal propensity. Jurors often don't want to know that kind of thing. Like, if they voted that the defendant is guilty, to come back and find out, oh, but he's, just so you know, he's been convicted of this like 10 times before. Yeah, they're not going to want to know that. So I would say, as far as in the deliberation room, wondering about what's gonna, what they're not allowed to hear. I personally haven't gotten a lot of juror feedback that suggests it's an issue. I think generally once they get back into the deliberation room, they're really focused on the task at hand, and they're told you don't get to consider the objections or the basis for them or speculate about what's out there and stuff. It's right there in the instructions. And so most of them understand that's the rules of the road. We want to go home. We want to get this done and go home. So there's no point in like wasting the mental energy about that type of thing. But are they sitting there in their seats right now before they go back into the jury room wondering to themselves, why on earth don't we get to hear that? They're human. Probably. Especially the stuff that seems so just inexplicable. Like, we already heard it. Why is she not allowed to say it again? It's just bizarre. She said it on cross. Why doesn't she get to say it on direct? You got to think, just as humans, they're going to notice things like that and they're going to wonder. But as far as does it really like affect them very much, I don't have any reason to think that. Louise Ray. In a future trial, can an attorney highlight that Dr. Laposata has been found not to be an expert in this trial if it concerned cars or dogs? Maybe if they're going into qualifications, and they could bring up, in this particular case, the court declined to qualify you as an expert on injury causation as to animal bites, dog bites, and motor vehicle collisions. Yeah, it could possibly come up. They can prove it. There's a transcript. There's a ruling where the judge said it. So it could come up. Is it likely to be all that influential? Really, no. it's probably easier to not be qualified as a witness because of something that has nothing to do with your actual qualification than the other way around. You know, a whole lot of reasons why you cannot be qualified, including the attorney just doesn't know how to present your qualifications. You know, they didn't make a record to show, didn't ask the right questions to expound on what your experience is, that type of thing. So it's less significant, I think, to not be qualified as an expert than to be qualified as an expert. So yeah, I think it could come up. It's just not, I don't think, likely to really influence a later decision. AK, how much do you think the American culture has to do with the problems in your judicial system? Do you think your system would work better in another Western culture? Boy, I mean, that one's tough. Our system seems so tied to our culture in so many ways. We have a very individualistic country, you know, culture here in the U.S. I mean, what else? What sort of culture do we have here that might influence? I mean, I think that you know, some of this is difficult because culture changes. It's a different world now than it was 50 years ago when the greatest generation, my grandparents' generation, was in charge, running things. Just a very different ideology and a very different set of expectations, a very different set of social norms to enforce those expectations. And because of that, I think a lot more idealism and just you know, looking at the whole American system and the ideals of freedom and due process and all this stuff, not as being aspirational, but as being challenges for us to have to rise to. I mean, we're talking about the people that stormed the beach at Normandy, okay? We're talking about challenge that they can rise to. That generation was down with that. And I don't think we live in that same world anymore. We don't have that same culture anymore. We don't have a sense of honor anymore, which is kind of sad, but we just really don't. We're much more shameless than we used to be. It seems like maybe more attention seeking that we used to be. The whole rise of mass media has probably changed a lot of our culture and our attitudes. And so if we don't have honor, you know, the system can't function. Like I said, it depends on the integrity of the people that are there to serve it. And if our culture just doesn't produce as many people with integrity, it's not going to work as well. It's going to create more problems. So import our system into a culture that has a little bit more of an honor value to it. Would it work better? Probably. Probably. It's just kind of that's a good and thought-provoking and deep kind of question to think about. Sort of the best I can do with it on a knee-jerk basis. But yeah, I don't think our culture anymore promotes the kind of values that we really need to have a good functioning criminal justice system. It's just too much about what can you get away with, how can you cover your back, how can you get your own advantage, you know. How can you set yourself up in the best position? And it really isn't about self-sacrifice, service to something that is greater and more important than you. Those, I say that out loud and it's like, does that sound like a silly thing to say in today's world? Service of something greater than yourself? I think we all long for that. I think everybody has a core drive to have some fundamental meaning. But I'm not sure that we are doing a very good job of actually fulfilling that. So great question. Thank you for that. Duncan, Idaho, what would happen if Brennan had interrupted AJ and AJ had said, shut your mouth? Good question. I mean, if it was his time and Bev wasn't controlling the court, I just really want some righteous fire already. Yeah. Yeah, I know. I know the feeling. This is such a tough call. It's something we've been talking about for weeks in this case now. You know, if the other party just refuses to fight fair, at what point are you disadvantaging yourself by not returning fire, not feeding them back their same dirty tactics? It's a very tough call. Everybody is probably gonna, you know, fall down on that line a little bit differently about where their tolerance is. Some people staying above the fray, you know, holding the high ground is going to be most important. It's going to be a lot harder to get them to abandon that high ground, but impossible. Yeah, I don't know. I tend to think that everybody's got a breaking point at some point. But it's something we talked about in this case for a long time. What point does the defense start fighting fire with fire? Stop trying to be nice. Stop trying to think that Bev is going to go along with you just because you're being cordial and you're being polite and you're following the rules. That's not getting you anywhere. It's not getting you any respect from the court. It's not getting you, you know, any high ground with Brennan. He's still the lapdog. So at what point do you just say, Mr. Brennan, shut the fuck up? See what happens. I don't know. Clearly we haven't reached that point yet, but I share your curiosity. I would love to see what happened. A decision like that was made. Pseudo RMRF. I don't agree with people saying Spanky's career is ruined. I don't like him one bit, but I wouldn't mind having him as my legal attack dog. Kind of said that about the mob lawyer, right? If he's a mob lawyer and that's who he is this really going to hurt his career? I'm not sure that it does. I think the issue is just going to go far more to, it's less to do with his attitude. I think that you're right. The thing that people often forget about hiring a lawyer is that, I guess it's a little bit different with criminal defense because you don't have the choice of being charged with a crime. It's not like suing somebody. What I was going to say is that you know, you're in the position to hire a lawyer. You're already probably more likely to be litigious than other people, accusatory, that type of thing. But it's not really the case when you're talking about defense. But yeah, you want somebody that's gonna fight hard for you. And frankly, a lot of people looking at a lawyer and seeing this lawyer follows the rules, that's a negative. A lot of people aren't going to want a lawyer that feels constrained by rules and ethics and obligations and stuff. That is why, this is why I preferred the public defense career. Always did, because the client has limited ability to try to pressure me to sacrifice ethics, sacrifice the rules, sacrifice, you know, put my career and stuff at risk to do something for you, some shenanigans for you that I shouldn't be engaging in. Because they don't have the power to fire me. They don't have the power to stop me from being paid. If they even manage to get me kicked off their case, which almost never happens. But even if it did, great. There's plenty of cases out there. I'll get another one. It's no harm to me at all. So public defender, you never get put in the position of, well, I won't say never, but it's not as routine to get put in the position of selling out your ethics to make your client happy. But with private counsel, it's baked in. It's baked into the incentives. The client wants to pay you, and then you go scorched earth. That's what they want. So I don't think it's his attitude that's going to cause him any particular problems in his future career. I think it's his competency, and I think it's his trustworthiness. I think it's just sort of mechanical issues, like who exactly in the defense bar do you think is going to refer to you? When somebody calls up my office and they're like, I'm Ms. Burkhardt, I want to hire you for this. I'm like, God, I just can't. My calendar's too full right now. Let me send you to this guy. Is he going to be on any of those lists? No, he's not. He's not. So it's a mechanical issue that I think is likely to affect his career, and that's mainly just because of him being a turncoat, going from the defense to the prosecution side, but really emphasized by the fact that he's being such a dick about it. So I don't think it's really his attitude that would hurt him in the eyes of prospective clients. I agree with you about that. I think it's, if anything, it will be competence. It will be competence. People watching this trial and be like, I like that he's an asshole, but God, he sure couldn't get anything done, and he kept shooting himself in the foot. All these gifts the judge was giving him, and he just pissed him away. That's what's going to cause, concern. Even if you want an attack dog, you want a good attack dog. You don't want an attack dog that's going to accidentally get confused and bite his own leg. AK, Andrea, my previous super chat was not criticism. Hope you don't answer with that in mind. No, I did not at all. There isn't a perfect system or a perfect culture, so I was just wondering where the problems lie regarding the U.S. system. I thought it was a great question. I didn't take it bad at all. And I also, I don't mind criticism. Criticism is fair. I don't think there's anything or anybody that is above criticism that's fair. And the goal is to be well-intentioned, to be looking for ways to improve things. Nobody is perfect. No system is perfect. No culture is perfect. None of it. I don't have a problem with criticism in general, but I definitely didn't take it that way. I particularly enjoyed that question. It was very, very thought-provoking. Jason Sorensen, it's too long to quote. Google Lysander Spooner's quotes on the Constitution. It either grants the government we have or is powerless to stop it. I think I know what you're talking about. The Constitution. I think I know what you're talking about. It's just going to be a question of, can I find it real fast? But whether the Constitution really be one thing or another, this much is certain, that it has either authorized such a government as we have had, or has been powerless to present it. In either case, it is unfit to exist. Quite a quote, isn't it? We just created a bunch of new kings over here in this country. We just took the power of the king and we went ahead and gave it to, I don't even know how many government employees there are in the country now. How many prosecutors, police, judges, legislatures, et cetera. All these people that will have that immunity, that the king enjoyed. Thousands, easily thousands. Fled one king and went ahead and created a constitution that creates thousands more. Little Rusty Potato. Dr. Laposata is a gem. She sure is. She's probably wondering if Hank has a brain injury. I think she's wondering if he's got a personality disorder. Hugs to this beautiful woman. Thank you, AB, for sharing your knowledge. Well, thank you for being here with us. I agree completely. She was awesome. One of my favorite witnesses I think I've ever watched. Really. Really one of my favorite witnesses I think I've ever watched. Unshakable. Unshakable. Not intimidated. Very, very skilled. Sabina D, theoretically, I am a grown-up. I still want to be her when I'm an adultier adult. She's just heart. She is. She is. She was very awesome. Loved her attitude. Just loved her confidence and her knowledge and her experience. You're not going to shake her confidence. That's part of what Hank does on cross-exam. It's part of how he puts in the words that you didn't actually say, or you said this, or there's evidence, that's not in evidence that he tries to confront you with. That's to shake your confidence in your position. So you start to doubt, did I get something wrong? Did I mess up? Not her. Not her. It's not working on her. Sandra M. Oh my God, Dr. Laposata does not get intimidated by anyone. Hank is scared of her. You can tell. He should be. He should have been more scared than he was, because she is extremely dangerous. She was very dangerous, wasn't she? She definitely had the skill advantage in this matchup. Definitely had the skill advantage. He had nothing to bring that she did not have a hard counter for. Nothing. Saw his openings and took them. I loved her. Duncan, Idaho. Love her demeanor change from direct to cross. Her countenance shifted and she went from waif-like and frail to stone cold and solid, and answers Brennan like he's a misbehaving little boy. She answered him like he's one of the dumbest people she's ever had the mispleasure of talking to. Like, there, Mr. Brennan. There. Just because you were dropped on a head as a child doesn't mean that we can't properly pronounce the medical words and explain the medical concepts together. It's okay. I'll take care of that for the jury. You don't worry about that. She did. She shifted kind of from teacher to warrior. You know, she really did. She shifted from here to educate to here to stand my ground, here to not be pushed back. I enjoyed it very much. Equality. There's this Japanese phrase, go hit your head on the corner of a block of tofu and die. No kidding. It's a sarcastic way to tell someone they're being ridiculous. Now that's funny. Go hit your head on the corner of a block of tofu and die. The corner of a block of tofu. That's you know, roughly the consistency of a brain. I don't know. It's not in evidence. Don't think we got that from Isaac Wolf. He just made sure we know that you could actually stick your finger in it if you wanted to, and then it made us all sit there and picturing him, you know, gleefully poking his fingers through the brains of people. Really did get the impression he's done that before. I did. I don't know about you guys. I really did. It was just the way he described that with a little bit of like, you know, little hint of a smile and like glee in his eyes. Stick your finger through it. I think I prefer the tofu. Great phrase. Thanks for teaching us that. That's a oh, and here's my mod giving me the Japanese tofu no kara ni atama abutsu gete shine. Something like that. Crash Daddy's left dimple. Can we please start a list of best Dr. Laposata quotes? Well, dirt's under the grass. Oh, gross. Good idea. Some Dr. Laposata isms. It would be fun to go back and collect those. See what we got from her. Her clapbacks. Best. I bet some of the folks, there are some amazing content creators out there with some skills with the clips. Okay. The ability to put the clips together. Dr. Laposata's clapbacks. That's some prime material for some good clips there. Michelle, my new case theory. Chloe died in 2021 and Alberts had her taxidermied. Colin duct taped Chloe to Karen's taillight at the waterfall, which proves beyond a reasonable doubt Karen did back into him. Is it a worse theory than we've heard from the Commonwealth that he cracked his skull on frozen grass? Is it dumber than that? I'm not sure. It's in the ballpark. We're in the same kind of universe. Crack the skull on frozen grass is pretty dumb, guys. It's pretty hard to top that one. Isaac Baruch's wholesome gabagool art. Hey, like your name. Darned right my artist is, but this lady is good. Been a while, Andrea. Hope things are going well. Things are going great. If it's been a minute, I'm guessing I can guess. I'm guessing I can guess when we met. Thanks for coming back. Isaac Baruch's wholesome gabagool art. Good to have you here. Jason Blocker, but if government officials are vulnerable to criminal prosecution for official conduct, what would present the weaponization of government against elected leaders who oppose that very government? Part of the risk we see, over the last, I don't know, 15 years or so, 20 years maybe, the risk of the government and specifically the law enforcement power of the government being co-opted for political purposes, being wielded against one's political allies. What's to hold that in check? Guys, the only thing that holds that in check is the tiny bit of restraint that people might have if they stop and think for half a second that if you take advantage of these opportunities, or you make these changes, or you start these practices out of nowhere, when you're in power, when the other side gets in power, they're going to be able to do it right back to you. And so anytime you're thinking about, is this a good strategy? Is this something that we should do? Is this a road we should go down? Really good thought experiment would be, if I handed this power that I'm contemplating exercising over to my political adversaries, would I be happy with that? Because if you're not, you probably shouldn't do it. It's mutually assured destruction, guys. That is really all that has ever held the prospect of criminal prosecution of your political enemies in check. It's all it's ever been, is knowing that at some point the tables will turn. Kind of feel like we might be living some of that today. Lake Dude, might be wrong. In pop culture, at least, isn't Station Nightclub fire why it is mandated all exit doors open outward? People stuck at front doors stampede and died. She was the Emmy for that. Crazy. I don't remember that. I do remember there was an issue with people not being able to get out. I think that there were far too many people in for the fire code, and so that was part of it. You would have had a bottleneck at the door anyway. I don't know. I don't know about this. Let me see if we can find this out real quickly. Is the station fire caused by doors not opening? See if we can get a quick answer. So according to the Google AI, Station Nightclub fire, crowd crush. During the fire, a large crowd attempted to escape through the main entrance, which led to a narrow foyer designed to prevent people from entering without a ticket. This cramped space became clogged, hindering escape. Stage door blocked. Reports from survivors suggest that a stage door meant for the band's use was blocked by bouncers who prevented people from escaping through it. Flammable materials. The fire began when pyrotechnics ignited highly flammable foam insulation, leading to a rapid spread of the fire and toxic smoke. And overcrowding. The nightclub was over its capacity, contributing to the crowd crush and making it harder for people to escape. So they didn't say anything specifically, at least in this, about the doors not opening the correct way. But definitely, egress was an issue. It was a problem. People weren't able to get out. There were too many people in. They couldn't get them out at a quick enough rate. So yeah, I don't know. Can't confirm about the doors opening inward or outward. But I do. I remember when this happened. I remember when that fire happened, because I hate to say it, but it was one of the first things in my mind. Great White is still a thing. Still playing concerts. Who knew? MEG, oh my God, Dr. Laposata is a boss. She is. She's taking no shit. She's taking no shit. None at all. You want to try to dish some out? She's going to cut you off at the knees. Oh God, she got him good. She got him so good. He tried to come in at her with advocacy. Don't give me your advocacy. Took the first opening she had. Yeah, I'll tell you all about how John doesn't have any injuries at all consistent with being a motor vehicle collision. The judge wouldn't let me say that on direct. Thanks for giving me the opening. She is vicious. Wouldn't want to meet her in a ring. Christy NC, a play, no exit 2, still no exit. Summary. Defendant, no coffee, no vape. Hank is 3 hours into a redirect of the aperture mountebank and his purposeful, maddening expression of malicious befuddlement for the rest of time. Are you writing a horror film, or is this like a Kafka? Is this a Kafka play? You know, we woke up one morning and found ourselves transformed. This hideous circumstance that we can't escape. I don't think I like the sound of this play. I don't think I want to go see this one. I think 2 to 3 hours of this play is probably going to be too much for me. Lula Bella. Oh, but Spanky can put up little snippets of Karen's interviews and he thinks that's fine. Yeah. Out of context. Out of context. Tell us more, Hank. Also, unfortunately, I predict tofu sales declining. Cultural issue. I see a lot of different ways that tofu sales will not decline. Tofu still, big in Asia. Much more so than over here in the U.S. So just looking at relative population, probably more people who are in a culture where tofu is a little bit more common being born than people over here where it's cows or nothing, guys. It's cows, it's chickens, or it's nothing. None of this tofu. But then we also have this, government policy, the role that policy plays in what's out there, what's available for food, how much it costs, so on and so forth. Get to a point where meat can maybe just become a little expensive, a little hard to get to. And suddenly that tofu looks a little bit more appetizing. Just depends on how hungry you are, guys. I love me some tofu. I'm totally down with the tofu, but I'm sure you already knew that. Mentioned that a few times. Oops. Uh-oh, I think I just went and accidentally deleted a chat that I hadn't read yet. Let me send a quick message to Jeff. All right, I'll see if I did, and if I did, if that can be hunted down. So I don't want to miss any of those. Greta Thunderer. This case is the perfect encapsulation of everything that has gone wrong with the judicial system in this country, and neither the cops, the prosecutor, nor the judge will be held accountable. We have, the corruption at the basic level. We have the cops with the different rules for thee, but not for me. Both with the homeowners who drive drunk despite being law enforcement, and then with the cops who have no problem with manufacturing evidence in a case to protect one of their own, and then lie about it. we got all that. We got the doubling down on the pressure to just cut a plea, and be done. We'll go all the way back to the grand jury and take it up to manslaughter to try to, or take it up to a second-degree murder to try to apply more pressure. So we got that involved. Karen has resources, so she has power to fight that lots of us don't have. Lots of people, the overwhelming majority of the people in the system do not have the kinds of resources that Karen has. So we don't get that. But that's pretty much like the only one big systemic thing I can think of off the top of my head. We got the judge who can't be bothered and who's pro prosecution, is lazy and just wants things to be easy and defaults to giving the prosecution whatever they want. We have the prosecutor who doesn't feel constrained at all by basic civility and decorum, let alone, rules and integrity and things like that. It is a lot. Just a lot going on in one case, and you're absolutely right. Not a single person is going to be held accountable. Only person that's had the tiniest little bit of accountability is Proctor. He got scapegoated out of all of this. Everybody else gets to skate. Oh, you got a sanction finding in your personnel file? Absolutely nobody gives a shit about that. You lost, 6 vacation days? That's not accountability. That's not a consequence. That's a symbolic. That's making it look like we cared and did something to take it seriously. Show how seriously we're taking it. Nope. Proctor is going to take the fall for all of them. He's going to be the scapegoat. Nobody else is going to be held accountable for anything at all. And there's not even really a mechanism to do that. Cross our fingers, maybe Mr. Morrissey. He's the only person in this whole picture that gets elected. So he's the only person that has some type of accountability to the public as a whole if they don't like how he does his job, the decisions he's made. Maybe. Stacy LeBruno, if opinion slides are excluded during Rentschler's testimony, can the defense use them in closing? If so, they should show them one by one. They cannot. Anything that has not been admitted into evidence cannot be brought up, argued, shown, anything to the jury in closing. Even demonstratives in closing, you typically can't use those. Just the evidence that has been properly admitted into court. So no, they can't. If the slides are out, they can refer to Rentschler's testimony. Doesn't sound like there's any problem with him saying these things. For some reason, there's just a problem with there being words on a slide. Some reason that hasn't been articulated by the court. So they can't do the slides, but they can certainly talk about his testimony and what he said. Lonnie, QQQ, if Hank brings up past for Dr. Laposata, could defense bring in the issue with Welcher and the junk science ruling 3 to 5 years ago? I don't know why they didn't before. Was it off limits? Was it off limits? Now I got to remember. I got to go back and remember what exactly was. I mean, because I remember they brought it up, but I think it just went to qualification. I think you might be right. They didn't try to cross him on any of that. It sounds like the judge, I mean, I think properly isn't allowing the whatever it was called, Pasita. The other case where, according to Hank, they found Dr. Laposata lacked credibility. It's, in my opinion, I stated that before. It's not proper to bring that in. It's a single instance of something being, offered to go to credibility. The rules typically don't allow that. You got to be really, really careful in talking about somebody has an opinion of somebody else's credibility anyway. You don't generally get to introduce evidence, testimony that is opining about another witness's credibility. So, shouldn't have come in for the Commonwealth. Now with Welcher, what was the finding before? I'd have to go back and look at the specifics of the case, exactly what was said and what the basis was and what the reasoning was. Seems like, at least to some extent, it should be fair ground. You weren't allowed to present your theories in a court. Maybe that's just where you leave it. But be nice to have a consistent and predictable standard, wouldn't it? To be able to know. Everything else being equal in this court, what are we going to be able to do? Unfortunately, the Commonwealth being allowed to do something is no prediction that the defense is going to be allowed to do the same thing. Carolyn Smith, Hank's arguments are hurting my tofu. Well, at least he's not sticking his finger through it. Colette Keenan, if Karen Reed is found not guilty, can the Commonwealth appeal? They cannot. There is no appeal from an acquittal. Any sort of right to appeal that the Commonwealth has that could result in her being retried on a charge that a jury has acquitted her of is a violation of double jeopardy. They don't get to do that. If she's acquitted, they're done. Oh, now what? Could I put you on retainer? What will you do after the trial? I'm research litigation. Do you mentor? Do you need another mod? Thank you. Oh, I'm not in a position of being on retainer these days. Not really a thing I do. You guys interested in the difference between the retainer and the advance fee deposit? Like very technical legal stuff. Okay. You give the retainer is I'm paying you to make yourself available when I want you. So you pay me the retainer and we have an agreement. Okay. You pay me $500 and I'll be available for this next week whenever you need me. Okay. So you've paid me. I've agreed to make myself available. I have earned it as soon as you paid me. That's a retainer. So I get to put it in my regular account. An advance fee deposit, you're going to pay me in advance for my time to do something. So you're going to hire me to work on your case. And we have a general idea. You know, we know what my rate is going to be. We know roughly how many hours it's going to take, but it can be unpredictable. So you typically build in a little bit of a cushion. Very common to bill that way as an advance fee deposit. Okay. You want to hire me for your criminal trial. You're going to pay in advance. I am not going to go through all of the energy and effort and so forth of a criminal trial. Not sure if I'm going to get paid. You better believe it. I'm going to be paid. So I'm going to get paid in advance, but I haven't earned it yet. I haven't earned it until I put in the actual time. So that one I can't put in my regular account and go spend it. I have to hold that in trust. It has to be in my attorney trust account. These are finite little distinctions with running a legal business. Anyway, reach out, send me a message on Instagram or on Substack or something like that, and we can chat. I'm happy to chat. See what I can do to help you out. DKIT, I guess Hank this time restrained using his usual ambush tactics with Dr. L after being exposed on the stunt he pulled yesterday. Restraint, which he astonishingly highlighted in his argument to Bev. Yeah, didn't you like that? He didn't ambush anybody by jumping up and bringing up the improper things that he hadn't pre-cleared impeachment-wise. He didn't go ahead and spring that. Wow, good job, Hank. Good job. You knew you had something questionable, and so you sought guidance ahead of time. This is not where the bar should be. You know, this is one of those things where it's like thanking somebody for something that you had to do. You were going to do it anyway. I guess we'll do it for form to be polite because we're polite people. But are you gonna really mean it? No, you're not. You're not. You need to do that anyway. That's the bar. This is how you're supposed to be. You don't get any credit for doing what you're supposed to do. You got something questionable, bring it up outside the presence of the jury. That's what you're supposed to do. You don't get any credit for that. Miscellaneous. Queen Dr. L, you dropped this crown. Hashtag it was bullshit. It was. God, I love that. I love that she just said it. I love that she just said it. What are you going to do about that, Judge? Nothing. See, Hank, multiple people can play this decorum game. Just because the defense isn't going to fight fire with fire, don't count on Dr. Laposata to roll over and just take your shit and do nothing. Nope. James Cassatelli, does it seem like it's on purpose to anyone else that every time Bev makes a ridiculous ruling that seemingly completely removes the Karen Reed's right to a defense, it ends up blowing in Hank's face? He just can't take a win and roll with it. It really is astonishing. I honestly can't think of like a bigger gift to be handed in this particular case than not allowing a forensic pathologist to testify that he doesn't have any car accident injuries. It's such a gift, and to just piss it away. Just piss it away. You're trying so hard to make a point, and see, you didn't know what that point was. Hank has really slipped. I've given Hank credit for some technical skill with his lawyering, and he does. He's got some technical skill in lawyering, but specifically when it comes to cross-examination, guys, go back to like week 2, 3. Remember when we had to give poor Mr. Jackson such a hard time when he had Jen McCabe on the stand. It just wasn't doing very well at that cross. Getting down and arguing with her, and he wasn't winning those exchanges. And so we talk so much about the technique of cross-examination, how to handle it. Guys, you got to go into cross with a point. If you don't have a point to make, you shouldn't be asking questions. You should already know. Here is a fact I want to elicit. Here is how I am going to get that witness to give me this fact. That's it. You're not there to cross swords in a big battle of wits with the witness, because things can go very, very, very south. And that's what we saw happen today with Hank and Dr. Laposata. He didn't have a point. Very few actual points that he was trying to elicit. And the ones that he did have, he doesn't have a way to get them in. He's just kind of relying on her, what she's going to concede, that she doesn't have objective evidence to rely on. Of course, she's not going to agree with that. That's just your argument. Of course, she's not going to agree with that. And she happens to be the kind of witness who can turn that around and slap you with it. So he either didn't have a point, or whatever point he did have, he didn't have a way to make it that wasn't just dependent on the willingness of the witness to give him that. And he ran into a witness who is not willing to give him an inch, not one. So his technique, he just really didn't display good technique on cross today. If you don't have a point and you got nothing to do but to try to cross swords with an expert, 40-year expert, intelligent woman, doctor, sit your ass down. It'll go much better for you to just not ask any questions. I can't say it seems like it's on purpose. It's just a remarkable talent at being able to shoot himself in the foot. Brian Elliman, once you drop below 98 degrees, you lose the Lachey effect and your quality of life starts to change dramatically. I'm going to have to look this up. Lachey, Lachey effect. All I get is Nicholas Lachey refers to the negative impact that reality TV, especially the show Newlyweds, Nick and Jessica, had on Nick Lachey's mental health and his relationship with Jessica Simpson. I don't think that's the Lachey effect that you're talking about. I don't know what that is. Unfortunately. I can tell you, me personally, I'm always below 98. I'm like never at 98. My body temperature runs low. I walk around about 96.8, a little bit below 97 degrees. I just remember because it's not 98.6. It's just you reverse those numbers, and that tends to be my average. I like to think I have a pretty good quality of life, but I don't know if I fell below 96, what would that mean quality of life wise? I don't know. Ethan Morgan, playing catch-up. Why was Laposata prohibited from testifying she saw images of the inside of 34 Fairview? Well, if you're playing guess-up, go ahead and I'll give you several guesses on whether Bev gave us an explanation for that. What do you think? Do you think we got an explanation? No, of course we didn't. We don't actually know. We don't know why she doesn't get to testify about what she saw inside 34 Fairview or inside the garage at 34 Fairview. But just judging by Bev's previous rulings and the things she has given explanations before, not just in this trial, but also going back to trial 1, the whole third-party culprit piece. You don't have evidence of anything happening in the house, therefore you don't get to present anything about the inside of the house, and it creates the catch-22 situation where, because you can't ask about the house, you can't develop any reason to think something might have happened inside the house. So you just hamstring them by not letting them develop it. There's no evidence, and then you blame them for there being no evidence because they can't develop the evidence because you didn't let them. That's the catch-22. But that's the best explanation I can give you. You know, she hasn't told us explicitly, but seems like Seems like, that's generally it. They haven't proven anything happened inside, therefore we don't get to talk about inside, and therefore we won't be able to prove anything happened inside. Lay in Cleardale. I want her to walk out of the courthouse, light a smoke, and walk away Kaiser Soze style. I want her to that meme of the smiling girl with the house in the background. I think I'm gonna picture Dr. Laposata. Somebody Photoshop that one real quick. Put Dr. Laposata and her sweet nice face on that girl's face. I think we got a couple of expressions from her today that would work very well for that. Yeah, I love this idea. Just burn it all up. Kaiser says it never to be seen again. And all along it was her that hit John O'Keefe with the car. Everage. If I was a college or colleague, I think, of Cannoni, I would be like, Bev, you are doing too much and it's not helping our image. Do you think she gets that kind of feedback? No, I seriously doubt it. If you're not friends, you're not going to think it's your place, to criticize people. It's just, it's not the polite thing to do. You don't do that with the people that you're not friends with. But then kind of paradoxically, when you're friends with somebody, you don't always want to tell them hard truths. People in general don't want to hear hard truths. They don't want to hear criticism. They don't want it. So most people know that, and most people will accommodate that. Recognize, might hurt this person's feelings if I say something critical. So it's just, I don't have to say it. So the path of least resistance is just to not say it. No, I don't think they're going to. And then you get into this universe anyway of judges and colleagues, and we've got to be super deferential for each other. And I can't second guess the other judge. And, judge has to make hard decisions. You make all kinds of excuses for why the judge does what they do. No, I don't think she's getting any criticism from other judges. I would be surprised if there is any significant pushback from her colleagues. Maybe an exception here or there, maybe a particular asshole, maybe somebody who's got a, specially good relationship with her that's, good enough that she'd be willing to hear some stuff like that. But I just doubt it. CNO, why no mention of the missing 3 liters of blood? Don't know. We haven't even heard 3 liters of blood lost. I know that that's a piece of information that has been kind of out there for a while. People have talked about that for a while, but I don't know that I've ever actually seen that sourced to something. I don't know if it's from the autopsy report. I don't know if it's something that just, kind of got generated. Sometimes it just happens. People get ideas or say things, or you find it online, whatever. Just a lot of ways the information can come out. So I don't have a way to validate this one because it's never come out in any of the trials. I don't know if it's even true, but we do know, logically speaking, anyway, that head wound. I don't know how much blood loss that's going to cause, but it's going to bleed a lot. We know that's going to bleed a lot. That's just a given. So where's that blood? However much it was, don't know. Not a focus of the defense theory in this particular case. Josh H. Wasn't Welcher updating his PowerPoint while he was sitting on the witness stand? I kind of think he was. I mean, he testified about how he's, continually updating his PowerPoint. I don't know if he was changing it while he was actually on the stand, but he, had his laptop there. He could have been. I don't know if the PowerPoint was being displayed from his laptop. Was the thumb drive plugged into his computer? That's some pretty bad security if that's the case. He can just sit there and and edit it while he testifies. That would be terrible, but I wouldn't rule it out in this courtroom. Yeah, I don't know. Good question. We just know from his testimony that, that day, the previous day, he's like constantly updating the PowerPoint. But he didn't say specifically, even while I'm sitting here on the stand. Michael Muddragon, I need Dr. Rentschler to give an analysis of Scott Sterling's injuries for both his soccer and volleyball college days. The man, the myth, the legend. Am I going to feel bad now that I don't know who Scott Sterling is? Should I know who Scott Sterling is? Why is Scott Sterling famous? I love when Google tells you like what question should you be asked. I don't even know what question to ask. Google, what question should I ask? Why is Scott Sterling famous? He's a character of Studio C. He is a soccer and volleyball player for Yale University who has the tendency to get hit in the face with a ball. Sterling's popularity grew the first day that he was seen. By the end of the week, his video had over 10 million views. So this is from something called Studio C, which I hate to say, I don't know what that is either. Is it a show? Is it a cartoon? Is it an anime? It's a series. One of BYU TV's BYU, Brigham Young University. Is that the BYU we're talking about? BYU TV's most popular original series, family-friendly sketch comedy show, Studio C. Okay, so he's a character on a sketch comedy show. I didn't know. No, I'm gonna have to go check that out. It sounds kind of funny. You know, tall girl over here. You get so used to hitting your head. Okay. Okay. You shorties. I don't care how hard it is for you to reach the stuff on the top shelf. Okay. Cause there's always some like hot, tall dude that you get to ask to go help you get it off the shelf. Okay. Your struggle is nothing like the struggle of constantly hitting your freaking head. So I have a this speaks to me, this this type of issue. Always getting hit in the face by the ball. I like it. I'll check it out. Thanks for bringing that up, Michael Muddragon. I enjoy a good family friendly comedy sketch. Who doesn't? Is it really BYU Brigham Young University TV? Is that what it is? It's Latter-day Saints College. I don't know, but that would make sense. Mispronounced name. Found at 6 a.m., 4 degrees per hour, 80 degrees Fahrenheit. Temperature 98 minus 18, 80 equals 18. 18 divided by 4 is 4.5. So John died around 2:30 a.m. What time was Haas long? Well, this is a possibility, but remember, 4 is like the up to. It can cool up to that quickly. It doesn't necessarily mean it is cooling that quickly. But if we took that, the maximum possible cooling rate and decided, that applied here, yeah, we could end up with 4.5 hours. He was found at 6 o'clock. We're at 1:30. I guess at that point we're at 1:30, right? 1:30, 2 through 3:30, 4:30, 5:30, 6. Yeah, 4.5 hours would be 1:30 before 6 o'clock when he was found. So we're close. But I think it's probably likely that he just didn't cool as fast as 4 degrees. That's the max temp. He's cooling somewhere more in the ballpark of 3 to 4 degrees. That would just be my guess, but of course that's completely a guess and speculative. I don't think we'll ever know. It's going to be about as specific as we get. Amy Lecoq, do PI's pics of garage tell the tale? Why leave out? Yeah, indeed. Do they perhaps tell the tale? Is there perhaps some kind of a step with some kind of a pebbly type of surface on it that might cause injuries, like we saw to John O'Keefe's head, back of his head, those patterned abrasions? Do tell. Why leave it out? Bad girl. Epileptic here. I bit my tongue every time I had a grand mal seizure. Sometimes I would vomit or spit up too. Yeah, I think it's very common with a seizure. Very common to bite tongue. Very common to vomit. Haven't heard anything about the vomit in this case, have we? Not in this trial. We heard about it in the first trial. There was some vomit on John's clothes, but it wasn't visible. I remember we heard about like the smell. They could smell the vomit, but obviously Maureen Hartnett did a whole visual inspection of the stains. stuff like that of the clothing. Didn't say anything about, finding a vomit stain. So just another little mystery out there, but it would certainly make sense. It would be consistent with everything that we've heard medically. He fell, he suffered a extremely serious brain injury, and it would result in potentially, seizure type of activity. Would absolutely explain biting the tongue and vomit. Edward Kirkpatrick. McLaughlin's famous words, the TUI materials match 90 to 95% of the Commonwealth's case. Apparently that missing 5 to 10% was insanely the whole case. Boy, that's a throwback, isn't it? That's a throwback. That's way, way, way back in the day, back when Ms. McLaughlin is trying to pretend that the TUI disclosure from the feds actually support the Commonwealth. Nearly all of it matches the Commonwealth's case. Really? Seems kind of hard to believe given what we know about the TUI materials, other than just that really important 5 to 10% detail of John wasn't hit by a car. Other than that, seems gold. Yeah, where was the grave concern? Where was the grave concern over that? Where was the heavy breathing and turning red and getting so worked up we got to get off the stand over that? Lucy Fair, could they tell how fast John's phone was traveling? Wouldn't his phone record an equal and opposite increase in speed to alleged Lexus impact speed? I don't believe the phone is going to be capable of registering that kind of movement. So its location data is just going to be pulling from GPS, and it's not precise enough to give you that type of granularity. I think if the phone had, you could build a phone, you could make a phone, I'm sure, that has the capability of monitoring something like this, but I don't think a general iPhone does. It's got like the accelerometer and stuff in it. But my understanding is that's really just detecting the change in motion. It's not focusing on, specifically how fast is it moving and stuff like that. And I'm really not sure how they would be able to do that, without tying it into a satellite or a cell tower or something like that gives you the fixed point that you can then tell this is where the phone is traveling to and from, the speed, be able to calculate the speed that way. So no, I don't think the phone can do this. It's a good idea, but I just don't think it has that capacity. AC75. Oh, that station nightclub fire. Yep, hear about it all the time in firefighting training. No kidding. Eye-opening case if you don't know it. Video available on YouTube. I remember when I remember when this happened, and I remember it was on the news, and there's some video from inside the club of like when the fireworks went off and how it lit up, and that is horrifying, absolutely horrifying. So I would definitely be interested in learning more about that, and just, why and how did it end up, so bad, so lethal? How did so many people end up trapped? Really terrible. Nan, today Dr. Laposata defanged Hank and gave them back to Chloe where they've always belonged. She sure did. She sure did. He just had nothing. He had nothing that could hurt her. Nothing. Couldn't touch her. Couldn't touch her. She was Muhammad Ali in there. Float like a butterfly, sting like a bee. That was her. Love to see it. Heather S. Is it a problem in the opening? Is it a problem the opening had Brian Higgins, Brian Albert, Michael Proctor, etc. weird behavior, but then defense skips most of it, not making good on promises? No collision theme is strong. I worry about taillight fragments, experts canceling, uninvestigated weirdness equals stronger Bowden. It can be a problem. It's not inherently, but generally, yeah. If you're telling the jury in opening that they're going to hear something, you want to follow up on that. It's not necessarily fatal if you don't, but it's something that you're handing the prosecution to potentially be able to use against you. Absolutely legitimate strategy in the closing argument. I've done this one myself several times because it's just fun. It's satisfying to be able to point out to the jury, remember back to opening and they told you everything that you're going to hear, and you didn't hear that, did you? In fact, it's not at all what you heard. You heard something completely different. A lot of those promises they made didn't deliver on. It's good. It's good to be able to make that argument. So it's a risk that they can do that. Question, I think, is just going to be, is it fatal? Has the jury heard enough about Brian Higgins and Brian Albert and Michael Proctor that they don't necessarily need all of the details of all of the shady behavior? The specifics, the specific ones that got brought out in opening? I don't remember if, for example, I mean, we know that Alan Jackson mentioned the gift. Didn't he mention the gift in the opening, the text about getting a gift? I don't remember if he mentioned wish that she would kill herself, that Karen would just kill herself. I don't remember that, if those specifically were mentioned, but those are like two big ones that haven't come in because those were Proctor's texts with his sister, with Courtney. And so neither Michael Proctor nor Courtney Proctor has been called as a witness. So those texts aren't in. That's, an unfulfilled promise. If AJ mentioned those, the question is just, has the jury heard enough that we don't have to do that? They heard everything he texted to his friends, and they heard what he texted to his boss and to his colleagues. And they heard that his boss was, penalized, sanctioned for failing to properly supervise him because of these texts. Do we really need to bring them in to just, have that one additional piece of information? It can be damaging to not do that. So it is a risk, no question about it. I agree the collision theme is strong. I also worry about the taillight fragments. It's always been the strongest part of the Commonwealth's case. And I think you just have to turn that around to your advantage. If this was such good, solid evidence, and it's got integrity, it can be trusted, why didn't we just immediately book it into evidence? Why do we have all these problems with the chain of custody of this evidence? Why do we even have to be asking questions about, is this the right taillight piece? Is this the right date? Did somebody, one of these unidentified people from the scene, show up and just sprinkle a little bit of taillight down there for you to find? The scene, by the way, unsecured all day, where anybody could have dropped a couple pieces of taillight plastic down there on the road, let the snow fall, cover it up. And we don't even know. The Commonwealth never showed me that those pieces of plastic that the CERT team found fit into Karen's taillight. Any taillight would do. And in fact, seems like a lot of taillight did, because 47 pieces they found, 23 fit into that taillight. So where did 24 pieces of taillight plastic all over the lawn, where did that come from? Just got to use what you have on the taillight to try to turn that to your advantage. Experts canceling. Experts, you kind of get what you get, not getting Richard Green. Maybe they just got enough from Ian Whiffen, so we don't have to go into some of those other details. Really don't know what the thought process there is, but yes, I agree. The more that's weird, that's uninvestigated, the stronger Bowden. And so that is a risk of leaving like the butt dials, the butt dials on the table. The, coincidentally, both of us getting rid of our phones in the time frame right when we're expecting that a court might order us to have to turn them over as evidence. I do agree there is some benefit to the defense bringing those things in. The question is, are they going to suffer if they don't? Don't know. Don't know at this point. Tribal girl. If Karen is declared innocent, can her defense team speak publicly about how terrible Aunt Bev was? I don't see why not. I don't see why not. Once the gag order is lifted, once she's acquitted, the case is over. She's released. She's no longer subject to the authority of the court. Case is over. So she's not subject to a gag order anymore. None of them are. They have First Amendment rights. Yeah. There's going to be some limitation, I guess, by the rules of professional conduct that deal with lawyers, but those are pretty limited restrictions. You got some pretty strong First Amendment case law that says pretty much what you can shut lawyers up about is details of their case that are likely to prejudice the jury at the time when it's likely to prejudice the right to a fair trial. But attorneys have First Amendment rights. So yeah, they get to offer their opinions about this process. They get to offer their opinions about the personnel. Don't know that they will, but they have the right to do it. Mispronounced name. Just realized I may have screwed up my math. Sorry. That's okay. That's okay. I'm certainly not one to throw stones about screwing up math. Couldn't figure out that force calculation just yesterday. Trying to figure out the difference from the arm. I'm not that good enough at math to be able to do it on the fly like that. No worries. We got you covered. Eric Wolfrick. Good description is you could hear her say, "Because I'm smarter than you, Henry," with every response. Yeah, she didn't have to say it. Show don't tell. She didn't have to say it. We all understood it. She never had to say the words. That's the sign of a good communicator right there. We all heard it loud and clear, and she never even had to say it. Stacy Labruno, thank you, Andrea, for your coverage of this case. If it weren't for you in this chat, I would be hurling things at the screen and screaming obscenities way more than I have. Your insight and honest commentary are appreciated. Well, I'm really glad that that you find this helpful, and that being part of the group of us that are watching this and taking this in and reacting to it. Again, it can be a very comforting thing to know that you're not alone. It's not just you. It's not just you seeing things this way. A lot of us, in fact, are seeing the same problems. A lot of us are feeling the same things. We're having the same reaction. We're having the same outrage. We're having the same judgment. This should not be like this. So you're not alone. Stacy, you have found your place, and I'm glad to have you here. Bev sitting on the scales. Lally's case was a pig's ear. Hank took it and tried to make a silk purse, but a pig's ear is a pig's ear. I want to be Dr. Laposata when I grow up. He tried to make a silk purse, but he forgot like the bottom seam or something. So then when he went to stick his wallet in it, or his phone, he went to stick his phone in it and just shattered all over the concrete. He did. It's just, it's the problem with this case has just always been the facts. Problem is always the facts. If John wasn't hit by the car, that's always going to be a nearly insurmountable hurdle to blaming Karen for his death. If he wasn't hit by a car, you're going to have problems with the case arguing that she murdered him with the car. It's always been a weak case. Duncan, Idaho. How awesome that the defense got these two eminently qualified and competent older ladies as medical experts who are also very personable and absolute kryptonite to Brennan. Then there's Commonwealth's Burgess. Good point. Good point. I loved both Dr. Russell and Dr. Laposata. Dr. Russell was like our sweetheart at the last trial. I think You know, it doesn't have to be a competition. We don't necessarily have to pick one over the other. But I've already crowned Dr. Laposata as possibly one of my favorite witnesses ever. She's up there on the throne next to Isaac. She's just phenomenal. God, that was good. It was just so good. We thought Dr. Russell was awesome and you couldn't improve on that. Nope. Dr. Laposata said, hold my beer. I do. And I loved how, you know what, Dr. Russell wouldn't even take it personally that I'm saying this, because she herself was busy hyping Dr. Laposata. Guys, these are the kind of women that you want around. The women who hype the other women. It's good stuff. When they deserve it. When they deserve it. We're not talking about those women who like make excuse for like abusers because the abuser is a woman. You know, we're not talking about that kind of thing. But when you got a badass girl, an awesome girl, beautiful girl, we can all appreciate that. It takes nothing away from us to appreciate the gifts of other people. I loved having these two very intelligent women. Wicked Psyched. The door law was from Coconut Grove in Boston in the 1940s. That must be talking about the fire code and the doors not opening. I'm not familiar with this fire either. Coconut Grove, I'm going to write it down. Put it on my little list of things. Coconut Grove fire, Boston, 1940s. I'll look into that. Does make sense. I mean, yeah, I don't know. I feel like memory is so unreliable. You know, you try to remember back to how things were when you were a little kid. And I was like, I'm pretty sure I remember as a little kid, the whole emergency door with the bar, you know, and you got to push the bar and it opens and that's got the alarm and stuff in it. Like, I'm pretty sure they had that when I was a kid. And so I would expect that to be the norm, you know, well before we had the station fire, because that was I think I was out of college when that happened. I think, pretty sure somewhere in that ballpark. But it's just hard to rely on memory of childhood anymore. It's an awful lot of years ago. I'll check this out. That's a good tip. Thanks for that. Wicked Psyched. Melissa Garcia, do you think she already knew his games because he has hired her before, hence him being scared of her? Her saying he wasn't hit was pure magic. Love her. You do have to wonder, in what capacity did he hire her? Did he, you know, he's denying it. I didn't hire her 4 or 5 times. Okay, well, I don't know what that means. Did you only hire her 3 times? Did you hire her for something else? Like, you know, I don't know. I don't know what he's taking issue with, but very possible. Yeah, she's gotten a feel for this guy. She knows who he is. She's picked up on his vibe. She knows his game. I could see that being possible, especially if she has worked with him before. And yeah, good reason for him to be scared of her if he knows how she handles herself as a witness. Probably should have been a little bit more scared. Maybe he wasn't prepared enough. I don't know. It was perfect. He teed it up. She hit it over the center field fence. Doesn't matter what speed the car was going because the car didn't hit him. He wasn't hit by a car. Brilliant. Jevi, Bob Mata said he will start the Dr. Laposata fan club. Let's remember to hold him to that. We'll do that. We'll make sure that Bob holds that up, and we'll all get the t-shirt, the fan club t-shirt. Dr. Laposata's clapbacks, MEG. Andrea, thank you for the display name inspiration. Your commentary is priceless. Dr. L dog walked Hank. Indeed, she really did. She really did. Yep. Just put that leash right on him. We're going this way. We're going this way. Bad dog. Michelle, I am under the assumption the federal government won't interfere with ongoing trials. Is that true? If it is, would keeping this case open shield some people involved in the case from a federal charge? Oh, there's so many levels to this. Yes, you're generally correct. There's this principle called the abstention doctrine, which is, we've talked about it before because it came up with the double jeopardy challenge that Karen had filed went through the went through the Massachusetts courts, and then went up into the First Circuit, the Court of Appeals, all the way up to that petition to the U.S. Supreme Court. It came up in that context. So the abstention doctrine is this idea that because the feds and the states, they are separate but independent sovereigns, that they need to respect each other's spheres of interest. The state has its own sphere of interest when it comes to criminal cases, enforcement of criminal activities. States are the primary enforcers of criminal law and criminal rights. Feds have very limited jurisdiction. Congress in general has much more limited jurisdiction over crimes. So states and feds both have their own interests at stake when it comes to pursuing a criminal prosecution. And so the abstention doctrine is giving effect to that respect that we have for each other. You've decided, for whatever reason, your interests are furthered by this, so we're not going to interfere with that. We're going to recognize you're the separate sovereign. You get to exercise your own judgment. We'll stay over here and not interfere. So yes, that part of it is true. And would keeping this case open shield some people involved? Potentially, yes. Potentially, yes. If the abstention doctrine is limiting federal activity here, the feds are not pursuing criminal charges or going to a grand jury or things like that, because doing so could very well interfere with this trial. If you go and indict, hypothetically, Michael Morrissey, just hypothetically, you go and indict Michael Morrissey for corruption relating to his oversight and handling of the Karen Reed case. Yeah, that's going to tend to, if that's all over the press and stuff like that, it's another thing that you're going to have to kind of vet the jury to make sure. Don't know about that. Not going to affect you, that type of thing. So yeah, it can definitely have the potential to interfere with the state prosecution. So it's definitely possible. Coffee addiction. Can Commonwealth try Karen for drunk driving if she is acquitted on these charges? Typically, no. I'd have to look at, let me see real quick. So normally this concept is the idea of what's called joinder of offenses. So Mass has, let's see, Criminal Procedure Rule 9 here. Joinder of offenses. Two or more offenses are related if they are based on the same criminal conduct or episode, or arise out of a course of criminal conduct or series of criminal episodes connected together or constituting parts of a single scheme or plan. If two or more related offenses are of the same or similar character, they may be charged in the same indictment or complaint, with each offense stated in a separate count. If the defendant is charged with two or more related offenses, either party may move for joinder of such charges. Trial judge shall join the charges for trial unless he determines that joinder is not in the best interest of justice. So there is nothing in here in this particular rule that appears to make joinder mandatory. In Washington, we have mandatory joinder. If they're arising out of the same incident, you have to charge everything at once. You have to charge it all in the same case. You don't get to cherry pick like that. Just on the quick look, it doesn't look like Massachusetts has that same type of restriction as Washington does. But you always have another consideration. Oh, that's interesting. The statute of limitations. You always have to consider the statute of limitations. So generally, apparently in Massachusetts, 6 years for misdemeanors, including first or second offense DUIs. This is all, quick and dirty, Googling stuff on the fly. So Don't know to what extent there might be wiggle room in that. So if you don't have mandatory joinder in Massachusetts and you don't have a statute of limitations problem, could she be charged? Maybe. Maybe. You don't have a double jeopardy problem unless they necessarily had to acquit her of this charge. Not clear that they would. Not clear that they would. They could reject, for example, the voluntary manslaughter. Fine, no, she wasn't intoxicated, but we don't know. The jury isn't going to explain the basis for their decision. They could decide, yeah, she was driving drunk, but she didn't hit him with a car, so she's not guilty because of that. That wouldn't be, we wouldn't know that, but it wouldn't operate as an acquittal on DUI. So looks to me, just on the real quick and dirty sort of look, that maybe looks like they might be able to. I would want to get into the common law and dig in a little bit more into the rule, specifically on mandatory joinder, because that's where it tends to come up. That's where you tend to have those types of restrictions, where you don't get to just like get a police report and piecemeal it and, try this one first. And then if that doesn't work, come back and try the next one. At some point it becomes harassing and not in good faith. But, when that point is, boy, in Bev's courtroom, they might not ever reach that point. So I would want to do some more research into mandatory joinder on that. But just based on the quick and dirty, kind of looks like maybe that's possible. Red for the mom joke today and keeping me educated and sane. Love you and your trial coverage. Well, guys, I mean, come on. That was a softball. That was a softball. How could I not take that one? Hung that one up right in the middle of the plate for me. Thanks for being here with us. Glad to have you. Glad to have you joining us. And yes, we all need to help keep each other sane. It can be a very insanity-inducing process dealing with this just kind of unbelievable, frustrating, unfair outrage. So we do rely on each other to keep each other sane. Thanks for being here with us, Red. Nicole Kelly, how come Star Wars expert couldn't be questioned on her previous court case that was thrown out, but Hanky can question Laposata? Oh yeah, this was Jessica Hyde. Jessica Hyde, she wasn't allowed to testify about they weren't allowed to bring that up to impeach her because it was too remote from the facts of the case. They didn't get to say you were found to have your methodology wasn't reliable because it wasn't the same methodology, so it wasn't close enough. Great observation. So would we apply that same rationale to Dr. Laposata? Testimony in that case has nothing to do with the testimony, the facts in this case. I mean, I don't even know what it is, just from the description of it. It sounds very unclear. She knew he was lying because of the text messages. I don't know what that means, because I'm here to tell you that text messages can be false. People can be lying in text messages. So I don't know what any of that means, that the description of that holding that Brennan gave was. But it doesn't matter. Bev didn't allow it anyway, and that was the smart choice. It's going to be opening some very dangerous doors to let an opinion about credibility like that come in. Brian Alleman, as a tall person, I constantly get asked to grab things off the top shelf for a short person. But if I ask a short person to get something from the bottom shelf, I'm a jerk. Well, look, it is good for you to squat, guys. It is good for you to squat down. Keep that hip and ankle mobility, really good. It's an important part of keeping your posterior strength up. Your full range of motion. Guys, we're not getting any younger. It's not a bad thing to go ahead and get in your squat. Pick it up off the bottom shelf yourself. But nobody needs to be an asshole about it. Nobody has to be like, giant, get over there and squat yourself. Michael Oldham, come on, Bev's Beach House doesn't pay for itself. Nope, it sure doesn't. It sure doesn't. Steve F, alcohol increases rate of body temperature loss in the cold. You know, I remember that coming up. Now I can't remember if it came up in the trial somewhere or if it just came up in the chat that we were talking about that. Some of our smart folks in the chat, I think, brought that up. Because I remember going and looking up, how does that work? Oh, it works because of the vasodilation. The alcohol is a relaxant, so your blood vessels dilate, and that means they get bigger, and that means that there's more surface area that blood is contacting, and so that's what you lose the heat through the surface area. And it was also paradoxical that you lose more heat, but you also feel warmer because you're losing that heat. The surface feels warmer because that exchange is going on. So I remember that coming up. I think it was just from the chat, though. I don't think that came out in the evidence. Would be a helpful thing. Helpful thing maybe to bring up. Maybe that brings us closer to the 4 degrees an hour, maybe. I don't know. Good point, though, Steve. I did forget about that. Teddy Bear 1287. I don't know why anyone hasn't brought up the fact that taillight that Barrows said was missing was found at 34 Fairview, in which case the timing is way easier to plant it from picking it up at Meadows. I don't know. I don't know. My personal theory on this that I've mentioned before, I don't think he's right about what was missing. He described the size and, kind of the shape of it. And he sure seems like he's describing the part that they never did recover any of the pieces, right? That rectangular piece in the back, kind of towards the top. Seemed like that's what he was describing, size-wise, but then he said it was on the side. And I just wonder, did he maybe get that wrong? Because to me, what makes the most sense is, she busted that in the driveway at Meadows, and it's just gone. It's never recovered. They're out there snow blowing. It's blown into the street. Nobody even knows that they need to be looking, for taillight over here for a long time. So it's gone by then. That's why they never recovered it. And then that's what Jen McCabe sees. That's what Carrie Roberts sees. That's what they turn into their story about the broken taillight. And that's the condition it was in when Nicholas Barrows saw it. Then it gets transported to the Sallyport. And what happens? The first pieces they find, guys, they're the ones that are right beneath that rectangular piece. It's already missing. Like you could just walk up to it and grab it and pull something off. It's literally like they just did that a few times. It's all right there. The first one, I think, is the cert piece. Below that, like at the bottom of the red part, is the piece that Berkowitz found. So that's what I think. I think she busted that rectangular part that they never recovered anything from over at Meadows. The rest of it is red taillight, and you get that to the scene either by the folks showing up and planting it, or you have somebody like a Brian Albert, anybody. The scene is unsecured all day. Just go in and sprinkle any taillight out there. Just give CERT something to find. Maybe it ended up back in the taillight. Maybe it didn't. Commonwealth hasn't proved that it did. But this is a possible point too. This is a possible point too. If it was the piece on the side, that was missing. Go swing by Meadows, pick it up, drop it off over there at Fairview. It's a theory. It's a theory. Might explain why we've got even more missing ring camera video throughout the course of the day. See, all the defense needs is possible alternatives. If all of these are possible alternatives, that should be reasonable doubt. Doesn't have to be any one of them. We don't have to prove which one, you know. If it's possible that they did a frame up with the tail light, and here are some possible ways they did it, that should be enough. Can't rule it out. And it's their own fault that we can't rule that out, because they just couldn't be bothered to run a clean investigation of the death of a law enforcement officer. They just couldn't do that. David Logan, iPhone 14 and above have crash detection feature that will auto dial 911 in the event of a crash. Not sure if it works for pedestrians. These iPhones are wild, man. Never had one, never had an Apple phone, probably never will. Just little distrusting of the iPhone and like how difficult it is to ever not, you know, have an iPhone ever again once you get one. Seems like you just kind of tend to get stuck there. But it's amazing the kinds of features that they have. How would it know that there's a crash? Yeah. And so would that apply? You would think it would be something like the accelerometer. Really sudden rapid change in speed. You're moving, suddenly you stop, you know, maybe you're stopped, suddenly you move. I don't know. Interesting. I had no idea that it had that kind of feature. Ashton, when Cross began and the doc's first response to Hank was, "It's 6 minutes till the afternoon," I knew we were into a ride. Guys, okay, so let's flash back now to Isaac Baruch. Remember what a good witness Isaac Baruch was, guys? He was so awesome that I made a YouTube channel. I resisted for quite a long time, but he was so good. I'm like, I got to make these videos because that's something I would want to see. I would want to see the breakdown of exactly how awesome Isaac handled that cross-examination. And by the way, what a masterclass in how not to cross-examine a witness that was. That we saw in that particular case. Do you guys remember right out of the gate, catches Elaine with a hard jab. She comes out of the gate with some sort of, you know, I don't even remember what it was now, but just some sort of aggressive, you know, something about the makeup, you know. Now I don't even remember the details. But she comes out with like this, you know, super aggressive question. And he interrupts her and he's like, "Can you repeat that?" He couldn't hear her. And it just completely cut her off and stopped her cold, because the script that had been written either in her mind or, in my opinion, more likely probably Amber's mind. I really do. I think Amber tried to script this out. She saw it in a movie in her mind, how this was going to go. And instantly we're off script. Because Elaine comes out barreling forward with this attitude, and she's expecting it's going to go a certain way, and just instantly, boom, you got caught off balance, unprepared. He didn't even hear you. So now you got to stop and reorient and make sure he can hear you. And you didn't plan that. That's not in your script. And everything just went downhill from there. Real similar, huh? Instantly, you can't even greet this woman. You can't even greet her without her catching you. It's actually 6 minutes till the afternoon. And he didn't quite know how to deal with that, did he? He's trying to smile, trying to laugh, trying to, you know, brush it off, but at the same time, not liking it, trying to have a comeback, can't think of one. Yep, we were in for the ride. She caught him right there coming out of the gate. It wasn't a damaging one. Neither was Isaac's. This is just a little jab. That lets you know I'm dangerous. You should pay attention to this. But he didn't. And neither did Elaine. And look what happened. Skippy One was looking to hear about multi-layer livor mortis. I don't know what that is. I mean, livor mortis in general, I know is the pooling of the blood. That's the oh, it's late in the day now, and it's been a few hours here on the stream, and so I can't remember the word. Chat's gonna have to remind me of the common term for the word for the pooling that you see on the body. It's not a bruise. It's lividity. Thank you. Thank you, chat. I love you, chat. I love you so much. Yes, yes, lividity. So I know livor mortis in general is lividity, but I don't know anything about multi-layer. I don't know what that is. So I see in the background here, because my awesome mods, including my husband, send me great information. Multi-layer livor mortis refers to the rare phenomenon where distinct patterns of lividity form in multiple layers or areas of the body, indicating that the body was moved or repositioned multiple times after death, with blood settling in different dependent regions at different times. Makes sense. The whole idea of livor mortis, the blood is settling, so it's gravity driven. It's just going to the lowest point of the body. Well, if you change the position of the body during that process, you're going to change where it pools. It's no longer the heart keeping the blood in a particular place. It's just gravity. So change the orientation of the body to the ground, and gravity is going to act differently on the blood within that body. I don't know if this was an issue in the case or not. I really don't. I mean, if it's not an issue, that would explain why we didn't hear anything about it. But, also just possible. There's so many, so many details that they're talking about and others that they're not, that maybe this just didn't get addressed for one reason or another. But my suspicion is if they had proof he was moved after death, they would have brought it up. So I'm guessing they did not have multi-layer livor mortis. Lady K, Texas. Would it be allowed for the jurors to give the judge a question about the blood? So in the last trial, and I would expect in this trial as well, the jury is going to be able to ask questions during deliberations, but they aren't going to be able to get any new evidence. So the evidence is what it is. It's what's presented during the evidence phase. Once the evidence phase is closed, they don't get any new information. So if it doesn't come in during evidence, they won't get an answer to that question. So they can ask, but they won't get an answer if it's not already brought up by one of the parties. Typically, all you really, I mean, honestly, now, if we're just going to talk about the real world and how this goes, when juries ask questions, they're told, just reread your instructions. That's the probably, 99th % of the time, the answer, just reread your instructions. Factual questions, we can't give you any new information. So if you're asking a factual question, it's either you have all the information, all the evidence that you're allowed to consider, or they're asking for help with like trying to interpret a piece of evidence that they have, or a conflict in the evidence or something like that. And the judge will basically just tell them, keep deliberating. Can't give you any more information about something. So fact questions, almost nothing happens with them. The purpose, at least in theory, for having these jury questions is so that they can ask for clarification about the law and the legal requirements. And so the idea is if they are confused about something, that can be clarified. Legal issues can be clarified for them, but the practical reality is it almost never happens. Judge just tells them, go back and reread your instructions, because it's less risky to do that than it is to give them a new instruction on the law. It's not in the pattern instructions. It's specific to their question. It might be suggestive. It might be a wrong statement of the law. Once again, the incentives are not really to help the jury. It's to protect the judge and protect the process. This is an issue. Believe it or not, I've litigated this. I've made the argument that the court really should have some kind of responsibility to answer a jury's questions. I had a case where jury has a question about the law. It's pretty straightforward. There's a pretty straightforward answer, yes or no. Defendant wants the judge to give the straightforward answer. Yes, the answer is yes. You can actually answer that question about what the law is. And the judge says, "No, I'm just gonna tell them to refer back to their instructions." It's a safe thing to do. It's a default. I argued in this case. You have at least, surely you have at least some minimal responsibility as a judge. Why else do we allow juries to ask questions anyway, unless it's just a farce to make it pretend like their concerns matter? Make this pretend, make us pretend like this is about them engaging in a sincere and honest process of finding the truth. Then surely we'd be concerned about dispelling their concerns when it's easy and not even disputed what the correct legal answer to the question is. No duty. No duty. That's my little aside about jury questions. A. Johnson, do judges typically allow such accusatory language as Hanks when addressing the opposition? No. And in fact, didn't she tell them before we even got started with trial, knock it off? Knock it off with this stuff. Just try the case. The personal attacks, the vituperative language, the hyperbole, knock it off. Well, I only see one side doing it, and I don't see that side suffering any consequences for it, so I'm not sure why they would just knock it off, because you're not making them. No, judges absolutely do not allow stuff like this. It's inflammatory. It's indecorous. It's uncivil. The courtroom, guys, very, very basic level. The courtroom is like the polar opposite of the street, the bar room, places in contexts where your problem, your dispute can be resolved. It's kind of the exact opposite of that. It is the gentleman's way of resolving a dispute. So you're supposed to behave like that. It's just part of the decorum, part of the institution. So no, most judges are not going to tolerate it. They would consider this not only disrespectful to the institution, but to your authority as the judge. Most judges would be a little bit dumbfounded that you would think you can get away with that in their courtroom, but not this judge. Not here. We're in the closing stretch. So what a wonderful witness today. God, that was great. That was a great day. I enjoyed Dr. Laposata so much. Everything you want from a good expert witness. Very talented, simple, likable. The jury loved her, guys. You see, she got that startle from the judge. Everybody laughed. Everybody laughed at her joke when Mr. Brennan gets up on cross at 6 minutes after. They all chuckled with her. Jury loved her. And then you get on cross. Then you get on cross and you're a freaking beast. Immovable, cannot be shaken. Go ahead and just take the opportunities that side gives you. If he's going to open up doors, you're not going to get any trouble by walking through them. Oh, she was such a wonderful witness. So I enjoyed today thoroughly. But here we are in the final stretch. Looks like tomorrow we'll get Dr. Rentschler's textless PowerPoint. His textless PowerPoint. I don't know, unless the defense goes back after court today and watches the video from Welcher's testimony and sees if that slide was presented. I don't remember. I don't remember one way or the other, but it is possible. Skippy one, try looking at the arm pick dog bites. They usually black out the livor mortis on his back. If you look at top shoulder, faint livor mortis showing his body was moved. Okay, I remember what you're talking about because that came up with, I don't remember if it was Scorty Bello or if it was with Dr. Russell that was talking about discoloration on the top of his shoulder and the possibility that it looked like a little bit of lividity or possibly a little bit of bruising. I want to say I think it was Dr. Russell because it was in the bigger context of like the color on the arm and how like one of the pictures, it was more yellow in color and stuff like that. That's vaguely where I remember that coming up. I don't know if that is the case. It does seem like a little bit of a missed opportunity, doesn't it? But maybe it's just not enough for anybody to have a strong opinion about it. I don't know. But now you've reminded me. I remember that coming up. Pretty sure it was with Dr. Russell pointing out that that discoloration on the top of the shoulder that is not consistent, if that is lividity, with blood pooling where gravity is going to flow onto your back. Bev sitting on the scales. Oh, I'm waiting for Welcher taking the stand again. He shouldn't be watching or listening, so he shouldn't know about the x-rays that don't exist being put into evidence. Very good point. Very good point. Yeah, this is along the lines of I really did want the defense to call Yuri back to read all of those proctor texts. I really did, not just because it's fun to make our little monkey dance and do what we want him to do. You read all of the texts. Sit there and like it. It was fun. And he got into it. I think ultimately even he had some fun with it. He's a decent text reader. But also because he's not supposed to know about him, right? He said in his examination, he doesn't know anything about the IA file, doesn't know anything about these texts, doesn't know why Proctor was fired, doesn't know any of the details. He's not supposed to know about him. So I could just imagine Yuri is like the cannon fodder equivalent of, the soldier cop out here. If the thin blue line is supposed to be the equivalent of like the brothers in the trenches, okay, he's the cannon fodder. He's not the brain guy. He's not the one strategizing and figuring the stuff out. He's just there to do a job, and he's good at throwing the fists and denying the authentication and so on and so forth. He's pretty good at that part. But that's cannon fodder stuff. He's not the brain guy. So I just picture this little cannon fodder guy in his mind. He's got to not know that these texts exist. So he's got to be surprised by reading the text, but he's also emphasized Michael Proctor behaved with integrity and the investigation was handled with integrity. And so he's going to have to react to these texts and learning about them. And how does it change his opinion and his assessment? And he's going to have to balance those things in deciding how to respond. And I just don't think his little cannon fodder brain is capable of that, of being able to walk that line. So that's why I really wanted to see Yuri have to read those texts. But this is a similar type of strategy with Welcher. He's not supposed to know. He's not supposed to know about the x-rays, then that should affect his opinion, shouldn't it? How is he going to balance knowing, not knowing? How is he going to balance, it's new information, got to act like I'm taking it into account, but I'm still going to go ahead and reaffirm my original position. Yeah. I like how you're thinking, Bev, sitting on the scales. I like this thought. I think that's a very, very good point. He shouldn't know about them. So how's he going to explain them, and how's he going to excuse them? Well, guys, we're going to wrap it for today. We're going to call it good. It's just been too good of a day. I think we need to take some time and enjoy it. Let the joy flow through us. It's fun to watch a good witness, a smart witness who knows the game, isn't going to be shaken. It's fun to watch. So I really enjoyed it, but I'm also looking forward to tomorrow. Wow, a third full day on Wednesday. I don't know, Bev. Better be careful. She's really pushing the limits of what I think she might be capable of. Sounds like we get Rentschler tomorrow. Probably not a ton of time left with him. Then Cross. Defense is done. Commonwealth's rebuttal. We're getting Welcher. Bev is saying check in tomorrow about whether Welcher needs to be here. So Welcher might be here tomorrow. He might be here for the rebuttal case tomorrow, but maybe not until Thursday. But either way, yeah, we're getting real close to having things wrapped up. So we knew this week. This was Bev's mental timeline. Friday we're done. She's ready to be done. This has been long enough. It's time to get to the beach. Time to not have to do this work. Time to have some more days off. Time to have some more late mornings. I mean, whatever. Day after day after day of 9 to 4 is just a little too much for the endurance of this particular court. So we knew she was going to wrap it up. We knew that was going to be the rough timeline, and it does indeed look like we are on track for that. So probably that would mean instructions conference probably on Thursday, and then closings and instructions read to the jury on Friday. And then they start to deliberate. It's crazy. Can't believe we're already this close to the end, guys. Already so close to the end yet again. Well, I hope you guys enjoyed today as much as I did. This defense case, it's been a bit of a roller coaster, hasn't it? And it's been a ride, largely not because of anything the defense has done or not done, but just largely because of the unpredictability of whether they're going to be allowed to present their case or not. But definitely a lot of questions and a lot of stuff to think about for especially those of us that have been with this trial first time around, revisiting it now the second time. Got a real picture of the big context and some of the other evidence that's available that the defense is choosing not to use, and it does make things a little bit nerve-wracking, doesn't it? But I'm very, very interested then to see what they do with closing. These decisions were made. They were made purposefully. They were made with a reason. So should be a good closing. Like they've already got these ideas in mind when they make these calls about, maybe we don't need to call Brian Albert. Maybe we don't need to call Brian Higgins. They've already got it in mind. How are we going to adjust our closing argument if we don't do that? So getting closer and closer every day. I'm looking forward to it. Guys, thank you all. Thank you for being here. Thank you for your contributions. Thank you for just being here to support each other and to allow us to have that comfort of not being alone, saying, yes, there are other people that see what I see, other people that feel what I feel, other people that think what I think. Maybe not everybody, but it does give us some comfort and some vindication. No, we're not crazy, guys. We We do our best to be very gaslight resistant here on this channel and here with this chat. You're just going to have a hard time telling me that I see something I didn't actually see with my own eyes. And it's because we try to be scientific here, and science is skeptical. Science is a process of skepticism. You have to start with doubt, or you don't actually know what you know and what you don't know. You just have arrogance. So epistemic humility, very important value that we have here. Try to be gaslight proof. Try to be gaslight proof. It's, you know, we're not crazy. Guys, I give you permission to feel like you're not crazy. You're not making it up. You're not a lunatic because, you know, you're entertaining the possibility that there was a police frame up here. Absolutely does not make you crazy. Makes you skeptical. Makes you questioning. Makes you suspicious. Makes you scientific. Want answers. Makes you want answers. All they had to do was run a clean investigation for the death of a law enforcement officer. And you wouldn't have these questions. That's all they had to do. But they couldn't even do that. Couldn't even clear that bar. The fact that they couldn't clear that bar, you got to ask why. Got to ask why. Why would it be hard to clear that bar? Especially the death of a law enforcement officer. How would you not dot every I and cross every T? Make your case airtight. Has to be a reason, guys. So thank you all for being a part of that, for supporting each other, for sharing your thoughts, sharing your ideas. It really does make it a fun place to be and to take all this in and process it. Thank you, as always, to the mods. Thank you to Jeff, all the little notes you send me behind the scene with great information, for going out and watering my trees when I talk all the way through lunch. Can't do it. Can't do it without him, for sure. And really, really just appreciate you guys and this whole experience of taking the trial in. Really appreciate you caring. I really do. I keep saying that, but it just gets real easy after a lot of time in the trenches in criminal justice, and you just see the same shit over and over and over again, the same injustice over and over and over again. And you start to wonder, does anybody even care? Does anybody even care? And that's been one of the best things. It's been one of the best things about this channel. You know, all of you folks that come and watch with me, seeing how many of you do care. You do care. I'm not alone, guys. I'm not alone at being like, it shouldn't work like this. This is crazy stuff. Why did we run away from that king and then take his authority and give it to like 10,000 more people? Why did we do that? Almost like it was planned, almost like it's on purpose to make us not have any recourse against our government betters. It means so much that there are those of you that care about this stuff, and you want to see why are things that way? Because seeing why they're that way and how they got that way, that is the first step to making it better, guys. Doesn't mean we don't love the country, doesn't mean we don't love the system. Being critical doesn't mean you don't love it, you don't have loyalty to it, you don't support it. Quite the opposite. It means you see what it could be and you want it to be better. That's the attitude I see here, and I really do appreciate that so much. So thank you, guys. Thank you for sharing all this with me. Already Wednesday tomorrow, as Bev said. Already Wednesday tomorrow. Another full day. Guys, bright and early, 5:45 Pacific, 8:45 Eastern. I will be here. And I hope to see you guys then. Have yourselves a wonderful evening off. We'll see you tomorrow.